Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
No, I am not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's in all caps.
I'm not a person. I am one of the people. Thank you.
Okay, thank you.
Thank you. All right, that's a preface to what we have today. Yes, we have a live Sov Cit in court in a jury trial out of Washington. Lacey, Washington is where we're going to be going today for this. It is juicy. It's incredible. We also have the two appearances that were on the same day but separate times that lead up to that. So we're going to watch those because Lacey, Washington starts at 9 a.m. That's 12 a.m. our time. So we're going to have a little bit of time to watch those two appearances, including on-camera jury selection. Now, the audio is not as good as I'd like for jury selection because the jury's not mic'd, but there are some key moments in there that you're going to love. This is so good. This is so good. Yes, a little bit of disappointment today. The Microsoft case got pushed. There's nothing we could do. You know, I called the judge. I said, "Look, Your Honor, we're planning on this." And he said, "Look, I'm sorry. Had I known, I wouldn't have." No, just kidding. Really, this just happens. You can't do anything about it. It's rough. But what beats this? As Red Pen says, nothing says like I'm going to beat the system like going pantsless in court. Yes, the defendant showed up in like short shorts and like an open poet shirt, long hair. He looks like like Dave Grohl. Is that the right guy? He's just amazing. This is so good. We've been waiting for a good case like this. He is he's determined to act as his own lawyer. He's sort of respectful and sort of not, so it's not as bad as Daryl Brooks, but oh my goodness, it's going to be so good. So we're going to bring that to you here in just a second. We're going to get going. I do have to say congratulations, Kim R. You were first in chat. You won the internet. I don't have the chat saved. I apologize, but you were first, and as punishment, prize, or penalty, depending on how you view the situation, you are responsible for everything IP related worldwide until we go live again. So please take care of that. Make sure everything's working for us. I also have to confess that I did it again this morning. That I am late because I did my entire intro, including the water pour, which was perfect and sounded incredible, without being live. And chat was going. I almost was ready to start doing a roll call, and then I noticed that something was wrong. At first I noticed that the commands weren't working. And I'm like, I need to fix that. And I relaunched the command system, and it also said that YouTube was not live. And then I realized, then I knew that in my joy and my celebration of having AC again in the studio, it was off the record. Yes, as Greener said, it was off the record. None of it was like nothing happened. So it can't go on my record because none of you saw it. I am Minnesota Nice. I am so pumped. This is the best. I love this sort of stuff. Now, let me give you the background on this trial. We'll find out a little bit about this as the trial goes on. But the hearings we're going to watch, I don't think they go into. We're not going to watch the first hearing. That happens, the arraignment and everything 3 months ago. And that was where the Sov Cit first developed, and we played the audio from that today. We're not going to go into that, but basically, here's what you need to know. We have a Sov Cit defendant.
There's a lawsuit.
Who was articulate enough to convince the judge that he can defend himself. And at least he says that he knows what's coming for him, and he's okay with that. He's a transient type gentleman that lives out of his car. The issue at stake that we're talking high crimes and treason here. He was charged with trespass at a 7-Eleven. 7-Eleven is a grocery store, a convenience store chain. They sell like Mountain Dew, gas, sometimes gasoline, and just chips, the basic things. It's a little convenience store, usually open 24/7. He was charged with trespass. The gist of what I can understand is that at the scene when the officers arrived, they're like, "Oh, you again," and they're like, "Mr. Milton, you need to arrest you." He says, "You can't arrest me. I can't be held accountable for something I did when I'm too drunk to understand what's going on." So this is the the basis we have moving into this. It's gonna be amazing. It's gonna be amazing. Yeah, I tell you, there is no more beautiful sound than the sound of the air conditioner turning off because it's too cold. And that just happened. It was no fans in here. It's great. It's heavenly. I've even got my blackout curtains back up just to make it dark, so it's good. They're off camera. They're just above this view. But we're good to go. All right. So unless you have objections, I want to just kick it off with the case. We've got about an hour and a half of video to watch. I also have to say another huge win. Woke up this morning, my phone went ding, and I woke up and it says I had an email, and it was from the Department of Public Safety from a state that I had requested a FOIA request for a helicopter and police audio footage for a police chase, and I got it. And they sent it to me. It was for free, 1.5 gigabyte file, and it was free. And they sent it in some weird format, so I've been up converting it so we can play it this morning, and it's great. It's wonderful. So we have a police chase. It's fairly recent. It was within the last month, I think. It looks like it's from a drone ship in Iraq. Okay, honestly, it looks like it's got that FLIR, the camera overlay, the GPS locations. It's got everything on there. So it's a fun view. They use the FLIR, they use the heat imagery to find the car, and towards the end it becomes important. Anyway, so that's going to be a lot of fun. It's going to be awesome. I'm not sure if we're going to have time to get to that because we have the Sov Cit. I don't think the Sov Cit case is going to run more than today. And once you see some of what happened in jury selection, you might understand why. I think it's going to go sort of fast. But hang on, Lee. What is this? I feel like we should have commands to control Ari's temperature. Honestly, I have the capability to do that, but I don't think that's a very good idea, Lee. I don't think it is. We could sync up commands and turn on the fan, turn on the AC, set the temperature. We could do all that. You're hyped. We're hyped. It's a Sov Cit case, and it's with a jury. Oh my goodness, this poor jury. We're going to watch the jury selection, but it's fairly quick. It took about an hour to do that. We need to start first with the initial. Let me make sure I've got the right one pulled up here. Yep, the first one. The first appearance is just them the morning of jury selection. Okay, we're gonna pick up with that one, and let's see here. Let's go back to multi-view. Is there anything I'm missing? Is there like a birthday or anything I need to shout out before? I'd hate to miss that this morning. Yes, Mr. Peyton Milton, accused of criminal trespass, first degree. This is good. Let's see. I do have a little more energy when I'm not fighting for my life against the temperature. Ashley, awesome. Drive safe. You forgot to mention our anniversary. Dinah, did you have an anniversary? Or is it my anniversary? Or our anniversary together? I need some clarification on this one. The only thing I'm bummed about this morning is the water pour was perfect. It would have made everyone, water across the country the water pressure would drop as everyone had to flush at the same time. It was that good. It was so good. Taco Tuesday.
Good morning, addicts. Taco Tuesday.
Hey, welcome, Ivan. Thank you so much. Thanks for all the super chats yesterday as well, my friend. Appreciate you so much. We're toying with some ideas with Ivan. He's been such a fun person to have on the channel, and the recent case where Ivan thought one way and I thought another, and one of us was right. It sort of spurred some ideas. So we're going to flesh that out and see if Ivan wants to play ball in that area. But it's fun to get his opinion, especially when it's different than mine, and that's basically what it's oriented around. Anyway, let's see, a 4-month anniversary. I love you all so much. Thank you. I think I did miss a couple comments that might have come up earlier. Congratulations, Dinah, on the 4-month Dinah Do 420. It's a member anniversary. I'm sorry, they go so fast, and let's see. Oh, there it is. I see it. Good morning, peeps. Thanks, RA mods and peeps. Love you all. Thanks for this amazing community. I found it. It was right near the top. Had I got 7 more messages, it would have been off the screen. We saved it just in time. All right. I didn't see any birthdays. Let's see. Stopped partying without us. I missed any other anniversaries other than that one. I do apologize. It's because I was talking to myself and not to you guys during that time. Ven says, I thought you were just waiting for me to wake up. You're here, so it's good. We can start. I'm excited. This is a Zoom court, okay? And it's Washington, and they literally are still following their pandemic protocols. And they'll mention that. Even you'll see it in the spacing of the jury, which we get to see. The jury's like on camera in the panel for selection. You normally don't get to see that. This one we do. But it's not really a huge issue. It's not like these jurors need anonymity to decide this trespass case. It's probably not going to be the highlight of their legal experience in their lives. Anyway, Denise Feldman Ursland says, I couldn't imagine being anywhere else. Thank you so much for the safe space. Welcome. Good to have you here. 7 months. Love that yellow courthouse as well. Thank you all. Let's kick it off. We've waited long enough, right? Give me just 1 minute here. Let's make sure we have audio. I think we do.
You ready to proceed today?
Are we ready?
Yes, Your Honor.
We're ready. This is in Thurston County in the state of Washington. The city of Lacey is bringing charges against Milton. Milton's on the left. The city's on the right. We have one observer in court. Judge, I don't know the judge's name. It'll come to me. But there was a prior judge that handled some of this that's mentioned a few times. I think it's Judge Myers or something, but I don't recall this one's name. So I might need to make myself a little smaller. Hang on.
First thing I'm going to do this morning is have the same conversation with Mr. Milton that I had at his original court appearance in this matter. And I have been told that Judge Meyer had the same conversation with you, Mr. Milton. That is, you're sitting by yourself. You don't have an attorney. You made that choice back in April when I last saw you. And I'm sure we had a full conversation about that, but I'm going to do it one more time. You have the right to be represented by an attorney. You know that. I've advised you of that. You have the right to be represented at no cost. You understand that? That's a question.
Yes, I understand.
Okay. And you understand you also have the right to represent yourself.
Yes.
And if you make the choice to represent yourself, which you have done to this point, you understand that I can't assist you in the presentation of your case. That you need to answer out loud and record your answers.
Yes, I understand.
Okay. And you understand that I'm going to hold you to the same standards that I hold Mr. Sharp to as far as the presentation of the case. And that's even with me making the assumption that you have not gone to law school. I'm correct about that assumption?
Absolutely.
Okay. So I can't assist you in telling you to do things that you're supposed to do or telling you not to do things you're not supposed to do. I can't do those things. You understand that?
Yes.
Okay. And you understand if you were an attorney and you had been charged with the crime, I would be saying the same thing to you. I would be saying, don't represent yourself. In my opinion, that's always a mistake. You should always have somebody represent you. You understand all of that?
I do.
Have any questions for me about it?
Negative, Your Honor.
Negative, sir.
And you understand I'm willing to appoint an attorney at this point since we have not started the trial. I'm willing to appoint an attorney now. If you say, no, I've thought about it. I'd like to have an attorney.
Okay.
This is my criminal trespassing case, correct?
That's the case.
I'll pass.
Okay.
Yep.
So meaning you wish to go forward representing yourself.
Correct.
Okay. I'll find that Mr. Milton, after now 3 discussions at least on this topic, continues to be consistent in his position that he wishes to represent himself. I believe there's been a full and discussion of this, and Mr. Milton fully understands the ramifications of representing himself and is making the choice to do so, does so voluntarily. Mr. Sharp, the city's proceeding on one charge, criminal trespass.
In the first degree, yes, Your Honor.
Yes, he's got no pants on. I believe he just has shorts.
Property alleged to be trespass is what?
This is a 7-Eleven store on Marvin Road, Your Honor.
Okay.
You need the street address?
2425
No, that's fine.
Marvin Road, Northeast in Washington. 7-Eleven. I don't know why I remembered that address, but that's where it is. I've never been there. Okay, so the judge is going to go through a little explanation here. Sovereign citizen means he's basically his own person. He's beholden to no country. He preserves his own rights, can act in his own defense. Nobody can do anything to him without his permission. This is the idea of a sovereign citizen. We saw the same thing in Darrell Brooks, and you'll hear some of the same
Your
arguments.
expected witnesses today are Mr. Sharp.
Your Honor, that would be tomorrow. We're expecting
Yeah, tomorrow.
Evers,
Sorry.
Officer Evers and Jessica Heasley. City has Janae Sal on standby as a potential rebuttal witness.
Okay, so and Officer Evers' first name is?
If I could have a moment, I don't want to misspell it or anything. That'd be embarrassing.
This part is catching up. The live is going to be the jury trial, which starts at noon our time. So we're catching up with what happened yesterday. So this is yesterday. Darrell Brooks, I heard that.
Josie Evers, Your Honor. Josie.
Thank you. And Jessica Heasley?
Yes, Your Honor.
Seven, thanks for 7 months of support. It's your what is it? Your golden birthday, is that what they call it? The magic birthday when your name and your number match up.
And Janae Sal is a potential witness.
Yes, Your Honor.
And you're not intending to call Ms. Hoffman Gates?
No, Your Honor, and I'll just stop there. No.
Okay.
I was kicked back, taking it easy.
And Mr. Milton, do you have any witnesses that you expect to appear tomorrow for trial?
Officer Evers.
Okay. Anybody else?
I have not been able to confirm that anybody else will appear for me. So
Okay.
the answer is no.
Okay.
He doesn't know how that subpoena system works.
I do note that you had submitted a witness list early on, but no contact information for those folks. So you've not been able to get hold of any of them?
I was able to get a hold of them, but my original court date that I told them about was like 20 days ago or something like that. Perhaps it was even last month. I recall I was arrested on June 4th. I had my witnesses set up to come and give me written testimony, and they were just waiting to hear from me, but I had none of their phone numbers, none of their addresses, and the only witnesses that I had worked at the location that I was trespassed from. So the only way that I could get there was by breaking the law further. Didn't seem to make a whole lot of sense, so I'm relying on Officer Evers to testify the truth.
Okay.
The truth, as in
Right.
opposed
So
to the facts
Evers
he's already
will be here.
testified to in the report. He has an officer for a witness. A Sov Cit with one officer as his witness list. This is one of the reasons why it's going to go fast.
And if I remember correctly, Judge Meyer had a discussion with you about your witness list. Is that correct?
We had a brief discussion, correct?
Okay.
Yep.
Right.
A convenience store, 7-Eleven is where he was
And-
trespassed from.
Mr. Sharp, any motions in limine from the city?
Yes, Your Honor. I guess first I'd just, so the city would like to reserve objection if any surprise witnesses do come out of the woodwork in response to Mr. Milton's request. I'll save the rationale
for now.
Okay.
So you'd like to raise the issue of identity. This morning, Mr. Milton has been responding to the court's colloquy, including addressing him by name. At previous hearings, he's identified as some other entity.
I never said I was Peyton Milton.
Calling himself, I believe, something along the lines of the agent authorized to represent Peyton Milton.
Okay.
I would submit to the court that there's only one individual in this courtroom other than court staff, observer, and prosecution. One person sitting at the defense table. The case is City of Lacey versus Peyton Ansley John Milton, and he is responding to discussions with the court. That would mean he's either the defendant himself or an attorney. As the court just established through thorough colloquy, there is no attorney on this case. That would leave the only conclusion being that this is the defendant. Now, it would be a different issue discussing whether the individual in question committed the act, and that's a fact for the jury to find. The city would move to exclude any references by Mr. Milton as to him being some entity other than himself. Grounds for that primarily being that, well, first of all, there's a factual issue, a legal issue, but it's not necessarily relevant for the jury. It could potentially lead the jury astray on a rabbit hole that would interfere with the process unduly, and there's no proper place for those assertions within this trial.
Thank you.
I object.
Okay. All right. Hold
Object.
on. Other motions?
A very ardent objection.
City would inquire as to whether the court intends to issue a preliminary pro se instruction, given that Mr. Milton is representing himself. That's an unusual circumstance that the jury deserves some instruction about. I've researched. I don't see a model Washington instruction along those lines. However, there is a model instruction from the federal system. And I guess I'm starting with an inquiry if the court has that instruction. If not, I would be happy to draft one up using that federal model language. The issues here being the jury would need to understand that he has the right to defend himself and that he's chosen to exercise that right. Additionally, that he'll be speaking at times other than under oath, and that when he's speaking not under oath as a witness, that is not evidence.
Yes, I fully intend to instruct the jury as to that. If you want to print up the federal instruction, I'll look at that. I've not seen it before, but I typically do instruct the jury as to pro se defendants.
Okay, and when do I need to provide that to the court?
Before this afternoon.
Okay.
Thank you. Anything else?
That's it from the city, Your Honor.
Okay, thank you. On the issue of Mr. Milton's name, I do recall now, since you brought that issue up, I remember vaguely, since it's been now 3 months, going on 4 months since I last saw Mr. Milton, this conversation about name. I'm not going to prohibit Mr. Milton from identifying himself as he chooses to identify himself. I think the issue of whether he's the person that was at the scene and had previously been told he couldn't be there, that's an issue the city's going to have to prove and do it before the jury. What Mr. Milton likes to call himself or not, I don't think is an issue I'm greatly concerned about. I'll let you you can of course make objections. If you believe Mr. Milton is trying to hide behind that to say some alter ego was present, but he wasn't there, that issue I won't allow that before the jury. So you can make the objection if there seems to be that presentation.
Understood, John.
Okay. Mr. Milton, did you have any pretrial motions you wish to make?
I feel the need to say that I'm not Peyton Ansley John Milton all of a sudden, but thank you for defending my ability to be the agent authorized to represent the name that I was given. I don't believe I do.
He can't even follow the logic.
Okay, so I will make clear to the jury, if you make that statement to the jury, I'm going to say, because when you say that you're the agent for a person, that can lead a jury to believe you're the attorney or the representative of a person who's now not here, that other chair is absent. I'm going to say, no, this is the person who has been charged with the crime. You're referring to yourself as the agent for the person who was given the name you were given at birth. And with that understanding, we can go forward.
Yes.
Okay.
Please, let's.
We have an objection counter.
Yeah.
It is at 1 right
Last thing I'm intending to do is to disrespect you, Your Honor, and to not be present, etc.
And by that, it means it is on his list. It's just on the bottom.
All right.
Thank you, Ann, for the gifted membership.
Yeah, I think we have all the issues we need to discuss prior to the selection of a jury. So I will, since you are representing yourself, the way this is going to work this afternoon when we come back for jury selection is the jury will be seated in the seats behind you.
Okay.
And I don't know how many jurors we have. It's usually somewhere between 18 and 20. And you'll have a seating chart. And we refer to them by numbers, 1 through whatever number. And you'll have information about each one of them. And I will instruct them on their role as jurors. I will ask some questions of them. I'll ask them to introduce themselves. And both you and Mr. Sharp will have spun your chairs around and be facing the jurors back there so you can see who's speaking.
Gotcha.
And then I will give each of you 15 minutes to inquire or ask questions of the jury.
Thank you, Tag.
And then when we finish the questions, I'll ask both of you to come forward. And you're going to tell me whether you think there are any jurors who can be challenged for cause. That is, they've said something which leads you to believe they can't be fair. And I'll address any challenges for cause. I will also make notes if I perceive any. And then after that, each one of you gets 3 challenges. So you don't have to have a reason, and you can challenge any juror you want, and we just go back and forth until each of you have used your 3 challenges. And then at the conclusion of all those challenges, the lowest remaining 7 numbers will be our jury. So if 1 through 7 haven't been challenged, they will be the jurors. If one of them have been challenged, and we just keep moving up. We have 7 because we are a 2-day jury process now, so we hold on to 1 juror as an alternate. And that would be the highest remaining number of those selected. And that person will sit through the trial. And if all 6 of the other jurors are present when we go to deliberations, then the highest remaining number gets excused and doesn't participate in deliberations. So I run through that process. Do you have any questions for me about how that works?
I don't believe it's going to change anything whether I ask or don't. So I'll have to say.
And you don't have to ask any questions. You can if you wish.
Appreciate you. If I knew what to ask, I would.
The judges.
It's one of those things I told you ahead of time. I can't tell you what to ask.
No worries. No worries.
Okay.
Appreciate you.
All right.
Just kick back, taking it easy.
So you're free. I'm pretty confident Mr. Sharp will ask some questions. You're free to, when I then turn to you and say, do you have any questions for the jury? You're free to say, no, I don't. And if you actually have questions for the jury, you can ask them. You'll do it from the table. And the questions are only meant to determine if the jury can be fair. That's the sole basis of the questions in what's called voir dire, is just to determine it, can they be fair jurors in a trial.
Gotcha.
Okay, so that will be our process for this afternoon. And once the jury is picked, I will give them some preliminary instructions, and then we'll excuse everybody and come back tomorrow for trial. And it's going to be important that you're here on time tomorrow because we're asking people to come in who are giving up days of work and things like that to be here. So I don't want to keep them waiting. So I want you here at 9 o'clock, ready to go to start the trial.
You got it. Thank you. Yeah, I will
right.
be here on time.
Mr. Sharp, anything else from the city?
I have one exhibit to pre-mark. I brought a copy from Mr. Milton. I'll go ahead and walk that up to the clerk.
Okay.
If that's okay.
Yep.
Nancy, thank you for the gifted membership. Okay, so we're watching the video from yesterday because the jury trial is going to begin today. So we're going to watch this and get caught up. Look. He holds those hands away. I don't want to touch that paper. He doesn't touch it.
And actually, may I see it, Mr. Sharp? Thank you.
This is in Lacey, the city of Lacey, Washington. Thanks, Dean. This is a criminal trial with a jury, or we'll have a jury. It's going to be in a couple hours, an hour, 2.5 hours, and the defendant is pro se, meaning he's representing himself, and he's also a sovereign citizen.
This is City of Lacey's exhibit number 1. Is that correct?
That's correct.
Thank you. And Mr. Milton, and I'm going to refer to you as Mr. Milton. I understand what your position is on that.
Yeah.
Do you have any objection to the admission of this exhibit?
Other than the fact that I'm technically not supposed to receive this, so I'll be leaving it on the table here. Negative.
Okay.
Oh,
so without an objection from the defense, this will be admitted as City of Lacey exhibit number 1. So you don't have to go through the admission process. And Teresa will mark that exhibit. And you have no other exhibits, Mr. Sharp?
No, Your Honor.
And Mr. Milton, do you have any exhibits you wish to introduce as evidence?
Now, is this where I would be required to put in the statute, the RCW, that would be in the case of my defense?
Well, okay, let's talk about that. That's an interesting issue. The law is what I instruct the jury on. You don't instruct the jury on what the law is.
It's my understanding if I don't verbatim the RCW, then all of a sudden I may have a contingency to worry about.
Okay.
Trying to keep a straight face.
I don't have the charging document in front of me. I'm assuming it's actually a violation of Lacey Municipal Code that you're being charged with, or is it? It's
charged under the Lacey Municipal Code, Your Honor.
Oh, that's good to know.
Okay. And
he doesn't know what he's charged with the day before trial.
Yeah, let's do this. I know I've told Mr. Milton we can't assist him in the presentation of his case, but to avoid any appellate issues, if you can print up the Lacey Municipal Code, or do you already have it printed up?
Printer with me, Your Honor. I wonder if the clerk could do it.
Yeah. If you can email it to Teresa, we can get it printed up.
Madam Clerk, is it okay if I send you a link to it? It's online. It's online, so I'll send you a link so you can print it directly from the online source.
Okay.
So we're going to print up the Lacey Municipal Code provision that the city is proceeding under, so you can look at it.
So RCW would be the state code, but he's charged in
the elements of that code section are what Mr. Sharp has to prove to the jury in order for you to be convicted. So to the extent that you want to talk about the law, that's totally appropriate in argument. It's not appropriate by way of testimony.
Okay.
So, and this is going to be something, and Mr. Sharp alluded to this, this is going to be something where you're going to have to understand there's this fine line. When if you choose to testify, and you don't have to testify, but if you choose to testify, you're going to come up here like any of the city witnesses, and I'll swear you in, and you'll sit there, and the jury who will be seated over there will hear your testimony. And your testimony will be about the facts of the let me see.
He's never had to give these instructions before, telling lawyers how to proceed. This guy's just chomping at the bit. He cannot wait to proceed and defend himself.
Facts of the events of March 31st. They won't be about the law. They'll be about the facts. You're not making an argument. You're saying, I was here, I wasn't here, whatever your position is on that. At the close of all the evidence,
an observer,
I give each of you, both Mr. Sharp and you, a chance to argue to the jury about why the facts he's going to argue prove that you engaged in a trespass in violation of City's Exhibit 1, and you can argue to the jury why you believe you weren't in violation of that order. But it will be based on all the facts that come in testimony. So anything you say outside of the time you're sitting in the witness chair aren't going to be facts that the jury can consider. So if you neglect to say something when you're testifying and then you add it into an argument and Mr. Sharp objects and say that fact didn't come in, I would sustain that objection, because the only facts that come in that the jury can consider are those that either come from you or other witnesses when sitting here as a witness under oath. Okay? So, it's a fine line and it's hard. That's one of the reasons why it's tough to represent yourself. I will also let you know that if you choose to testify, you're not going to have to ask yourself questions. That's, kind of a silly process. You can just tell the jury what you believe the facts of the case are. But you can't argue to the jury at that time.
No
all
worries.
you can tell them are what the facts are. You can't say, and you should find me innocent because this, and this.
I got it dialed down to 3 points.
Okay. All right.
I got it dialed down. 3 points. Okay, so we're catching up with what happened yesterday. Then we'll have this court live. The Microsoft case got pushed back till September, unfortunately. Last minute, they got rescheduled. Yeah. And that's just how
Your
court
Honor,
happens.
maybe it'd be helpful, and in the spirit of fairness, I prepared already the city's proposed jury instructions, and that may be useful for Mr. Milton to have to review. That I think would satisfy this question as to what the instruction as to the law is going to be. The court be willing to accept that, and I'll
Sure.
start with him now.
Yeah,
I had planned to do that later in the process, but
that's fine.
So he's going to give him the jury instructions. This guy's bending over backwards to help him, as often we see in a Sov Cit case at the beginning.
Okay, so there are two sets of instructions here for Mr. Milton who hasn't done this. One is cited, the other is uncited. What I mean by cited is that they're based off of...
Why don't you just present Mr. Milton a one-sided version? He doesn't need the unsighted, unless you...
Understood, John. All of the instructions are derived from the Washington pattern jury instructions.
And may I see it so I can refer
of course.
Mr. Milton where to look, so we can just cut right to the chase on this? Thank you.
Cited.
Yes. Good. Thank you.
Lady in the back is just an observer, just somebody who wants to watch court. That's where the jury is going to be seated here in just a minute when we jump to the afternoon from yesterday.
There's a raccoon on our roof.
There's a raccoon on our roof in the garage?
Oh, red. I get it.
Hang on.
I have red-green color blindness, Mr. Sharp. So.
So about 2/3 of the way back, labeled as instruction 60-16.
Yep. Okay, so Mr. Milton, if you'll open that packet, and as Mr. Sharp says, go about 2/3 of the way back. If you'll open it up, so
Would you just tell me what is to be understood?
Okay. So is it reading an issue? Let's say
yes to make things simpler, Your Honor.
Okay. All right.
Yeah.
Okay. So it essentially reflects the language of the Lacey Municipal Code in the elements that the city needs to prove. And what the city needs to prove beyond a reasonable doubt are that on the 31st of March, you knowingly entered or remained in a building, that you knew that the entry or remaining was unlawful, and that this occurred in the city of Lacey. Those are the three things that the city has to prove. Okay. You knowingly entered or remained, you knew you shouldn't be there, and this occurred in Lacey. So
Gotcha.
That's the law that's going to be before the jury.
Okay.
Okay.
Beautiful. Thank you, sir.
Okay, and you have it in the documents if you wish to refer later to it, but that's essentially what it says.
I sent my kids out to get pictures of the raccoon. I don't know how it got on the roof. There's no tree next to it. I mean, there's a tree over it. It might have fallen on it. Yes, also part of the Sov Cit thing, he can't receive or refuses to receive because he's not the person. You know, in all capital letters, it's bizarre. But in his head, it all makes sense. He can't actually read. I don't believe reading is the problem. I believe it's more of his refusal to accept and participate in the process that he's there. It's easier for him to say that he can't read, but it's not because of ability. He never received it. He can't be held accountable because he never received it. Let's let him get some things squared away here. Then we'll kick off the jury selection ahead of the live trial that's going to be this afternoon. You know he can read because he's been on the internet researching this. And look at him just rubbing his hands together. He's like, let's get this show on the road. I'm gonna show this court. I'm gonna educate them all. Neighbor's dog is barking at the raccoon now. I do have air conditioning. It's beautiful. Of course, it's cooler this week anyway, so. This one looks sleepy. Just going to wrap this up here. Yeah, I need to. That's our intake, the air intake. That's whistling.
It's just to be clear, I will also read to the actual language of the Lacey Municipal Code. So what it says, Mr. Milton, is a person is guilty of criminal trespass in the first degree if he knowingly enters or remains unlawfully in a building or on real property adjacent thereto, or upon real property which is fenced or otherwise enclosed in a manner designed to exclude intruders. So it has not only the entering into a building, but or on real property adjacent to a building or real property which is fenced or otherwise enclosed. So that's the Lacey Municipal Code.
Okay.
Okay.
Cool.
You will, I think we've resolved all the issues. Do you have any questions for me?
Negative, Your Honor.
Okay. Ms. Sharp, anything else?
No, Your Honor. Thank you.
Okay. I'll see both of you at 2 o'clock and be here. Now you know where we are. So be here at 2 o'clock and we will proceed with our selection of the jury, and then we'll gather again tomorrow morning at 9 o'clock for the trial.
Your Honor, quick question on the timing there for Mr. Milton's benefit mainly. The jury selection process starts at 2. Is there a time we should be here to receive any preliminary documents if there's still a questionnaire? I don't know if that's the...
Yeah, you may want to get here a few minutes early, say 1:50, just to receive.
Oh, 1:50? I thought it was 9 a.m.
No. This afternoon, you're coming back this afternoon.
Oh, goodness. Okay.
Okay,
That's good
because
to know.
we're going to select the jury this afternoon.
Gotcha.
And then we're going to start the trial tomorrow morning. So you need to be in that chair no later than 2:00. But if you come earlier, you'll get copies of the juror questionnaire, which you can read if you wish.
Gotcha.
Okay. So
All right.
we'll see you at 2 this afternoon,
Yes,
right
sir.
here. Okay. Thank you.
Okay,
Yep.
so
Thank you, Your Honor.
Welcome.
he's like, ciao, y'all. Namaste. I forget what he does here. He's loading up all his gear. He's going to be headed out of here. And now we're going to cut to the 2 p.m., okay? Let's see. Give me just 1 second.
Hello.
No, that's Mike. I'll talk with Mike, who also is covering this one, but we don't want his live feed. Just 1 second. I love Law Talk with Mike, by the way. Funny guy. Okay. All right, jury selection. And audio.
Each of the parties, Mr. Sharp on behalf of the City of Lacey and Mr. Milton on behalf of himself, will have a chance to ask some questions, and then we'll select our jury for the case today. So that's the process that we're going to go through. My guess is it will take, or give or take, a few minutes on either side, I'm guessing.
Okay, so he's had all the instructions. He's told when to be here. He's here. He's on the right side now. So Mr. Milton's on the right. The jury members, potential jurors, are seated there in back. I think we have like 19 or so of them. Roughly, they're seated about 6 feet apart for, precautionary reasons, because the court still operates that way. When they're done with the questionnaire, the lowest 7 numbered people, after they've eliminated everybody, the lowest 7 who remain are going to be the jurors. So after all, the reasons excused for cause or without cause. So let's kick this off in grand style here. Dr. Jennifer, I cannot remember this judge's name. This is the district court judge in the city of Lacey, the district court that covers the city of Lacey, Washington. But
folks,
they'll say it here eventually.
Actually, before we do that, Mr. Sharp and Mr. Milton, if you'd swing your chairs around to the other side of the table. Just swing your chairs around to the other side.
It's got wheels on it, but he picks it up and carries it.
Officer Ever said it correct.
Bring all your files with you. There's one juror who's like is
Folks,
the right height to
all
swing
the
his
jurors would
legs under the
please
chair.
rise and raise your right hands. Do each of you solemnly swear to truthfully answer any questions asked of you by the judge, Mr. Sharp and Mr. Milton, in the jury selection process today? You may be seated.
We just have to take care of it on our own.
So we can shoot it.
I would like you to shoot it, yes.
I have to go eliminate a raccoon. I have the proper arsenal to make that happen.
Begin with our standard instructions. I'm going to get right to an obvious point, which is Mr. Milton is sitting here by himself. Typically, there would be counsel with him, and I'm going to address that issue now. First of all, I want to address the issue of Mr. Milton. This is Peyton Milton, and Mr. Milton, that's what I refer to him as. He prefers to refer to himself as the agent for Mr. Peyton Milton. So I don't want there to be any confusion. We're talking about one and the same, but I refer to him as Mr. Milton, and he may refer to himself as the agent for Mr. Milton. And I told him prior to trial, that's fine. He can do that. So I wanted to clear that up. And also let you know that Mr. Milton is representing himself. And he and I have had chance to have a good conversation. It was a full conversation. It was a thoughtful conversation, and Mr. Milton is exercising his right to proceed without counsel. There is a formal instruction on that, and I'm going to read it now just so we make sure, I make sure I cover all the bases in this regard and clarify for you what that would mean in the context of your serving as a juror in this case. Mr. Milton has decided to represent himself in this trial and not to use the services of an attorney. He, in fact, is eligible for court-appointed counsel, and the court said I would be happy to appoint counsel. Mr. Milton has made the choice not to accept that offer. He has a constitutional right to represent himself. His decision to represent himself has no bearing on whether he is guilty or not guilty, and it must not affect your consideration of the case. Because he has decided to act as his own attorney, you will hear him speak at various times during the trial. He may make an opening statement, he may make a closing argument, and he may ask questions of witnesses, make objections, and argue legal issues to the court. It is important that you understand that when Mr. Milton speaks in these parts of the trial, he is acting as his attorney. And his words at those particular moments are not evidence. The only evidence in this case comes from witnesses who testify under oath on the witness stand, which is right here, and from any exhibits that are admitted into evidence. Mr. Milton will have the opportunity, if he chooses, to testify as a witness, or he also has no obligation to testify. But any facts you are to consider from Mr. Milton would come should he choose to testify under oath from up here. This is a criminal case brought by the city of Lacey as plaintiff. The city is represented today by Mr. Matt Sharp. And as I've discussed, Mr. Milton is representing himself. Mr. Milton is charged with the crime of criminal trespass, first degree. Specifically, this charge alleges that in the city of Lacey on the 31st of March of this year, Mr. Milton was present on the property of the 7-Eleven store on Marvin Road, and he had previously received a trespass order indicating he should not be present on that property. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. To the charge of criminal trespass first degree, Mr. Milton has entered a plea of not guilty. The plea of not guilty means that you, the jury, must decide whether the city has proved each element of the crime. The city has the burden of proving every element beyond a reasonable doubt. Mr. Milton has no burden of proving that a reasonable doubt exists. He has no duty to call witnesses, to produce evidence, or to testify. He is presumed to be innocent. The presumption of innocence continues throughout the entire trial. The presumption means that you must find him not guilty unless you can conclude at the end of your deliberations that the evidence has established the defendant's guilt beyond a reasonable doubt. A reasonable doubt is one for which a reason exists. It may arise from the evidence or lack of evidence. A reasonable doubt is a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or lack of evidence. If after such consideration you have an abiding belief in the truth of the charge, then you are satisfied beyond a reasonable doubt. Now, before I ask all of you some questions, I'm going to ask each of you to take a moment, introduce yourselves to us and to each other. And what I'm going to ask that you do is when I call your number, you stand and tell us how long you've lived in the area, what you do for any employment you may have,
your address,
and what your primary interests are outside of any employment you may have. And before I do this, I'm going to point out the obvious, and that is you all have a number attached to you. In case you're curious, your name was randomly drawn and assigned that number. And the reason I'm pointing this out is you do not need to give us your name for purposes of serving as a juror today.
This is awesome.
You don't have to give us your name. You may maintain your anonymity if you wish. The reason we do this is we've had requests from jurors in trials past that wish to do so. So when you stand, you can give us your name if you want to, or you can just be juror number, whatever your number is. And we'll start with juror number 1.
But we do want your favorite color.
Juror number 1, Christian originally from San Diego. I've been here 20 years now.
And employment?
And there they are.
Okay. And interests outside of employment?
What are your hobbies?
All right. Thank you very much. Juror number 2.
John, and I'm a self-employed woodworker. And I was born here.
So much pressure. Be cool.
My interest in my work and I like reading and road trips, that kind of thing.
All right. Thank you very much. Juror number 3.
Oh my gosh, this is so funny. Oh, I can't hear them at all. Please act it out.
Rescuing animals.
She said rescuing animals.
Embroidery.
All right. Thank you very much. Juror number 4.
My name is Terry, and I've lived in this area about 25 years, moving here from Canada. And I am a real estate broker working for Windermere office, and I'm an elected official serving on the Yellow City Council.
Thank you very much.
I'm
Juror number
in
5.
charge, just so you know.
My name is Linda. I've lived here about 28 years. My husband and I moved to the area. My husband was in the Army, and we were in the Army for 27 years. I'm retired from working for the school district in a kindergarten room. Currently, my husband and I are currently serving as full-time missionaries for our church.
Awesome.
Working with the young missionaries with medical issues.
They're
All right,
probably
thank
in our
you.
church.
Juror number
That's
6.
really hilarious.
My name is Joe, originally from Florida. Been here for about 19 years. Currently, I work at Western State as a maintenance mechanic. Outside of here, I just like to work on music independently.
All right. Thank you very much. Juror number 7.
Thanks for choosing me.
My name is Travis. I've been in the area for 14 years. I'm a transportation manager. Outside of work, 2 brand new grandbabies, so doing everything I can to chase them around as much as I can.
All right. Thank you very much. Juror number 8.
This is awesome.
David, originally from San Francisco, but have been here for the last 30 years. Recently retired. Used to commute up to Seattle. The last 25 years installing corporate security systems like cameras, badge readers, stuff like that. So that's what I do.
Thank you very much. Thank you. Juror number 9.
I didn't know I would have to do this. I quit.
My name is Luke. I've been born and raised here for as long as I can remember, and I work as a forklift operator at a warehouse. Very
Okay. And outside of work, you like to?
relaxed.
Okay. Fair
I
enough.
hate that question. I'm like,
Juror
I don't
number
like
10.
to do anything. I just want to work.
My name is Brandon. I've lived here almost my whole life in Thurston County for 16 years. I am transportation and engineering director for government here in Thurston County. And hobbies outside of work or woodworking, being outside.
Thank you very much. Juror number 11.
Juror number 11. I've lived here all my life in Thurston County in the last 30 years. I'm an airline pilot, and I dive, and I fly a sailplane.
Thank you very much. Juror number 12.
I am a
management analyst with Department of Labor and Industry. I write wax school. Interests, we eat, breathe, and soccer. Both my kids play competitive. I serve on the court. So.
Thank you. Juror number 13. Thank you. And juror number 14.
Oh man, how many are
Chris,
there?
been here about 10 years, came from Minnesota for that. Construction project manager for the Fish and Wildlife. Now I conflict.
Thank you. Juror number 15.
Been there 38 years. My out time is chasing after my 17-year-old.
Good luck. Juror number 16.
Born and raised here, moved to Wade for work in school and everything while I've been back for about 2 years now. I work as a software developer, and interests include woodworking, 3D printing, honestly just about anything. If you name a hobby, I've probably looked into it.
All right, thank you. Juror number 17.
Oh my gosh, it's the whole town.
17 years, retired. Right now, I try to keep up with a very young labor crowd.
Thank you. Juror number 18.
This is a huge jury. I think the judge might be really lonely. Okay, Scott, they're doing a get to know you game. They're just standing up and introducing themselves. It's awesome.
Thank you. And juror number 19. Good. Do we have any? Yeah, there we go.
I was born and raised here until I graduated from Lincoln High School. I came back here after college to go to law school at the University of Washington, and then I pursued a career in international law, from which I retired just last year. I've actually traveled to 110 countries. Besides travel, my current hobbies are swimming, reading, and hiking.
Thank you very much.
Okay, as there.
There is one more thing that
yes,
I probably should mention.
She doesn't want to serve.
I have, this is very early in my legal career, I provided legal advice to prisoners at McNeil Island, San Quentin, and Alcatraz.
Yeah, thank you very much. And you're right, that would have come up a little bit later in our conversation, but I appreciate you sharing that. All right, and before I start asking some questions, I'm going to point out another obvious thing, and which is we're sitting in what is just basically reformulated office space, and we're still separating people. We call this our COVID courtroom. Our normal courtrooms at the courthouse have people sitting right next to one another. They're much smaller than this. And even though, the COVID emergency, the pandemic emergency has been lifted, we are still sensitive to the fact that some folks prefer having a little bit more space. So we continue to use this courtroom for that purpose. Now, it's obviously not ideal because it has posts in the middle of it. Most of you are so far away from me that even with my glasses on, I can barely make you out. So my apologies. Once the jury is selected, they'll be seated over here, and it's going to be a little bit easier. But if you're curious why we're all sitting in what used to be somebody else's cubicle,
this trial starts today.
That's why.
This is
we're trying to just maintain a healthy environment for folks who are asked to come serve as jurors for us. All right, as indicated, I'm going to ask some questions. And then if you would answer yes to any of these questions, please just raise your hand and keep your hand raised until I call your number. Now, that's going to be problematic for me because I don't, I can't see your number, so I may ask you to tell me your number. And then when we ascertain your number, you can put your hand down. And then that'll give us a chance to decide whether your response may engender further questions. And understand that these questions are not meant to embarrass you. If there's any answer you might give that you're reluctant to give in front of a group of people you've just met for the first time, let us know. We'll see if we can skip over the question or if there's information that's important for us to get. If there might not be another way to do that without putting you on the spot. Does any juror know the prosecutor for the city of Lacey, Mr. Sharp?
I'll have a raccoon update.
Are there any jurors who are now or previously have been employed by the city of Lacey? Okay, and is that 16? Juror 16, is that right?
Raccoon's still alive.
Juror 16, thank you. And juror 16, is that current or you used to be?
No, I was a lifeguard for the department in high school.
Okay. Anyone else? All right, juror 16, I'm going to ask you another question then. Since at one point in your life you were an employee of the city of Lacey, and the city of Lacey is a party to this trial today as the plaintiff, is there anything about your prior employment that would keep you from being able to fairly and objectively weigh the testimony in this case?
No.
Okay, thank you.
The raccoon is not scared of people.
Are there any jurors who are now or
perhaps
previously have been employed by the 7-Eleven Corporation? Are there any jurors who, in any capacity, your personal or professional, have felt obligated to call law enforcement to report a situation of a trespass?
None of these guys have lived.
Thank you.
Never worked for.
Are there any jurors who themselves have ever been arrested, charged, or convicted of a property crime such as trespass? Thank you. As I indicated earlier, we had a little discussion about Mr. Milton representing himself. Are there any jurors who are going to have a difficult time with Mr. Milton representing himself to the extent that you would hold that against him in deciding this case? Thank you. We will conduct our trial proceedings tomorrow, starting at 9 o'clock in the morning. I have great confidence that this will be no more than a one-day trial. Are there any jurors for whom coming back tomorrow for trial proceedings would be more than ordinarily inconvenient? Okay, juror number 13, is that right? Okay, anybody else? Okay, juror number 13, tell me about that.
My boyfriend plays for the Red
Well,
Sox.
if he plays for the Red Sox, I should probably make you stay here. Now, if I'm not mistaken, the game time tomorrow will be 6:40.
She wants to get off because she has to be at a baseball
All
game
right,
at 6:40.
Sure.
Thank you, Aaron. Morning, everybody. I really like this icebreaker format. That's a new one to me. Matt Sharp, I'm a prosecutor for the city of Lacey. I enjoy just kind of tinkering around in the garage, whether that's woodworking or fixing something that I broke or fixing something somebody else broke. I noticed in the questionnaires that a few of you have done jury service before. Could I get a show of hands who's done jury service before? Now, out of those, keep your hand up if it's been a criminal case. We've been on a criminal jury. Okay, if you wouldn't mind keeping it up for a second. Juror A, what was the charge? Yeah, when you were a juror.
What was the charge?
Mhm.
I'm not sure if it's criminal. It was some guy hitting him with a vehicle.
Oh, I see. Like a car accident?
Yeah.
Okay. So who else did we have? Juror 11?
It was a felony eluding.
Eluding? Okay. Juror 3?
Was someone who was breaking a restraining order and being a property that he was not supposed to be at.
Ooh, that was
Okay.
trespass too.
And I thought I saw another hand. Was it Juror 6? Did you have your hand up?
Yeah, it was criminal.
It was a criminal? Okay. Well, thank you all for your service before and for being here again. You've heard the charge in this case already. It's trespass in the first degree, and I think we could all agree that's not exactly the crime of the century, but I would submit to you that it's important for all of us to be here, and I thank you for your time. There are a couple of reasons for that. I'd like to recognize that Mr. Milton is entitled to his day in court, and for that to happen, we all need to be here. So thank you for performing your duty so that important function can happen. I'd like to suggest there's another important reason too. And real quick before we get into it, this is the one and really only interactive part of the trial. After this, it's all passive. We'll be talking sort of at you or for you, but we won't get to hear back much. So I just encourage you to not be shy now and feel free to speak up and share. I'd like to start by asking, and this will, I think, illustrate the importance of this. Does anybody here own or rent their home, whether that's a house or an apartment or a vehicle even, or a tent? How many people own or rent or basically just have a space of your own? Okay. So Juror 3, I'll pick on you just for a second. Who gets to come into your home?
Those who are invited.
Those that are invited. If after we wrap up today, when you get home, all the rest of us show up and just help ourselves in, is that cool? No?
Unless you're invited.
Okay. What about if somebody was invited and they were already in, and then you didn't want them around anymore? What options do you have for that?
Communication is the best way. Ask them to leave.
Ask them to leave? Okay. I won't pick on you too much. Move on. Juror 4. So do you agree with that option? That if you've got a guest that you've already invited in, but maybe you don't want them around anymore, you talk with them about leaving? How about if they don't want to leave?
Make sure they understand that you really want them to leave, and I guess if they didn't, you would go for help to remove that person.
Why is it that you have the power to ask them to leave?
Because it's my property.
It's your property. Okay. And how about we shift it just a little bit? Does anybody own or manage a business with a like a physical location that accepts customers, like a brick and mortar type place? Nobody. Okay. Does anybody work as an employee, not a manager or owner, in a place like that? Okay, Juror 4, Juror 16. So I'm thinking like a shop or a restaurant or a theater, something like. Has anybody ever worked retail? How many people have worked retail before? Okay. See a few hands there. Has anybody worked in a movie theater? Okay, lucky you. I've done that. I'm going to ask you to imagine for a second. Let's imagine that you're working in a movie theater. And I'm talking about movie theater because it's a little different than a house, right? Like a movie theater, you don't get invited to go to the movie theater, do you? Juror 16, do you have to get an invitation to go to a movie?
No.
Why not?
It's open to the public. We want people to come in the ticket.
Okay. If everybody could just imagine, you're working in a movie theater, you poor thing. And somebody comes out during a big popular movie and they say, hey, somebody's in there and they're just shouting out spoilers. And it's ruining the movie for me. Juror 14, if you were that employee, what can you do there?
They've established to
Okay. Anybody want to guess what kind of policies there might be for a thing like that? How about, can you ask them to stop? Like, hey, stop ruining the movie for everybody. Okay, Juror 5. What if you've asked the person to stop shouting during the movie and you went back to the concession stand and you're working on some stuff and more folks are coming out of the theater and they're saying, it's still happening. He's shouting all the spoilers and giving away all the surprises. What happens next, do you think?
Almost, it doesn't quite seem like a big enough deal to call the police, or something like that. I don't know if the theater has security, at a theater, but if they did, I suppose you can turn it over to security people. I'm going to ask them to escort the person out.
Okay, so have security ask them to leave. Okay. Isn't the movie theater kind of similar to where you live? It's not a place where people live necessarily, but isn't it when guests are invited in, if they're no longer wanted? What do you guys think? Does a business have the right to ask somebody to leave? Can I get a show of hands? Does anybody agree with that? Does everybody agree with that? Juror 19? I don't see your hand.
Yeah, because I don't think that your home and a theater which is open to the public and for which you pay for admission are.
Okay. So the person that's in the theater and they've been shouting out the spoilers and they were asked to keep it down and they kept doing it and they were asked to leave. Would that be wrong in your mind to ask them to leave?
No.
Okay, well, how come?
Because again, it's a public place. Public places have rules that govern content.
Okay. Does anybody disagree? Yes, ma'am.
Maybe facilitate the leaving of that person by offering.
Okay.
Offer a refund.
Does anybody here disagree with that take on it? Any hands for that? Okay.
Nobody raised.
I don't have a whole lot more questions for you here. I kind of just have a catch-all that I'd like to ask. Is there anybody here that would have trouble at the end of this trial? You're gonna hear evidence from the parties. You're gonna hear arguments, and you'll be given instructions from the judge. The judge is going to tell you what the law is. Now, sometimes we like to think we know what the law is. We come in with ideas because we're trying to navigate within the law in our lives, right? Is there anybody that's going to have a hard time accepting the judge's instructions over what you came into this room with? In other words, if the judge gives you an instruction about the law that's different than what you thought before, is anybody have trouble with that? Okay. And then really a blanket here. Is there any reason that hasn't come up in the conversation, either with me or the judge yet, any reason you don't think you could be fair as a juror in this case? And that means fair toward Mr. Milton or fair toward the city? Seeing no hands. Ma'am, number 3.
Being at the trial that I was sat in a couple of years ago, I feel like it might be hard for me to be impartial based on the circumstances of that, how it ended up. The consensus of the group, the consensus of the jury was that we felt that the gentleman was guilty of what he was charged with, but there wasn't enough evidence to meet the criteria of what the judge gave.
Okay.
So it caused me a lot of anxiety because I felt that after it was all over and we got to know more about the case and the person, we felt like we made a wrong decision.
Well, how would that affect your judgment in this case?
I don't know if it would. I guess that's why I'm kind of struggling.
Well, it kind of sounds like you did your job. It sounds like you waited until all the evidence came in and then made a decision based on that evidence. Did the jury acquit in that case?
We did.
You acquitted.
She regrets letting him go.
And it sounds like you took your job pretty seriously. Is that fair?
We did.
Do you think you could do that in this case too?
Yes.
Could you wait until all the evidence comes in before you make a decision?
Oh, yes.
Okay. And could you make a decision based only on the evidence?
Yes.
Okay. Could I get a show of hands? Is there anybody that's going to have trouble with that? Waiting until all the evidence comes in first before making a decision? And then making a decision based only on that evidence? Yes, sir.
The more and more I think about it, the more unsettled I get that Mr. Milton is not adequately represented. And therefore, through the course of this trial, won't take advantage of the best opportunity there is to defend himself. Going at it alone, I'm thinking,
yeah,
that's what's bugging me.
Mm-hmm. I hear you, sir.
Mr. Sharp, I'll address that.
Thank you, Your Honor.
All right, so folks, as I said at the beginning, because that's a natural concern that's being expressed, and we wanted to make clear that somebody in Mr. Milton's position has the constitutional right to represent themselves. Before they do that, however, it's my obligation as the judge to have a good conversation with Mr. Milton about that, what I think the advantages are and what the disadvantages are of that, doing that. And Mr. Milton and I have actually had 2 conversations about that. And he's asked very thoughtful questions, and we've gone over it. And my conclusion at the end of our 2 conversations is that he's making this request, understanding exactly what the ramifications are, and that he is doing so voluntarily. He understands that I would appoint counsel to represent him. I told him that again today, at the start of the trial, that even though it's late in this process, I would be more than willing to appoint counsel to represent him. And he says, no, he would like to proceed representing himself. And we've had a good conversation about that. So to the extent that that would put you at ease, fine, but I understand the qualms you feel, because that's why I felt compelled to let all of you know that, because I would feel the exact same thing if I were sitting where you were. All right. Thank you. Any other questions, Mr. Sharp?
If I could just briefly follow up on that. So Juror 15, thank you for sharing that. This is a very serious thing. And after what the judge just had to say, I wonder, do you still feel the same way? Would you be unable to be unbiased in this case because of those feelings?
I guess he's talking, but we can't hear him.
Okay, I appreciate the honesty, sir. Thank you. No further questions, Your Honor. Thank you.
Thank you. And Mr. Milton, do you have any questions for the jurors?
Do I have any questions for you all? I suppose I'd like to take this opportunity to build rapport, but let's not waste each other's time, right? So, do I have any questions for you all? No, am I allowed to only ask questions?
Yeah, right now it's just questions of the jurors.
Fantastic. No, I'll pass, Your Honor.
Okay, thank you, Mr. Milton.
I'll pass. Clearly, this is a jury of my peers.
All right, Mr.
No
Milton
questions.
and Mr. Sharp, if you both approach. Okay.
Yeah, I've just been thinking about this and everything, and I want to make sure I don't personally don't think this would be an issue for me. But my brother back in I don't know quite how long, he was captain of the Lacey Police Force. They're a Lacey officer here. So I went to some of the meetings, I met the officer and everything. I don't think it's going to be an issue for me, but I wanted everyone to know that if they.
His brother was captain
Thank you
of
very
the
much
police
for
force.
pointing that out. Appreciate it.
I pass the jury. He passes. Why would I have questions? We don't want to waste anyone's time. We could build rapport, but no. We'll cut straight to the chase. So this concludes basically jury selection. We're waiting. Trial starts today. Now those that have showed up saying, "Hey, where's the Microsoft trial?" It got pushed. It got pushed till September. That happened yesterday. So we were expecting it, and then it got pushed out. Unfortunately, those things happen with court. Unfortunately, everything is happening in September. Sarah Boone, Brian Koberger, everything is going on in September. The Microsoft trial. So it's going to be crazy if they all happen then. But yes, I watched this previously.
When you're ready, you can.
This happened yesterday.
And Mr. Milton, come on, right over here.
Mr. Milton there in his shorts. I think they're camo shorts. With amazing flowing curly hair. So judge is talking to them very briefly about this. The jurors that are not selected will be excused. First, they're talking about right now about strikes, either for cause or just one of the 3 strikes they're allowed to have. The remaining jurors, after they finish all the strikes, the remaining jurors, the first 7 or the lowest 7 numbers that remain will be serving on the jury. So I know 19 had questions and 13 had a boyfriend playing for the Red Sox, and the guy on the back, a couple guys in the back. The guys on the back have the least chance of serving. It's the front row. Juror number 3 had a couple issues. Juror number 5 had a couple things that came up that she wanted to talk about. So those are probably the concerns. And if there's going to be a strike, we'll see it in those numbers. Let's see what the judge does here. See if there's any excused for cause or stricken. This jury selection, Chrissy, is for the criminal case that the defendant, who's pro se, represented himself, also a sovereign citizen, is charged with criminal trespass, first degree, at 7-Eleven. I believe he was drunk at the time, but there was no charge related to the public drunkenness. Judge is about to talk to everybody. That was Judge Stephanie Boyd we were watching yesterday, Miss Murder. Fabulous fashion sense, great sense of humor, a great way of handling defendants of all varieties.
This will be fairly straightforward. Our jury will be comprised of jurors 1 through 7, juror number 7 being our alternate juror, but we'll sit through the process of the trial. The rest of you are excused, and before you go flying out the door, I want to thank all of you for coming in on such a beautiful day. I'm guessing that there might be other things that you had in mind doing today, whether it was work or otherwise. But I really do appreciate your response to the juror summons, and hopefully this small window has given you a chance to understand how important it is to us that members of our community serve as fact finders in adjudicative proceedings like this. It's very important, and we really appreciate your commitment of time and effort to get here today. So jurors 8 through 19 are excused. We were just checking and have confirmed that you have no further callback obligation. So thank you once again, and I hope the Mariners beat the Red Sox.
Her boyfriend's Red Sox. So 1 through 7 are going to serve. That's 3 men and 3 women with 1 man as an alternate. They're in the back. It's the alternate. The rest of you out of here. The jury's going to move off camera for a little bit of instruction, and then the case is going to move forward. We're watching this not because it's a criminal trespass, but because it's a Sov Cit pro se. And it's going to be live today. So it's going to be great. So this was yesterday's events. The jury got selected yesterday. They're going to be showing up here in an hour or so.
For the folks selected for our jury, Teresa's going to bring you up here to these seats over here, and we'll have you sit in what is referred to as the jury box here in this courtroom. So if you will follow her.
The court's not really concerned. We do have a couple shorts wearers there. The court's not really concerned with showing the people. They've actually introduced themselves on camera. So this isn't like a murder trial. There's not a great deal riding on this one.
Sure. Yeah. Mr. Milton, Officer Evers, you can swing your chairs around to the other side.
Those they're like camo pants.
All right, folks, I'm going to spend a few minutes letting you know what's going to happen through the rest of this process, to including swearing you in to try the case as jurors, and then we'll be excused for the remainder of the day and have you come back tomorrow morning. So first, juror number 7, you heard already that you will be the alternate juror. Because it's a 2-day process, in case somebody gets sick overnight and can't show up, we need 6 jurors to try a case. So since we are running a 2-day process, we keep an alternate juror. You'll sit through the entire trial, and if when the jury has finally heard closing arguments and retires to deliberate, if all 6 of your colleagues are here, you will then be excused. You can stay in the courtroom to wait for their verdict, or you can depart. It will be totally up to you. All right, folks, if you would all 7 of you stand and raise your right hand for me.
It starts in an hour and a half. We might have time for a police
Do
chase
each of you solemnly swear to well and truly try the case and declare a true verdict according to the evidence and to the instructions of the court? Please be seated.
Paul Mack, thank you so much for finding that. Judge Brett Buckley is this judge's name.
So we have standard instructions on the law, which explains why I'm reading them off a document here. And I will continue the instructions that we heard earlier, and these now apply to the jurors who have been selected for our jury. I will explain now the procedure to be followed during trial. First, the city's attorney, Mr. Sharp, may make an opening statement outlining the testimony of witnesses or other evidence that he expects to be presented during trial. Mr. Milton may then make an opening statement, or he may choose to make an opening statement at a later time. Next, Mr. Sharp will present the testimony of witnesses or other evidence to you. When he is finished, Mr. Milton may, but need not, present the testimony of witnesses or other evidence. Each witness who testifies may be cross-examined by the other side. When all of the evidence has been presented to you, I will instruct you on what law applies to this case. I will read those instructions to you, much as I'm reading these instructions. You will have copies, written copies of those instructions for your use in the jury room during your deliberations. After I finish instructing you on the law, Mr. Sharp and Mr. Milton will each have an opportunity to make a closing argument to you. Finally, you will be taken to the jury room where you will select one of you to act as presiding juror. The presiding juror will preside over your discussions of the case. Those discussions are called deliberations. Until you are in the jury room for these deliberations, you must not discuss the case with other jurors or with anyone else, or remain within hearing of anyone discussing it. It is your duty as a jury to decide the facts in this case based upon the evidence presented during trial. Evidence includes testimony of witnesses, documents, and physical objects. It also is your duty to accept the law from these instructions, regardless of what you personally believe the law is or what you think it ought to be. You are to apply the law from these instructions to the facts, and in this way, decide the case. The only evidence that you are to consider consists of the testimony of witnesses and any exhibits admitted into evidence. When witnesses testify, please listen very carefully. You will need to remember testimony during deliberations because testimony will rarely, if ever, be repeated for you. Any exhibit admitted into evidence will go to the jury room with you for your use during deliberations. Mr. Sharp's remarks and Mr. Milton's remarks, while Mr. Milton is acting as his own attorney, are intended to help you understand the evidence and to apply the law. However, in that context, neither one of their comments are the evidence or the law. You must disregard anything they say that is at odds with the evidence or with the law as stated in my instructions to you. You may hear objections made by each side during trial. Each side has the right to object to questions asked by another and may have a duty to do so. These objections should not influence you. Do not make any assumption or draw any conclusion based on those objections.
I'm about to close the poll.
One of my duties as judge is to decide whether or not evidence should be admitted during trial. Do not be concerned about the reasons for my rulings. You must not consider or discuss any evidence that I do not admit or that I tell you to disregard. Our state constitution prohibits a trial judge from making a comment on the evidence. Because it is your role to evaluate the evidence, it would be improper for me to express, by words or conduct, my personal opinion about the value of a particular witness's testimony or an exhibit. I will not intentionally do this. If it appears to you that I have indicated in any way my personal opinion concerning evidence, you must disregard this entirely. You will be allowed to take notes during trial.
Oh, they get
And we
notes.
will provide you with notepads and pens for that purpose. Whether or not you choose to do so is entirely your own decision. If you choose to take notes, you should make sure that it does not interfere with your ability to listen to and to observe the witnesses. You must not discuss your notes with anyone or show your notes to anyone until you begin deliberations on your verdict. This includes fellow jurors. During deliberations, you may discuss your notes with other jurors, and you may show them your notes if you wish. You are not to assume that your notes are necessarily more accurate than your memory. You are also not to assume that your notes are more accurate than the memories or notes of other jurors. Throughout trial, you must come and go directly from the jury room. Do not remain in the hallway or in this courtroom, as witnesses and parties may not recognize you as a juror, and you may accidentally overhear some discussion about the case. It is essential to a fair trial that everything you learn about this case comes to you in this courtroom and only in this courtroom. You must not allow yourself to be exposed to any outside information about this case. Do not permit anyone to discuss or comment about it in your presence. You must keep your mind free of extraneous influences so that your decision will be based entirely on the evidence presented during trial and on the instructions to you about the law. Until you're dismissed at the end of trial, you must avoid outside sources such as newspapers, magazines, radio, television, or any other electronic media on the subject of the trial. During trial, do not try to determine on your own what the law is. Do not seek out any evidence on your own. Do not consult any reference materials. Do not inspect the scene of any event involved in the case. And the law hasn't caught up with reality in this regard because there's no paragraph here for me to talk to you about what is really a significant issue for jurors, and that is you're not to go home and Google Mr. Sharp or Google Mr. Milton. Or
check
Google,
YouTube.
Or Google Officer Evans or Evers. You're not to do any research regarding this case. And you're also not to solicit input regarding this case. So, for example, you're welcome to tell people you've been selected for a jury, that you spent Monday here and got selected. and you're coming back for trial tomorrow, but that should be the end of the comments. There shouldn't be anything more about either the nature of the charge or the fact that Mr. Milton is representing himself. Those things are going to solicit comments, and you're going to get some input, and it's going to be tough for you to ignore that because it's coming to your computer. So it's very important that you don't engage in that activity in any sort of social media context while the trial is ongoing. So I will direct you not to do so. When the trial is over, you will then be released from that instruction, and then you can post any comments you want about anybody in the proceeding, me, the parties, whatever, and solicit whatever input you want, but not until the trial is over may you do that. Finally, I will indicate to you that as members of the jury, you will have the opportunity during the trial proceedings tomorrow to propose questions for any witness who testifies. And the way that process will work is as follows. When we conclude the testimony of any witness, I will then ask you whether you have any questions for that witness. And if you do, you must write those questions down on the notepad that we give you. And Teresa will gather them up. We'll send the 6 of you at that point out into the deliberation room, and I will discuss the proposed questions with Mr. Milton and Mr. Sharp, and then I will decide which of those jury questions may be asked. And the way I'll decide that is by applying the rules of evidence to those questions. Those questions that comport with the rules of evidence will be asked. Those that don't, won't. You'll then be brought back in here, and I will ask the witness the questions that may be asked. And then I will give Mr. Sharp and Mr. Milton a chance to ask any follow-up questions based on that. I will not give the jury a chance to propose any follow-up questions. So when we conclude the testimony of the witness and I see, and if somebody has a question, then make sure it's in writing. I'm not going to give you a chance to sit there and go through your notes to figure out what your question is or whether you indeed have a question. My hope is that you will have the question already prepared. And the way that typically would work is that when a question occurs to you during testimony, just go ahead and write it down. If at the end of testimony you've either received an answer or you no longer need an answer to that question, fine. But if you want an answer to that question, then you already have it prepared, because we're trying not to interrupt the normal flow of a trial. Also, you should not propose a question trying to act as an advocate on behalf of one party or the other. You should merely propose a question as a fact finder in this case. And you should feel under no compulsion to propose questions. This is merely an opportunity for you if you wish to do so. All right, folks, we will now adjourn. We'll come back to this space tomorrow morning. We will have the witnesses ready to go at 9 o'clock. Teresa will be keeping you in the deliberation room until we have everybody in the courtroom and ready to go. And you'll then be brought back in here at 9 or just shortly thereafter. And the first thing that will happen tomorrow morning is you will hear an opening statement from Mr. Sharp. And after Mr. Sharp finishes his opening statement, Mr. Milton will let me know at that point whether he wishes to do an opening statement at that time or he wishes to wait until Mr. Sharp has presented all his testimony. But we'll start with that opening statement. We'll then have presentation of witnesses. Once we've reached the point in the trial where there are no further witnesses, at that point, I'll excuse you. I'll discuss what the instructions on the law are going to be with Mr. Milton and Mr. Sharp. And we'll bring you back in here. I will instruct you on the law that you're to apply in deciding the case. And then you will then hear closing arguments from Mr. Sharp and Mr. Milton. And then you'll retire to deliberate on your verdict. So this is all going to be done map today for how tomorrow will go. So once again, thank you very much for your time. We will see everybody tomorrow morning at 9, and you'll be checking in hopefully a few minutes before that with Teresa, who will get you situated in the deliberation. Thanks, folks. Have a great evening.
Yeah, Law Talk with Mike has followed this one. Squishy Gardner has followed this one. It's a great little case. Both great channels, by the way. Love them. We're going to be watching it live. So what we just finished right there was yesterday's proceedings. So this morning in Washington, all the way out on the Pacific Coast, so they're a couple hours behind us. When it's noon on the East Coast, it's 9:00 a.m. in Washington. So we've got about
questions from the city of Lacey.
Hang on, turn that off. That's replaying the same thing. Oh wait, hang on.
Morning.
It's a little bit more. Hang on.
Okay. Available all day. Mr. Milton, any questions?
Negative.
Okay. You feel like you have a handle on how it will go?
For the most part, yeah.
Okay. I mean, if you have a question, now's a good time without the jury here.
I feel like if I'm not actually guilty of breaking the law knowingly, like it states in the RCW or as your municipal code should state, or maybe I didn't look that up in the time appropriated or was aware of it, and I'll find out.
Okay.
He's going to find out, all right.
You have in the packet of instructions that Mr. Sharp provided you, there is a definition of what it means to knowingly know something. So you may want to read that so you understand. So you have that available to you.
I more or less understand the words of art in the law.
Okay.
So.
All right. See you tomorrow morning at 9. See you tomorrow morning at 9.
Okay.
Thank you both.
Okay, so now he's gone.
Mexico City. With inflation.
Oh, now we get the next video, what everyone is playing right here. Why? I'm watching Boston Public Radio now suddenly. All right, so here's where we are. The jury's been selected yesterday. They're going to be in court in about an hour and 10 minutes, so they're probably going to be there a little soon. They'll probably be there in at least about an hour. The judge is not allowed to give advice, says Ann. Yes, but he does. He already has. He told Mr. Milton, I can't help you. You're on your own. You're your own lawyer. I can't step in and tell you what to do. But then he goes ahead and steps in and gives him a lot of help already. So we'll see if that continues as we progress in the trial. We're going to close out the poll here. I was going to before. The question in the poll was, can you be a fair juror in a Sov Cit case? Yes, said 57%. No was 17%, and no, but please let me anyway was 25%. So it looks like about 57 plus 25, yeah, about 82 roughly percent of us would, or 72, sorry, higher math, somewhere in the 70s to 80s range, would want to serve on a jury, or at least say we could. All right, we have a little bit of time, and as I said this morning, we had a FOIA request that I submitted to actually Utah Department of Public Safety. It just came in this morning. They responded. They gave me everything I asked for, which is wonderful. Usually they respond and say, you forgot to dot an I or something, so we're not going to give you anything. This time it came in. We got the entire video with the police audio, and this is video from a helicopter of a police chase. As we wait for Washington to wake up, because it's still early morning there, I thought we could share the police chase today with you guys, and then we'll just have a little bit of time to get ready for Washington for the live court, and we'll follow that live as that proceeds on the judge's YouTube channel. Is that okay for everybody? Are you guys all right with that if we interject a police chase in here this morning? Let's see. Let me pull it up here. I haven't seen any objections, and even if you did, I'm not sure if I would. Let's see. There we go. Hold tight just 1 second. Pause. That was a heck yeah. Okay, about the raccoon. Let me give you the raccoon update. First of all, we called the non-emergency number to talk to our law enforcement here in town, and they said, unless it bit you, we're not going to do anything about it. But we suggest you kill it. And I'm in a town where that is feasible. Raccoons are invasive species. They're actually illegal to trap and release somewhere else. I could be charged if I were to catch it and let it go again. I can never be in possession of it, because if I'm in possession legally, I'm required to have it killed. So I I looked at it, maybe even through the crosshairs of a pellet device, and decided that I did not want to cause it any harm. And so I looked for some scrap metal, some scrap wood, and set up a ramp where it could come down off the roof onto a little trellis and climb down and get away. And then I tried the hose, tried spraying it. It does look, I would say it does look not well. It looks not well. It has no fear of humans. I chased it with water. It came towards me. Anyway, so I set it up and let it down, let it climb down. And it found the way down fairly quickly and climbed down the trellis. And then I tried to scare it away by banging a rake on the ground on the brick thing just to make some noise. And it did run from me at that time. And I asked the kids to keep an eye where it went, and it ran, and then it came back, right back. And it's apparently guarding our house on the outside. It is wandering around in the daytime, does not seem dissuaded by anything. I've usually raccoons have scattered. This one looks different. That's all I'll say. It's likely rabid. Something's I would say it's much too small to be a mama. I did look at it very carefully, and it did not appear to be a female looking for food for its litter. But that's where it is. So it's outside, probably feasting on something out of our garbage, which is where it keeps trying to go back to. And so we're going to let it do its thing and maybe go away. So it's a play inside day today. Carrie says, "You are now its dad." I did nothing to treat it nicely, but I did not hurt it at all. Animal control, we called them. They will not do anything unless it bites us. That's just how it goes in a small town. Anyway, so we're gonna stay inside and hopefully it goes away. Otherwise, we'll have to take action at that point. I wouldn't want to do that, but we do have that opportunity. Or I say opportunity meaning legally it is a permissible route to go. And if it's sick and it's going to hurt somebody or something, then it might need to be put down. Anyway, so that's where it is. The raccoon, as I know it right now, is feasting off some garbage in our garbage can and is still alive. That's where we'll leave it. That being said, we have a police chase. We want to bring. Oops, let me go back over here. This FOIA request came in this morning. Just this morning, it was just barely showed up, and I had to convert it from a really nasty format of a TS video. Never seen a video in TS format, so I had to break out VLC and convert it to an MPEG-4, which plays nicer on my equipment. My garbage is tasty, apparently. It's all that ice cream that I've been throwing away. Your animal control is whack. No, it's just when your town has like less than 5,000 people in it, there's no money for anything. Zero money. What money did they do have to waste on other things like expensive trucks for our Parks and Rec people to drive around all day, every day, even though the town is tiny. Anyway, so we're going to do this. Let me bring in this right here. This is, let me set the preface. This was a police chase. Originally, I think they started in Arizona. So it's down in the, I think it's near St. George in Utah, which is the very bottom, the south part of St. George. If you're driving from Salt Lake to Las Vegas, you would drive on this road. This, I believe, is I-15. Probably, I think, in the hurricane area. The police copter footage that I requested was any video footage starting with when they located the vehicle. And this is the moment they located the vehicle, and we proceed all the way through an arrest because it does end in an arrest. So that's the preface. And any other questions before we get started? Because I don't want to interrupt this. Please give me the same instructions concerning my mother-in-law. Oh my goodness. Okay, so here we go. Let's go ahead and fire this one off, and we'll hear the full chase as heard from the police helicopter. Come on, give me sound, give me sound. That's not funny. That just means I have to play it using VLC. Okay, so hold tight. We're going to switch back over to that in just a second. It doesn't want to play the sound for you guys, which I think is part of the video that you should hear. So let's open VLC.
Kind of go slow here. Is that them?
Is that him now in the number 3 lane?
Down 4. 310, you on the there?
Yeah, so he is
Going down the hill.
I got him.
You got eyes on him?
Yeah, gonna be coming.
Coordinate a cold spike with Star 9.
Star 9 is the helicopter.
Looks like
that has eyes
he's
on it.
gonna stay not taking this exit, and he'll keep on going.
Star 9, 310, I'm at 19. There's a Starlit guardrail going down the hill.
He's taking the exit.
Copy. He's taking the Hurricane exit. Off ramp into Hurricane on 9.
Copy, county. Control, you want to let them know?
Look at all the data. Look at all the data they have on their screen here. This is a FLIR camera. You can see the angle, like over here on the left-hand side of the screen.
He's eastbound on 9 in the number 1 lane.
You can see the direction the camera's facing is mounted on the helicopter. You've got your GPS positions in the bottom left. The altitude, 4,700 feet.
Just passing mile marker 1 coming up on the intersection, setting up to turn south on, I believe that's Telegraph Street. He's now southbound on Telegraph Street.
I got spike set up. I just can't tell which car it is.
10-4 block GMP Acadia.
He's just coming into the construction zone there on Telegraph in the center turn lane.
Copy, confirming he went south then.
Hey firm, he's southbound on Telegraph Street.
Copy, I don't have him then.
Just passing Corral C, still southbound Telegraph Street.
Try to take the top end off from the helicopter noise.
Star 9 to 260, or 260 Star 9. I'm just behind him quite a ways, just 1040 is following.
Yeah, 10-4, stay off him quite a ways. We got good eyes on him here. If you guys can set something up in front. He's still southbound on Telegraph Street, passing Coral Canyon, heading up the hill right now. Coming up on Highland Trail, and passing through Highland Trail, still southbound on Telegraph Street.
This guy's moving too. This happened on June 23rd, by the way. It's a little delayed, but it takes a while to get a Freedom of Information Request Act process.
Subject's still moving faster than the flow of traffic, but he seems to be fairly controlled, fairly safe right now. Still southbound Telegraph Street.
This area of the state is deserty, very hot.
All city units with normal traffic switch to off flight, and all city units with normal traffic switch to off flight.
That was all the other units with regular stuff.
Washington
Goes to a different
Parkway.
channel.
I'll let you know what he does. There's a red light there. Looks like he's running the red light straight through, still southbound Telegraph Street.
Control 260, I've discontinued following. I'm going to set up at 15, about 15 and a half northbound for spikes.
Spikes.
10, you still set up at 19? Affirm. Yeah, if you just hold the line on that, here's the last one up north of Spikes at this point. Copy.
Still southbound Telegraph Street, approaching Village Way and 300 east.
Whoa.
Running the red light
There's a green light.
at 300 east, still southbound Telegraph Street.
I don't know where the police are on this one. They're nowhere
Southbound
behind.
Telegraph Street. I don't know if we've got anybody set up to watch the exits back onto the freeway. Right there.
Echo 7, I'm Green Springs and Telegraph.
It's a lot of cars.
Coming up on Green Springs Telegraph now.
Yep, Charlie and Bravo, same traffic at Green Springs.
Alright, he's straight through the intersection at Green Springs, still southbound on Telegraph.
That was a red light too.
Echo 1 to Echo 7.
They they're trying to use the tracking feature.
And he's blowing red lights, just about T-boned somebody in this intersection.
This camera has the ability to lock onto an object right there and just keep going. They need to leave it just like this. Okay, this is the amazing thing about this camera. This FLIR camera can do this.
Chopper, track him.
But instead they insist on switching to manual mode later on the chase.
Yeah, we'll stay on him up here. I'll call it out if you guys know the area better, if there's anywhere you can cold spike, things like that. Traffic is pretty heavy on Telegraph.
One, who do we have with spikes? We have spikes at 15, 19, and the on-ramp from SR9 to go northbound. He's moving towards southbound I-15, so if we can have somebody down there.
He's turning, correction, just straight through Mall Drive to go under the overpass. He's still on Telegraph, southbound.
Hey, units, the stationary spikes are no longer there. So I'm asking 101, do you have spikes? Yeah, 101 Charlie still has them down by exit 2.
That's him passing that red truck now, isn't it?
Yep.
Okay.
Camera operator's new on this one.
101, truck 1, that's 25 right down there at the wash on the 15. Sorry, 10-9 where? Just south of 2, right there at that wash where the bridge choke point.
They lost him.
Alright, coming up on River Road and turning westbound on River Road.
St. George Boulevard.
And St. George Boulevard.
Chuckarama.
Looks like he's flipping a Yui there.
Chevron.
Turning back around. Setting up to go southbound again on River Road.
Seriously, don't they have like a missile button they could just end this right here?
1X39, truck 1, do any of you guys have spikes?
Oh, he just pulled into the gas station.
Yeah, 10-4, we're all heading that way.
Didn't he?
Alright, he just pulled into the gas station there, right there on the corner of St. George Boulevard and River Road. He's at the very north pump, pulled up to the pump.
6 Charlie and Bravo, coming down that.
Someone's running in.
Passenger got out and ran into the store. You want me to stay with the driver? Car's on the move again.
She ran back out.
Yeah, stay with the driver. 1 male driver wearing sunglasses, approximately 40 years old. Control 2 Echo 7. We're tailing the driver. He's just coming up 100 south. No story. Do we know where it is or what it is? Gauge is going to be the Chevron. He's west on 100 south.
Star 9's got the vehicle. He's just going under the freeway, still westbound.
That's him just turned left, isn't it?
Yep. He just turned southbound on 100 east. He's southbound on 100 east.
Is anybody going for her? 2 Echo 8 just headed to the gas station for her. Hey, Gage, they said female jump back in the car. She's with him. Copy.
He's just making the turn on the 400 south. He's now westbound on 400 south. And southbound on 400 south. Correction, 900 east.
It's a nice baseball diamond.
900 east.
Ooh, it was a tight fit.
He is turning southbound on 700 east. Southbound on 700 east. Approaching 700 south, setting up to go westbound on 700 east. Correction, 700 south from 700 east.
So the numbers seem confusing, but a lot of Utah cities use a grid system where they have Center Street and Main Street, or the crossroads, and then as they go out from that, they count up north, south, east, and west.
Just below exit 2. Set up.
He is still westbound on 700 south, just passing the tennis courts at the high school there.
Don't lose him. Oh, man. They locked on the road.
He's turning south on Main Street. He is now southbound on Main Street from 700 south.
It's very hard to outrun a helicopter, especially whatever car he's in.
1070 south, still on Main Street, southbound, just heading into this wide sweeping curve here.
Hey, it's McDonald's. Maybe he'll get in line and order something.
He's straight through over Bluff Street, continuing straight onto Black Ridge Drive, westbound. He's turning into the Maverick there.
Maverick's a gas station chain.
There, I'll try to get a nice orbit here for you.
We might roll here.
We rolled.
He pulled into the pumps, and the center pumps lost visual for a sec as we flew over, trying to reacquire.
Just to confirm, it's the Bluff Street Maverick, not the one on Indian Hills.
Yes.
Hey, firm.
Bluff and Boulevard. I'm heading down that way.
I think that's him right there. The last car on the right.
10 Bravo, south of Bluff. I'm going to, south of Main on Bluff, I'm going to try to flip around. Control Alpha is 23 as well.
I think he's just at the pump there, but
I think so.
I kind of lost him.
Control 30 Alpha 509, we're out at the Bluff Maverick with the St. George unit.
There's the thermal. We just switched to heat. Calibrating. Calibrating it back. Okay.
1 Charlie on Bluff Street Maverick, looks like the GMC is still here. Female ran the door going back to the car.
There's the one running back to the car. That's probably him.
Detain her. She is a suspect just as well.
Detain her. Nope, they're in. The cops are behind them right there.
There he goes again.
Back to full color.
It's going to be back on Black Ridge, westbound. We're both in the vehicle.
They've now refueled and they're ready to continue.
We're gonna roll again, possibly.
Suspect did almost ram a police vehicle.
You still got it?
Are we still now pursuing?
I see it.
Yep.
Rolling has to do when the camera can't rotate any further and has to flip around back the other direction.
Yeah, he's southbound on Black Ridge.
He's moving too.
He's taking westbound on Hilton Drive. Westbound on Hilton Drive.
Yeah, station clerk is saying the female got back in the vehicle.
He's coming up on Dixie Drive, setting up to go westbound on Dixie Drive.
7 Bravo, Clark Drive in Valley View. Yeah, what are we doing, Brunton? Units just hold back. He's got to be running out of fuel.
No, he just filled up.
Still gotta...
He just filled up.
Just passing Mesa Palms Drive.
More spikes, maybe on the boulevard. He might circle back that way.
Kind of stuck in traffic right there at the back.
Yeah.
101 Bravo. We'll stay around the boulevard.
Just doesn't really seem to be trying to work through it.
101, just let me know where you set up on the boulevard still.
Just passing 1600 south, still on Dixie Drive, headed northbound.
Okay, let's stand clear right now.
Correct.
Star 9, if you're comfortable coordinating a cold spike spot ahead of where they're headed at least, let's try to do that.
Yeah, 10-4, if I see something that stands out, traffic isn't as bad on Dixie Drive, but if anybody knows a good spot there, he's coming up on West Canyon View Drive, still on Dixie Drive, headed north.
Yeah, if he goes west, that spot's going to be the bridge on Sunset.
Yep, it looks like he's turning left.
Yeah, he's setting up to turn west on Canyon View Drive. He is westbound on Canyon View Drive.
Alright, let's set up containment. He's got limited exit points there. 7 Bravo's behind him. I'm not pursuing. I'll just continue to follow. You got some marked close by too, if you need them.
Yeah, he's still on Canyon View Drive, just coming up to Village Road. Looks like he's going past Village Road. Correction, is he turning into... Where did he go?
He went straight.
Did he?
Yeah, he kept going, so he's coming up on this, it's only going to be a left-hand turn or the dirt.
Alright, yeah, he's coming around Canyon View onto Plantation Drive, right there where all that dirt is. He's on Plantation Drive, headed south.
I forgot to tell you guys, the original want on this was theft. And if you had like one guess from what store they stole from, what would that be?
Yep, he's just coming around the curve on Plantation Drive, still southbound, headed right towards 1790 Street.
Oh, he's moving. There's a hard turn.
And he is taking the dirt road.
Oh!
He's good.
That was not on the dirt road.
Units to Curly Hollow.
He just 1050.
All right, they're exiting the vehicle. I've got one in blue. Driver is in blue. And female exited as well.
See if I get you the other side of that tree.
Got one officer on scene giving commands.
Here's the FLIR.
2 units closest. Stepped up. 30 air 2 Echo 7 and out.
White is hot in this picture. White is hot.
Appears that subjects are being compliant. One officer on scene. If we could get other officers there. Female sitting down. Male is squatted down.
T2 trucks were to lead us in from where we are.
It was Walmart in Arizona. They stole from Walmart. This is a blend of thermal and color imagery.
To the end of Plantation Drive, dirt road, hang a left, and he's just right there.
Hey, he's not complying with me. I've got him at taser point. He's saying he's given up.
Give a smooch to the girlfriend at risk of being tased.
Yep, that's good. End of Plantation, hang left.
Hughes, we're 1 minute out. Just wait. Control 38 Alpha 509. We're going to be out with St. George again here in about 10 seconds.
Copy, 1 Mountain Page, 57.
You see that?
Floyd, raise down, 2 detained.
2 detained.
That white is a cigarette. They were both smoking. And the helicopter can see the heat from overhead from the cigarette. It's extremely high-resolution thermal imagery.
Anytime, unless you need us to stay above, we'll head back to the airport.
Do you happen to see anything get ditched or anything we should maybe look around for? Or not really.
No, negative, unless they did it right there close to the vehicle. What did they have in their hands? It looked pretty hot on the FLIR.
They're smoking.
Copy that. Yeah, I didn't see anything other than that.
This is why you don't just throw your cigarette on the ground.
Camera works. That's pretty awesome.
Yeah, it is. All right, that's our chase that it took almost a month to get that FOIA request back from Utah. High resolution FLIR. FLIR is forward looking infrared. It can see heat, and the camera has a regular camera, like a zoom color lens that we were watching for most of the chase, and it also has this other lens, and it can blur the two images on top of each other, layer them, and so you can see the heat. This is the technology the cops can use. And imagine if this was a nighttime chase. There is no hiding. There's no hiding. You can see cars that are hot, the engines that have been running, the tires are hot. If a cigarette from several, 1,000 feet up shows up like that on this camera, imagine trying to hide you from the police. So they were busted. Let's see, just a little background on this one. This was, it was June 23rd. St. George police were notified that a black GMC Arcadia had fled from the police in Mesquite, Arizona, after they stole multiple items from Walmart. They found him on I-15 going about 100 miles an hour. The helicopter the police helicopter engaged and chased for the whole time. And UHP, the Utah Highway Patrol, made the stop and the arrest. Let's see, the passenger was 38 years old. The driver was 40-year-old Pedro Antonio Vargas. He got his Miranda rights, and he admitted to the police that he stole. So he's pled guilty on that one. They did attempt to pay for gas at 2 gas stations, but jumped back in the car when the police arrived. So they were running low, but didn't have any time to fill up. And they had existing warrants as well. Let's see. Both were booked into Washington County Jail for third-degree felony charges of failing to stop, misdemeanor charges of theft, possession of controlled substance, and Schedule 1, 2, and something else, analog, possession of marijuana, possession of drug paraphernalia. So there we go. That's our update for that. Now, as it stands, we are waiting to go back to court for the jury trial for the Sov Cit citizen. Technology is amazing, Carrie. I love it. I actually I played a little bit with that. At one point I was going to start a business doing thermal imagery, not just thermal imagery, but the near infrared imagery as well, which is just off the visual spectrum for identifying different types of plants from the air. Anyway, we could talk about that another day. But there's a fun technology that basically can identify even the species of corn growing in a field based on the color signature that it gives off in the near infrared fields. Let's see. Do you think spicy maple bourbon pickles would be good on BLT? I think spicy maple bourbon pickles are good on everything. So you might be asking the wrong guy. Speaking of Walmart, what happened to Cynthia and her husband? Cynthia and James, who stole from Walmart and are facing trial in Cedric. I was going to say Prince for some reason. In Judge Cedric's court. That happens tomorrow. That'll be on early tomorrow morning. That's what we're going to start with. All right. Let's see. Please check to make sure you see if you receive gifted membership from the channel is turned on. As it turns, YouTube have turned them off. Okay, so if you click this link and go to the gift settings on this page, make sure the setting is turned to the right. So the button slid to the right. That would be the active setting if you want to receive a gift on this channel. Thank you for the reminder. Did the trial start already? Jackie, the Microsoft trial got pushed to September, but we are going to be following another trial. This morning we followed the Sov Cit hearings and jury selection for, I can't even remember his name. It starts with an M. But there's a gentleman up in the city of Lacey, Washington, who's charged with criminal trespass first degree at a 7-Eleven. It's a gas station. He had previously been trespassed from the property and was back on the property. He was arrested there, and he wants to represent himself without an attorney. And he's also a sovereign citizen, so he's one of those people that believes that he has control over everything related to him, that no laws have any hold on him unless he wishes them to or grants them permission, that he sort of has his own belief about what his right is as far as travel and where he can be and how he can exist and pursue happiness in the way he likes. At the same time, he's exercising rights afforded to him by the Constitution to represent himself. So he's claiming some of the constitutional rights that he has and wants to exercise those, but he also wants to be not beholden to other rights. And so we're going to hear him as he tries to convince a jury, using only a police officer as a witness, that he is not guilty of trespass and that he should not be held guilty and that the jury should find him not guilty. This is going to be a fun little trial. It begins about noon, so we have half an hour. Do we want to take a half-hour lunch, or do we want to just work through it? It's your call. Honestly, if I take a lunch, all I'm going to do is go outside and look and see if the raccoon's still eating my garbage. But yes, actually something like Peyton, Andrew, Michael, Brian, Milton. But he also said he's not a person. He said that he's not a person. He's of the people. He's not a person or something like that. Let's see. Okay, so that's where we are. I'm gonna keep an eye on. Does he take the stand? Of course, he will take the stand. He will speak. He will sing like a canary, and most likely his own words will convict him, as they have led us to believe early on, where he said, "I didn't want to further commit any more offenses by going back to ask employees of 7-Eleven to testify in my defense because I already can't be there." He wanted Shaggy as a witness, but couldn't reach him. That I've heard that as well. I didn't watch that part, but it's bizarre. Stay, says Kimar. Kim, well, since you're in charge of the internet, we're going to go ahead and take that advice. We'll stay here and work through. We'll have an early day act anyway. I don't envision this part of the trial, the jury part of the trial. They have 7 members of the jury that they've picked out yesterday. We watched that this morning. Let me reset. How do I run to A? I was just too small. I couldn't see myself. So they have 7 members of the jury. We have 3 women and 3 men that will be deliberating, and an alternate is a man. I know 2 of the men are wearing shorts. Why is that important? Well, because the defendant was not wearing shorts when he appeared in court yesterday. So maybe there's some sort of kinship or bond they already feel with the defendant, but we'll see if that pays out. Nobody was struck from the jury at all, and the first 7 jurors were selected. See, I'm not a person or a camel. He's an agent representing Mr. Milton. He said that, but he's also, he gives in so easily. The judge says, well, I'm going to call you Mr. Milton. He's like, oh, that's good. That's all fine. That's fine. I'll answer to that. He's not sticking to his beliefs. He needs to, in every instance, maintain and assert his rights and privileges, or else he's going to lose them. Will he run back and forth from the stand to the defense table? Jenjen Pookie, that's a good question. The judge actually addressed that with him. He said, if you choose to testify in your own defense, you don't have to ask yourself questions, because that just gets awkward, honestly, to stand there and then run back and forth and pretend you're both people. That's crazy. He basically would allow him to sort of free spool and talk within reason, probably a little bit without that reason as well. The judge has been smiling through all this. He knows how it's going to end. It doesn't end well. Let's see, similar mindset of toddler or other teenagers. Let me see if I can. I've got a ton of messages on the burner phone, but I wanted to show a quick one here. Share to the laptop. Won't let me share to the laptop. Let's see if I can share this. I'll type just 1 second. Sent. Rebecca asked me that I play a little video here. If I can get it to play, I'm going to try. There it is. Okay, we're going to try to play this one again. Here we go. This is Buttercup, by the way. Trying to play with the chickens. It's a little bit blurry. That's the cleanest it comes through for some reason. I'm not sure why, Rebecca, but Buttercup is sort of like our channel mascot over there. I think he wants to play with the chickens a little rougher than the chickens want to play with Buttercup. But anyway, there we go. There we go. All right. So I showed it. Bite me. I showed him playing. Thank you very much. All right. Let's see. What will jurors get to decide a penalty phase 2? I don't think so. I think in Washington, in this case, it will be the judge that determines that. We'll have to look. Can you explain trespass laws? Because they're here in the UK, it means just being on someone's land without permission and wouldn't warrant a trial. Peter, yes. In this case, when I say someone was trespassed from a property, the property was a 7-Eleven. It was a convenience store, like a BP, right? It's a store that usually they'll sometimes sell gas, sometimes they'll just sell drinks and food and chips and something like that. So he's on the property previously, and the store owners or the managers at that point said, we don't want you on our property, not just now, but never again. And so they called the police, and the police said, hey, they don't want you here. We're going to trespass you from this property, meaning you can't come back. Even though it's open to the public, it's no longer open to you. And so you have to leave, and so they help him leave. But if he ever returns again after he's been trespassed, it would be a crime for him to be on the property. And so he did return again, and they called the police. And because he had been trespassed, that's when they had arrested him for criminal trespass. At the time, I believe he was drunk and being belligerent as well. And that's probably going to play into his defense, because he used the word when he said, according to the law, I have to knowingly be committing this crime, and I was too drunk to know that I was committing the crime. I think that's going to be his defense that we're going to hear. So that's going to be the trespass law. We do have, each state has sort of different laws when it comes to trespass. For example, some states, a lot of states, require you to have your property posted. If you don't want anyone to come on, you have to have signs at the corners and every so many feet, if it's a large property, that say like no trespassing. In North Carolina, the law is a little different here. The property owner has to have it flagged with purple paint. So they'll spray a little purple square on the trees near the edge of the property line, and then they'll register with the sheriff's office and say this property has been flagged as no trespassing. And if the police see anyone on there, even without the owner contacting them, the police can stop them, check to make sure they have the proper paperwork, signed permission to be on there. And if they don't have them, they can arrest them, even without the owner intervening. So the laws are a little different here. We don't know exactly how it works in Washington, but it sounds like he had previously been trespassed from the property and told to leave. Let's see. Can you tell your neighbor we need to borrow his dog? We need puppy time. He's not going to be here today. Tomorrow, maybe Zoe will be back. But I wouldn't want Zoe to take on that raccoon, because the raccoon's about twice the size of Zoe. Let's see. It's the light version of insanity plea. Okay, let me get the feed ready for court today. Let's see where we're at. Please take the grass off your face. It isn't you, Han, says Eva. You don't like the facial hair. It's probably going to be gone this week. Probably. Okay. That's not it. Okay. Okay, we're still waiting for notification on that. It's not live. This will be in the Thurston County District Court. Number 4 is what I believe it will be on. I took a short hiatus from true crime to cleanse the mental palate, watched Japanese bread making, didn't think I was gone for long, but I came back to RA with facial hair. It's really just about a week and a half, maybe 2 weeks is what it was. The thing is, I went camping, and I don't shave when I'm camping. Then I came back, and there was an incident where the razor was not fully charged, and usually I only shave it off like on the weekends, and so I skipped the weekend. It went another week, and it started to grow on me. In Louisiana, we were told that if you don't own the land you are trespassing, that there is no need for the signs, but the signs are a good idea. I veto the thought of you shaving your goatee. Mrs. R.A. has total right on this, and she might actually be in chat. So if she says it goes, it goes. Mrs. R.A. will create fake accounts and remind you to shave. The Mrs. R.A. is actually my wife. She created that account because of the confusion with Homeschool Ground Zero, and it was a long name, but that is actually her. It does make me look older and maybe a little bit wiser. Probably not. Shaving with camping, it's actually against the law, Ivan. Right? At least that's my belief. TMB says I could grow that in like an hour and a half. Man, this was almost 2 weeks, okay? Or maybe this is over 2 weeks. All right, we're anxiously waiting Thurston County District Court to go live. It might be about 20 minutes. We'll see what happens here. Okay. Have to keep refreshing here. All right. So other than that, we actually have to find a new trial to follow. So I'm open to suggestions right now. We were going to follow the Microsoft case, which was supposed to begin today. Yesterday, that got moved to September. Thank you, Judge. Nothing like pulling the rug out from under us at the last minute. So that trial got moved. We'll have to find something else in the meantime. We do have a small trial to follow tomorrow that'll take about an hour or two, and that's going to be the trial with our two favorite, our dynamic duo of criminals, Bonnie and Clyde. That's going to be James and Cynthia, that are in court for also theft from Walmart, and that's going to be a Judge Cedric Simpson's court. We're going to follow that tomorrow as well, and then we'll have to look for another trial. And it could be one that just started, but I'd like it to just be a clean murder. Can we not just have a plain old murder trial without all this kinky stuff? It was so fun having Mrs. R.A. man the controls earlier. Her giggles are the best. She does a good job. Are the gifts when they're a black outline? Debbie, if you're on the gift page or receive gifts on this channel page, make sure the button is moved to the right. So the button has to slide over to the right, and that's when it's a gift. Is this another Darrell Brooks? Very similar, Mary. If you watch the Darrell Brooks trial and the arguments he made, you're going to see a lot of the same things raised here. He hasn't talked about Admiralty Court. He hasn't talked about subject matter jurisdiction. He hasn't raised all those issues, but he's raised some of the same ones. Obviously, the one about his, he doesn't agree to be called the name that he's being called by, because the court on the documents when he's charged lists his name in all caps, and that's not his name. He doesn't spell his name with all caps, and that's just one of the little things that he's going to have a problem with. Let's see. Tag says, a week. Wow, you're lucky. I shaved my legs in the morning, and an hour later my legs looked like they were up solving crimes all night. A clean murder, yeah. I mean, it can be a whodunit, but I just don't want all this, and then, all the emails exchanged with torrid affairs and things. We can skip some of that stuff. Cynthia and James couples goals. Crusoe says, I have it enabled, but I'm not lucky. I think you've had a courthouse previously, right, Crusoe? I think if you got another one, it would be a different color. Yes, we're waiting for Mrs. Ari to chime in. If she has, I've missed. Oh, there it is. I like him clean shaven or scruffy. Define scruffy. Is scruffy like 6 weeks of beard growth, or just like 20 grit sandpaper? DMB was a difficult one because he was a horrible person. Today's sovereign citizen is just kickback, taking it easy, way different. Carrie, you're right. This guy's likable, even though he's making a stupid decision. Ultimately, the outcome in this case is probably not going to change his life, right? He may serve 30 days in jail. He may have a little bit of a fine or restitution he has to pay. But I don't think it's going to be, life-changing, the outcome of the trial. Either way, I think he should have a lawyer. Let's see. You've been gifted, I think it's I was gifted before, I think twice, and I gifted it back to, or I bought it myself, both, I can't remember. So you've had about 3 months in. So you're almost probably due for another courthouse color change. Kim Newton, thank you for gifting a membership. That one went to Heather Davis. Congratulations, Heather. This could develop into a domestic. Nope, I will give in. Okay. Sorry if I'm a bit sidetracked, but I want to just make sure we don't miss anything from this court. Pretty sure it's going to be court number 4. Let me just double check. Let me check the other courts. Court 3. No. Court 1. Not there either. Court 2. Court 2 has a lot more stuff in it, but nothing live. Pretty sure we're in Court 4 still.
Are we going to address subject matter jurisdiction?
Probably should. If subject matter jurisdiction comes up in this one, we will address it, Last Poet. Because that's a legitimate question. What time is court due to begin? Kimmy, it's supposed to start at noon, so we have 14 minutes, but I was just hoping that the live stream would start a little earlier. Yeah, he's a likable defendant. And part of it is that he's not trying to just be obstinate. I mean, he's got his opinions, and between me and you, I think they're wrong. But he's not trying to shove it down everyone's throat, and he's just playing the game according to how he wants to play it, and he's probably going to lose. As Debbie says, I will turn myself in. You can cover my trial. Murdered a spider yesterday. I'm a serial killer. Flies. We've had to have the kids kill all the flies because we had the doors open to let the air blow through, and the bugs wanted to come in, so now we had to exterminate all of them. Ashley's ready for a nap. Me as well. It's gonna be an early day, Ashley. Once we finish this, we're gonna do nap time once this court's over. Hey Jay, it's a pro se out of Thurston County, District Court number 4, I believe, up there in Washington. That's not far from where you are, right? Did someone help DB with his defense? You give him assistance on a laptop or something? Jenny, if the Darrell Brooks trial, it was interesting. No, nobody helped him during the trial. The judge would not allow him to have standby representation, but he did have all of his preceding lawyers' legal work. So all the paperwork they did, all the interviews, all the discussions and depositions. He had all that information. He had boxes of that, and so he wasn't left alone. He just had to pick up their work where they left off and try to make heads or tails of what it was. And he was no good at it. He didn't know what they were doing, and so he was miserable. He is channeling Mr. Brooks a little bit. The sounds are a little quiet. That's all. I'll turn them up for you. We'll turn it off during court, though. Does this defendant have a record? I have not looked up his record, but the way he asked a question earlier today on our video, where he said, now, is this the case about the trespassing at the 7-Eleven? It makes it seem like there are other cases. There are other processes working their way through. Yeah, but screens, they stop the airflow. I mean, I want like a huge blast of air coming through the house. Of course, right now we have the AC that's, my feet are cold right now. Nancy B says, my neighbor's having a property line dispute with his neighbor, and the other guy had a criminal trespass on him, and my friend was arrested. He's looking at a fine or 1 year in jail. Wow. Hopefully this guy doesn't do a year in jail for trespassing at 7-Eleven. Let's see. I bought a green fly trap bag to hang near my cabana in my yard, and it cut the fly problem way down. Is that just like a Home Depot type purchase or Amazon? Man, Ann, hope the AC gets powered on for you. That's rough. Thank you, Jenny. AC is wonderful. We have AC. It's back. We got it fixed yesterday. Okay. I'm busy subscribing to all the Thurston County District Courts. They have 4 YouTube channels. Apparently, they're very busy in court, but we'll see. Ashley says, I sent you a link to the burner phone. Let me take a quick peek at this one. Whoa. That's the decapitation one. I guess that's just plain murder. Is that the one you sent me, the Connecticut man, Ashley? Or is that someone else? That's the most recent link I got. All right. Sounds family friendly enough. Yes, just a decapitation with a sword. What was the AC problem? Officially, it boiled down to a capacitor issue. The pump was not powering on, and they changed the capacitor and it worked. So it's something I probably should have had fixed a long time ago. Jury selection for a case starting August 17th in Connecticut. That's the decapitation one. Here's what I'll need to do. Let me check out Connecticut's laws, first of all, to see how they're going to handle media in the courtroom. I may still have time with it being the 17th to get access and approval as a media member. And if they do Zoom, that will be easier. You'd be surprised how many neighbor disputes end when someone makes the first move to do something kind. Yeah. Like give somebody cookies with X-Lax in them or something like that. Hey, Mrs. R.A., how are you doing?
15 minutes I have to take him to work, and I'm scared of the raccoon.
Okay, so you have to take one of my kids to work in 15 minutes, and you're scared of the raccoon.
He's my kid too, but yeah, I am.
Okay. Wear shoes. The last place we saw the raccoon was under the car. So now Mrs. R.A. is a little worried. The car's right next to the garbage can. It looks like we're going to play a little bit of music as we wait for court to start. We have 7 minutes. Let me run outside and make sure.
It's in 15 minutes.
In 15 minutes, but you can move the car or something, right? Well, you can use remote start on it, and maybe that will scare the raccoon.
It's my body outside that I'm worried about.
Yeah. AJ, yes, this is a nice thing to do for neighbors. Carve your trees into letters like F and U, like I did. Here's the thing. Mrs. R.A. needs to use her car, and she's worried because the car was right next to the garbage cans, and we don't know where the raccoon is. Go protect your queen, says DMB. Did you put the raccoon in a car? No, we didn't. It went under the car. I will say I used my my air rifle, which is a Ruger .177. It's a pellet gun. I used that without any pellet. If you just cock it and dry fire it, it produces a very loud crack because it projects air at over the speed of sound. So you get like the sound barrier crack. So it sounds like a small caliber firearm being fired, even though there's no projectile. It's just air. You could shoot it at your hand and it wouldn't hurt. But it makes a loud sound. And we used that to scare it away, but it scared it under the car. Use a sword. Okay, put a smelly bag of trash 500 feet away. I wish my neighbors would do that. Apparently we're the ones with the smelly trash, though. Let's see. Capacitors can last 10 years or 10 minutes. No way to protect the demise. Yeah, but they actually, it was a very cheap fix. It was less than $200 to get it fixed. And they showed up. We finally found a company that said we'd show up in 45 minutes after we called them. And that's just amazing. I agree, but the rifle is, less than $100. It's a cheap little gun. And when it's a raccoon or me, I'm going to dry fire. Okay, so, hey, Jen, Mrs. R.A., she's going to have to be here on camera and talk to you because I can't just leave you guys hanging. I'm going to let you talk to her if I'm going to do the heavy work and go find the raccoon and clear out her car. She'll be here with you guys. The raccoon heard you got AC. Beep the car horn. It's got remote start. So we're going to try that. Okay, here you go. I'm going to go work on the car, and you sit right here. That's the deal. There's nothing on, by the way. We're waiting for the judge to start. It's supposed to be in 4 minutes, so I'll be back in 4 minutes. All right? Okay. Here you go.
Okay, Scott's going to go protect me. So here's the deal. I know there are a lot of you out there who think, what's wrong with you and why aren't you being nice to the poor raccoon? There's something wrong with this raccoon. He's not behaving like a raccoon ought to behave. And I had an experience when I was just a little kid where somebody had a pet raccoon and they left. I think they went on vacation and they didn't leave any food for the raccoon. And so because the raccoon was hungry and not afraid of humans, it came to our house, and my little brother, who was just a couple of years old at the time, was attacked by this raccoon, and it completely engulfed him and was eating him, and it was really problematic. And my mom was really, really brave, and she ran outside and she grabbed that raccoon and she threw him off of my brother, and it came back and attacked her leg and bit her. And then Caruso, I'll tell you how they're supposed to behave. But anyway, it was bad. They had to take him to the hospital. He had just bites all up and down his entire body, and they had to get shots and everything. And so I know that not every raccoon is that aggressive, but they can be. It can be actually a real problem. And I gotta say, the reason that this one is concerning is because it's out in the daytime and it's not acting afraid of humans at all. It's not trying to run away or anything. It's being kind of aggressive. And so it's just anytime an animal is not behaving as that animal is supposed to behave, that's something that is a red flag, and it's something you need to be worried about. So I already called and whined to the people in our city and said, please come save me. And they said, no. Yeah, it was really problematic. So yeah, I remember the next day the police officer came to take care of it, which, I mean, that was a very, very small town. I guess maybe they didn't have animal control, but I remember watching this guy come through, and he had a revolver because I was short. So as he's walking by this police officer, his gun is right at my eye level. And I remember thinking, that gun is really big, and just being kind of scared by the whole situation. And he went outside and he shot it out of the tree. It was way, way high up in the tree in our backyard. And I never saw it. I never saw the body. I assume he got it. But then it was gone, and we didn't have any more problems with it. But that's kind of where I'm coming from. So I am not a fan of raccoons who aren't behaving properly. This is not okay. Okay, Scott's back. Thanks, guys. Oh, are you not back?
I'm back.
Okay.
Here's your keys. Car's running.
Thank you. Okay, I don't have to leave.
Okay. You left an iPad in here. All right, and I'm back. Sorry to disappoint you all, but here I am. You left an iPad. Yeah. 3. Still waiting on court. We have nothing. It's 12 straight up, so we should have something here, but our raccoons should be very full. We have, don't they eat like corn and things like that, or is that just skunks? But we have huge fields, farm fields around here. What story did she tell you while I was gone? I'm looking at these questions. We're wearing matching shirts. Raccoon Hunter is back. Did not do any hunting. It didn't run. It's not out there. I could not find it. I hit the garbage cans. There was no scuffling in the garbage cans at all. Nothing was happening. Man. Let's see. Got nothing from Thurston County yet. Just waiting. What a letdown. If this judge doesn't air this, there are going to be issues. I'm hoping. It didn't. There was a garbage bag that was out there that was sort of protruding from the top of the garbage because tomorrow's garbage day, so the can's like full, and it was not torn or bitten into or anything. So it doesn't look like it had accessed our garbage at all. Rebecca, you sent an utterly moo cow for road rage. They're good for that, although you probably can throw them at people as well if needed. Do we have any type of game wardens you can call? We have animal control is the closest thing. Because raccoons are invasive species in the United States, they're not native to the area. They're not treated as like the Fish and Game Department won't do anything with them because they're not protected. They're legal generally to hunt year-round with any weapon, no limit, because they're invasive species. So the game wardens don't do anything, but Fish and Game or the animal control sometimes will, but usually in a bigger town they will, but not here. So I'm checking all the Thurston County courts to make sure he's not in another room. Alternate jurors is one subway from 600. That's awesome. Congratulations, alternate jurors. There were folks on the Law Talk with Mike channel who are looking for it as well and saying, RA has it up now. Oh, no. We're all looking for it. If your game ward is anything like ours, he's probably 2 tall boys deep at the VFW already. I don't know. I've never seen a game warden. Not here. Apparently, I didn't miss much. If we can get this court to come in today, it's going to be a blast. We've got this Sov Cit case that we're waiting to begin. Let's see. Big shout out to Law Talk with Mike, though. Great channel if you like. And Squishy Gardner as well. Both of them follow some really funny stuff. I think both of them are following this trial as well. But you can trap them and let them go because that's you can. Yeah, you can't trap them. The only option is to kill them, so just try and ignore them as long as they don't do any damage. Yeah, as soon as you trap a raccoon and you try to let it go, they'll bust you. To decide which trial we're going to be covering tomorrow, Sharon, first of all, our number one priority on Wednesday is for James and Cynthia, who will be appearing in court. I believe it'll be early in the morning. Maybe 10 o'clock. We'll check that one. Rex's court appearance is pushed to 2 p.m. Rex, is that the beheading one? Pitt County, P-I-T-T. Yeah, tomorrow we have James and Cynthia. We think that their case is actually going to run to, work its way through the system. Now this has got to happen here. What's happening here? It's not in District 3. It's not in Court 3. It's not in Court 1. Court 2 is not live either. I just think they're late this morning. That's all. What's the Gilgo suspect? The Lisk. No cameras in Lisk Court. This is New York, right? Yeah, that's going to be impossible to track. Whoa. Let me do a quick check for this one. Thank you, Amber, for a heads up. Orange County court records. Here we go. We're going to search by case number. And just from memory, I think it's 2020 CF 002603-AO. That's her. Trial is set for 10/2 is the latest I see. They set a trial for January, February, March, April, May, June, July, August, September, October 2nd. Why did I have to do that on my fingers? I just could not remember which month 10 was. October 2nd is Sarah Boone's date. So a little under, just over 2 months. It's going to be awesome. Sweet. So we get probably one more letter in that time. Let me go back to watching the court here. Has anybody seen anything from Thurston County District Court today? Not seen anything at all. Filters live or today. Court 3 just went live. Okay, that's not the right one.
Ryan.
Ryan Apple Snapple, how are you doing, my friend?
Good. How are you now that your AC is fixed?
Oh, tell you, I'm in heaven. I really am. I wish the court wasn't running late this morning because I'm excited to get started. But what's up?
No, I thought I would call in because I'm seeing a conversation in the chat of the man flu. Somebody has the man flu. And something I don't know if many of you know or if any of you know, I'm trans. So I was born female, transitioned to male. The male flu and the female flu are two different things. So ladies, please be nice to your men or the men in your family when they have the flu. It is completely different.
There we go. So, well, thank you.
Your body reacts very differently. But another thing there, I don't know if it's true. I don't know if it's confirmed. There are rumors that Alicia Navarro and the man she was living with are on the run. That they, here you go. That they vacated the apartment they were staying in and took everything with them. I sent you the TikTok.
Okay, I'll have to look at that. I've got like
phone.
a billion messages on the burner for some reason.
Yeah,
but check burner for phone numbers.
But I wanted to congratulate you. No, it was not your husband, MCAT. I am a trans man who definitely the first time I got the flu after medically transitioning felt like my world was crashing because I couldn't do anything around the house.
So this just means that when I get sick and I'm like, you know, my wife gets sick and she's like, well, I still have to parent, I still have to teach, still have to feed the kids, you know, things like that. And she still gets tons done, but it's worse for me. That's what you're saying, right?
It is.
There you go.
It is because I used to be able to, I would stay at home and I could get stuff done. I could get cleaning done, all that.
Hang on.
When I have the flu now, the dishes might get done.
Ryan.
But anything else, nothing's getting done.
Ryan, we're starting now. We're starting now.
Okay.
So we found
court.
Thanks, Ryan. We'll see you.
Order and continuance.
Hang on one second.
I would just ask the court to keep that in place. I think once Mr. Montgomery completes that online.
I've got too many cameras running. Just one second.
The state will be amenable to rescinding the no contact order.
All right. Okay. So it sounds like
I've got to find
wait the whole year. You can certainly ask
what's
the court
playing
for a hearing to discuss that. We'd let the other David Montgomery know that hearing was had, and we could talk about.
I've got to find this video and stop it.
I will note that as soon as my client completes that class, Judge.
Okay.
Where's the video?
All right. So any questions about entering this agreement?
No.
Okay. Well, I'm glad to grant this. It's a good opportunity. So we write off.
Why am I
sign
getting
off on
audio
all
from this?
Second. Let's see.
So camera
As
3.
to probation is going to be doing some work here. I'm going to impose a $60 probation fee.
Okay.
And if you need time,
Hold tight. We need to shut this off so we can get the other.
We can make that happen. Let's see. Would it be realistic, Mr. Montgomery, in 30 days? So by September 1st, you start a time payment agreement?
I can't find my. I've got a window open somewhere and I cannot find
do
it.
that if you want to. Yeah. All right. But I would certainly let you, if you decided that you needed 30 days to start, then
We're
you
going to
can
back up and catch this, but I need to find.
And when my client completes the class, Judge, I'll file a copy with probation and Your Honor.
Perfect. Actually, just probation is enough. They're great. They're my right hand. So, all right. And then you stay law abiding and that online anger management class. Let me get all this.
This is driving me nuts, guys. There's no window open. I'm just getting audio from somewhere that I shouldn't be. Okay. All right, there we go. I think I fixed it. Okay, so court is about to begin here. We're going to back up just a little bit so we can get it live.
Good morning.
Good morning, Your Honor.
So just abide by that no contact order, and then exactly that will probably, if you decide.
Why is
that
it coming
you'd like to
back?
Have a hearing about that. You can get that scheduled.
Oh, there it is. Sorry, my own fault. Got it fixed. We're fixed.
And Mr. Milton is just to, you're going to have the opportunity, as I said yesterday, to do an opening statement. Mr. Sharp will go first, speaking to the jury with his opening statement. You can do an opening statement when he finishes, or you can wait till he finishes his case, or you don't have to do one at all.
I'll do one for a nice presentation, but according to the concern I raised yesterday, the jury has literally been told not to take anything I say seriously. So my case is literally built off of Officer Evers on the stand right now.
Okay.
Yep.
All right. So I was going to point out that what the opening statement does is you're going to tell the jury what you believe the facts will show.
Yep.
Now, they've been told that what you're saying aren't the facts. Your facts, you can have the opportunity to give your facts when you're sworn in as a witness. But all the opening statement is you believe this is what the facts will show.
Right.
And that's what you're telling the jury in opening statement. So if you wish to make one, that's what it's about.
Yep.
Okay. All right. Let's bring the jury in.
Okay, here we go. We've got a few people watching this one now. Judge has already had a big smile on his face as the defendant, who I can't tell if he's wearing pants today or not, has already said the jury's already been told not to believe anything I've said. No, he's just, it's not evidence. He can't just spout stuff. The judge is so ready for this to go, to be over. I think he might be wearing the same outfit as yesterday.
Bring the jury.
Seated. Good morning, folks. Hope everybody had a nice evening, and thank you for all coming back. We appreciate it. When you enter the courtroom, you're going to find the parties standing. They're standing out of respect for the role that jurors play in our judicial system. So when you come in, you feel free to just go ahead and have a seat. All right, folks, you have been previously instructed. Those instructions that I gave you yesterday obviously apply today during our trial proceedings. We will begin with opening statements. Mr. Sharp.
Thank you, Your Honor.
Morning, everybody. Looks like we all made it back. Thank you for that. Your time is precious, and I recognize that. And, I hope this trial will be fairly swiftly so you can get back to your lives. Should be a fairly simple affair. I'd like to get out in front of it and point out that I would imagine if you could sit on a jury, if you feel that you are being asked to pass judgment on it, where one way or another, whether that's a good person. And I just want to make sure that everybody understands that's not what we're discussing today. You're not going to see the city come out and present a parade of horribles and say, jury, now that you have seen all of this, make your decision. Is Mr. Milton good or bad? That's not what we're doing. I would like to think, as I imagine all of us in this room, is a good person. We're here today specifically to examine and evaluate. Okay? We are asking you to decide whether Mr. Milton took certain actions that he's been accused of and whether those actions violate the law. It's that simple. In the city's case, it's as simple as 1, 2, 3. Evidence will show, I believe, that 1, it was made very clear to Mr. Milton that he wasn't welcome back in that 7-Eleven store, and he knew it. 2, that he went back in there anyway. And 3, that this happened in Lacey on March 31st, 2020. The city intends to prove this by presenting evidence in the form of testimony from 2 witnesses and 1 physical exhibit that you'll be able to look at. The testimony will present an event that happened in 2 phases on March 31st. I'll call this the early contact phase and the late contact phase. What I'm offering you right now is just a rough preview of what I expect the evidence is going to show to you. So you have a roadmap. You kind of know where we're going and what to expect and have a framework to receive this information. So obviously you will hear from Officer Evers. I wonder if you assumed that that is the case. You'll also hear from one other witness today. That's a civilian. Her name is Jessica Easley. She was a clerk at the 7-Eleven store that day on March 31st. She'll take the stand first this morning. She'll start by describing that early contact phase of this incident. She'll explain to you how it was a busy Friday afternoon at that 7-Eleven gas station, and that Mr. Milton had been at the store that day. He was in and out that afternoon, not conducting typical business within the store there. She'll describe what could fairly be called a loitering behavior, that he was hassling staff and customers within the store. She'll describe that she believed he showed signs of being intoxicated, that he had expressed that he was too drunk to be held accountable. She'll describe how he brought a cell phone in, was trying to get that charged within the store. They had asked him to leave. She'd asked him to leave at the time, and he didn't. And she'll explain, I have to protect him, that she felt some fear from this circumstance. That after a while of him not leaving when he asked, she called the police. At that point, we'll move roughly to the later contact phase. You're going to hear from Ms. Heasley all in one go, and then you'll hear from Officer Devers. So they both have two contacts to explain, and the chronology will be a little tricky there because it's all Ms. Heasley and it's all Ms. Devers. I hope you can track it. I don't think you can. Ms. Heasley will explain that after the police came and warned Mr. Milton not to go back in the store, that she kept herself busy to try to stay away from the front counter in case he did come back. She didn't feel safe. So explain she kept an eye on things, and sure enough, to explain Mr. Milton did. I'll leave it to her to explain what she saw and heard when that happened. And I'd suggest maybe trying your best to imagine what it must have been like in that store. What the environment was like, how you would have felt when you were a customer. She'll also explain that that second time coming in, that Mr. Milton also brought his cell phone in that time. So both of these contacts should explain the phone and cell phone. Officer Evers will take the stand after Ms. Heasley. She will explain to you how she was dispatched there after a call to the police. She arrived and received a complaint from Ms. Heasley. This is the first contact. Besides receiving the complaint, she also received the cell phone. That's pretty important. She'll describe that for you. She'll describe to you how she gave Mr. Milton, the verbal warning, hey, you can't go in there. She'll describe the written warnings that she gave him. We'll go through this, and you'll be able to see this. She'll describe to you the conversation that she had with Mr. Milton, her take on his intoxication. She'll explain how he asked if he could go back in to charge his phone, and she specifically told him.
Sorry.
Also explain how there was a tricky issue and his car was outside the store. She didn't want to drive it in safety. So they worked out together, some troubleshooting to arrange for him to be able to push the car off into the next lot so it wouldn't be on 7-Eleven property. And then left. Unfortunately, had to come back again a couple hours later when this incident. So this is a rough roadmap of what I expect you'll see from these two witnesses. To ask you to, while all of this is happening, use a tool that we all have, the same thing. It's a built-in live thing. I call mine my baloney meter. When mine starts going off, I think I might be fed a bologna sandwich. Whatever you want to call yours, I'd ask you just kind of be sensitive to that phase. The witnesses all testify. You are the ultimate arbitrators of credibility. So who should you believe? That's up to you. So that's the tool that you decide. Central in this case is going to be whether Mr. Milton was, as he claimed to be, too drunk to be held accountable. I'd suggest that you pay attention, especially during Officer Evers' testimony, as she describes her training and experience in dealing with people who've been
consuming alcohol, as well as her observations of Mr. Milton in that particular encounter. How the conversations go, listen to how she describes how they were coherent or not, how complex they were or not, how responsive Mr. Milton was, and whether those are indicators that he's maybe too drunk to be held accountable, or
I'll explain what happened in just a second.
again, the city's case is as simple as 1, 2, 3. I believe the evidence will show beyond a reasonable doubt in the city's case that Mr. Milton did, in fact, no, it was made clear to him, but not go back into that 7-11 story. 2, did it anyway. 3, this happened in Lacey on March 31st. Conclusion of the trial toward the very end, the judge will read to you the jury instructions. There's a packet that you'll get to read along with. And those are the judge's instructions as to what the law is. Once you receive those and he reads those to you, we'll have another chance to talk. And I'm going to take that opportunity to connect the facts from the testimony to the law that's in that packet, show you how they line up, show what I believe is a pretty clear case that the facts indicate a violation. I hope that you'll agree with me at the conclusion of that presentation on the facts.
Right. Okay, here we go.
Why is the city of Lacey
Because this is a criminal.
Okay, so I had showed you what happens in just a second. I showed you this. So now I can cut to this.
Jerry. I was out of gas. Was hanging out with a friend. About 60 years old. Store. He and I were drinking together. Went in, and Jessica Heasley, I believe is the name, denied me a sale. But then the manager there was like, "Why are you treating him like that?" And everybody else here.
Your Honor, objection. Okay. I'm so sorry to interject, Your Honor.
Okay, Mr. Milton, hold on just a moment.
I would like to not be interrupted, but I will.
Okay.
I apologize for the interruption. The city has to object. Mr. Milton, unfortunately, is introducing testimony while not under oath rather than presenting an opening statement.
Okay. Well, the juries understand what Mr. Milton is saying is what he believes the facts will show. Mr. Milton, go ahead.
Forgive me, Your Honor. I was out of gas. The manager told her that she's not allowed to deny me the sale because she's the only one that doesn't like me there. So she told me that I had to leave because she had a problem with me. I was intoxicated, like I just said. I left. I had no gas. She called the police on me. The police came. The manager came out as soon as the police had left and said, "Here's $10. Go get gas and get the out of here." I was never allowed to leave with my belongings, with all my stuff. I went in to buy the gas, and then she called the police on me. The manager at the time had a plane to catch. So she gave me the $10 and went to go catch the plane. I denied the sale on gas. I got called on and I got arrested. When the police got there, I said, "Okay, Evers, I'm too drunk to tell you that I didn't do wrong right now, I guess."
Thank you, Mr. Milton. And Mr. Sharp, if you call your first witness, please.
Thank you, Your Honor. The city calls Jessica Heasley, and she's in the hallway.
All right.
Do you mind going to get her?
Yeah.
Thank you.
As far as objections go, we're up to 2. We're going to count both sides. One from yesterday, or from the stuff we watched this morning, but it was yesterday's proceedings, from the defendant, and one from the state as they objected to his opening statements. Apparently, he was out of gas and drunk, and he got $10 and admitted to guilt on everything. Yeah, drunk driving is much worse than
If you step up here, please. And raise your right hand for me.
think we'll have camera on the witness stand.
Swear the testimony in this case to be the truth, the whole truth, and nothing but the truth. You can just say yes.
Yes.
Okay, go ahead and have a seat.
Thank you.
Sure.
Good morning. Jessica Heasley. JESSICAHEASLEY.
And what do you do for a living?
I work as a store sales associate at 7-Eleven.
Which 7-Eleven?
The one on 2425 Marvin Road.
What city is that?
Lacey.
And were you working on March 31st, 2013?
Yes, I was.
What happened that day?
A gentleman had come into the store while I was on the break in the back room, and started shouting. I asked him to leave, and my coworker also asked him to leave.
You're under oath. I object, Your Honor.
Okay, the nature of the objection.
The nature is she's under oath, and I was literally served after she mistreated me. So
okay, yeah, you're a different view of the facts isn't a basis for an objection.
Cool. It's not a different view of the facts. It is a fact. But okay, thank you, Your Honor.
All right, you may proceed, Mr. Sharp.
I picked up where you were.
He was asked to leave. My coworker ended up being the one to kind of encourage him to go.
And what time was this from?
I believe after 2 p.m. I called the cops after he refused to leave, and he put himself in the doorway and claimed that since he was outside the store, he was gone and we couldn't tell him to leave.
I object again.
Okay, good. I'm not going to hear that objection unless there's an objection.
She's under oath and she's lying.
Okay.
I don't
All right.
appreciate it.
Okay, thank you. Go ahead, Mr. Sharp.
Let's back up a little bit if you don't mind. How are you feeling today?
Nervous.
Nervous. Feel free to pace yourself and take a breath as you need. So about 2 o'clock in the afternoon, you were at work. What did you see and hear?
Initially, I didn't see much. I was in the back room. I did hear him start to shout. I didn't hear a lot of it. I believe things about his personal life. He did start to insult me.
How so?
He called me a heartless bitch. And asked my coworker if he said he hated that bitch yet today.
So what happened after you heard him say these things?
We asked him to leave. My coworker talked to him a little and said he couldn't be in here, be in the store drunk and shouting. And then he put himself in the doorway, like I said. I called the cops from the back room and told them there was a drunk man who was refusing to leave the premises and was insulting me. And that he left the store for a little bit, but in the time it took for the cops to arrive, he'd come in and out of the store a few times. I believe the second or third time came in, he claimed that it was his cell phone and asked us to charge it for him. My coworker plugged it into the outlet. He also attempted to purchase gas, and we refused the sale because we didn't think it was a good idea. one, to sell gas to someone who seemed to be drunk, and two, I informed him that we were not going to serve him because he was not supposed to be on the premises.
Ma'am, you've mentioned a couple of times Mr. Ron. Why do you
he seemed very emotionally volatile. He was raising his voice a lot and seemed aggressive, and his hands were shaking a little, I think. He was a semi-regular, and I hadn't seen him act this way before. He'd come in before, and while he wasn't always an ideal customer, he did seem a lot calmer and wasn't prone to raising his voice. I'm sorry, I lost track of where I was.
take a breath? Okay, so I believe chronologically it left off with giving his cell phone.
Yes, he claimed it. Sorry.
What happened?
He claimed it was his cell phone and asked us to charge it. I attempted to say no. My coworker just kind of went with it. The phone was on the charger, charging until the cops arrived. I'm not entirely sure how many times he came in and out of the store. I mostly attempted to avoid the counter as long as he was there. So I went into the back for part of this, and then I found chores that kept me away from the counter because I was nervous about him being there.
Would you recognize that person?
Yes.
See that person present today?
Right there.
Does the record reflect that this is pointed to the defendant?
It will.
Defendant has his hands on his head.
At one of the times he came inside while we were waiting for the cops, he claimed that he owned the Lacey Police Department and the court system, and nothing would come of calling the cops on him. And my coworker informed me that he was asking for me and had said that he was going to be outside all day. So if I would want to come to talk to him, he'd apparently just talk to me after work, which was kind of terrifying. The cops arrived. I'm not sure how much later. And I was not outside, so I don't know anything that happened between the cops and him. But they came to talk to me after.
I'm going to interrupt you on. Mr. Sharp, if you'll ask questions rather than have a narrative, please.
Sure, Your Honor. Okay, ma'am. So, when the cops arrived, what did you do?
I kept working. I was breaking down cardboard because it kept me away from the counter, but also let me watch the door. The cops came to talk to me. They gave me a yellow trespassing paper, which had his name on it and said that he acknowledged the trespassing.
Did you read that paper then?
Yes, I read it through, and then I put it in our drawer where we put paperwork and things.
You may.
Yeah, I'm handing you what's been marked as Plaintiff's Exhibit 1. Take a look at that. Recognize that one?
Yes, ours was yellow, but yes. It says, I, Peyton A. Milton, and born on August 3rd, 1993, do hereby acknowledge that I've been notified by J. Evers of 7-Eleven that from this day forward, I am prohibited from entering the premises located at 2425 Marvin Road, Northeast Lacey, Washington. It acknowledges that if he does, it could result in his arrest for criminal trespass in accordance with LMC 9.28.090. And then it says he has been advised and acknowledged that on the date of the 31st of March, he And then it also says.
That's okay.
Yeah.
Thank you for reading that.
Sorry.
So is this the, well, I'll ask while you still have it. Is this the same form that you saw that day?
Yes.
Thank you. Okay, so the police had arrived. They went outside with Mr. Milton. They came in, gave you this form, and what happened?
They told me that he still had a chance to vacate the premises if he came back in, to call them again and they would come arrest him, and that his car needed to be gone by end of day. And I gave them the cell phone from inside and said that he claimed it was his phone, and I wasn't comfortable going to return it to him, so I handed the cop the phone and asked them to return it. After the cops left, I'm not sure how much longer, but he came back in with the phone and tossed it on the counter and said that it wasn't his. I told him.
What happened then? So the police had left, came in, inside. What happened after that?
I told him he needed to leave because he had been trespassed, and if he did not leave, I was going to call the cops again. He did not leave, so I called the cops again.
How was he acting?
I think the best word would be belligerent. He was still very, did not seem inclined to listen when asked to leave. There was an argument with another customer. I missed the initial spark to the argument, so I don't know what led to it. But when I came out to see what was going on, he was about 6 inches away from another customer. He was elderly, and he was shouting that he owned their community and he'd done so much for the community. They can't treat him like this.
Saying
Milton, Peyton. I asked him to leave again, and he was very focused on the argument. He barely acknowledged me. He would not stop arguing with this gentleman. At some point, he sat himself on the ground in his refusal to leave. It was, honestly, we were like very focused on this as well. There was a line building up. The customer seemed pretty upset as well.
So after sat down on the ground, what was happening while he was seated? What was he doing?
Still arguing with this gentleman. At some point, we just tried to work around him. My coworker came, the one who had chased him out the first time, she had left and forgotten something at the store. So she came back and kind of chased him out again.
The defendant's Facebook is nuts. Holy cow.
When the cops came back, he was arrested. He was outside in the parking lot again by that point. He was arrested, and when the cops came to talk to me,
where were you?
Still inside the store. I was, I believe, breaking down cardboard again. When the cops came to talk to me to tell me they were arresting him, I got the phone he put on the counter and gave it to her, and said that he said.
If he'll stop right there. Sure.
Your Honor, the record, the city asked the record indicate that was easily pointed to Officer Beavers at the city's table.
I'm sorry, I forgot her name.
It will.
And said that he claimed it was not his cell phone. And at that point, he was arrested. He was off the premises. And she kind of gave me the rundown of, you shouldn't deal with this again, if you ever do see him on the premises again, call us again. You still have the trespassing paperwork. And that was kind of the end of it.
Further questions at this time?
All right, thank you.
So Peyton Milton has a Facebook page.
Mr. Milton, do you have
nuts.
questions for Ms. Heasley?
I do, but I don't know what they would be at this current point in time, and I don't really like dealing with people that lie under oath.
Okay,
So
you can't comment on her credibility. All you can do right now is ask questions.
No, I'm all right, Your Honor, is what I meant to say.
All right, thank you. Members of the jury, any questions for Ms. Heasley? I don't see any. Any objection, Ms. Heasley being excused?
No, that would be the request, John.
And Mr. Milton, any objection, Ms. Heasley being excused?
I guess I do have one more question now that I think about it.
Okay, go ahead.
Should I?
You can sit or you can do it from the easel.
He's a kung fu master, so keep an eye on him.
Do you remember who came to pick up the phone a week later?
No, I handed it to the police officer.
Okay. So you don't remember hearing about it being in storage or being in lost and found and somebody else coming to get it?
Nope, I handed it to the police officer.
Okay. And did you know that the man that you said that I was arguing with was my friend and trying to get me out of the store to help you?
No.
Because, forgive me, I'm only allowed to ask questions.
Correct.
Thank you, Your Honor.
All right, thank you, Mr. Milton.
He's doing
anything else,
splendidly.
Mr. Sharp?
No, Your Honor, thank you.
All right. Ms. Heasley, you are excused. Thank you very much for your testimony.
Thank you. Have a good day.
She did not like him being up there next to her, asking questions.
Next witness, please.
Your Honor, City calls Officer Evers to the stand.
This is located in Lacey, Washington.
Raise your right hand, please. Swear the testimony in this case will be the pardon me, the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
You may have a seat.
Officer,
Morning.
please introduce yourself to the jury and state your or spell your name for the record.
Yes, Josie Evers, Josie, and last is Evers.
And you're in uniform, obviously, a police officer. Where do you work?
I work for the city of Lacey as a commissioned police officer.
What are your duties there?
I work patrol, so I respond to calls of service on the road as a patrol officer.
Were you on duty on March 31st of this year?
Yes, I was.
Were you dispatched to an incident in 7-Eleven store?
Yes.
What happened?
So at approximately 2 p.m., I was dispatched to an unwanted call at the 7-Eleven on Marvin Road. Dispatch advised that there was a male being belligerent and yelling at staff members. I responded to the area of the 7-Eleven. When I got to the 7-Eleven, I contacted Miss Heasley inside the store. Miss Heasley advised me that there was a white male. He was approximately 5'5" with a beard, and then he was wearing a plaid green and black long sleeve flannel. She advised me this male had come into the store, was yelling, being belligerent, disturbing the other customers inside the store. She also advised me at one point he had told her that he would be waiting outside when she got off of work. With that information, she also told me that he had a Toyota 4Runner that was parked on the side of the 7-Eleven building. She advised me right before I'd gotten there, he had left the store and gone into the 4Runner. With that information, I went outside the store and I looked over and I saw the 4Runner right where she had said it would be parked. And inside of that was Mr. Milton sitting in the driver's seat. Before contacting him, I already had contacted him on prior social contacts before, so I recognized him.
Awesome. Sorry to interrupt.
Yes.
So you had prior contacts with him where his identity?
Yes, so
as a patrol officer, I go on what we call social contacts, where I've seen him outside other gas stations and the 7-Eleven clean up trash, and I just went and talked to him, offer him we have a mobile outreach team to see if he needed resources or if there's anything we could help him with. At that time, he also had provided me I asked for his name, and he willingly gave me his name and his date of birth on that prior social contact. And with that, I ran him for any wants or warrants. And to confirm his identity, in our system, I pulled up his Department of Licensing photograph, which is how I was able to identify him.
I think we left off, you had just spoken with Ms. Heasley in the store and going out to contact Mr.
Yes, and then Ms. Heasley also provided me with a cell phone, and she said he had left it inside of the store, a little prepaid phone with a charger. She told me the gentleman, Mr. Milton, had left it inside the store, and she didn't feel comfortable or safe giving it back to him. She also advised me she wanted him trespassed from the store, so she provided me the cell phone and the charger. So right where I left off, I went out to the Toyota 4Runner. I contacted Mr. Milton. I asked Mr. Milton if he was inside the store, and he stated that he was. I provided him the cell phone and the charger back. Speaking with him, based on my training experience, I could smell the odor of intoxicating liquor coming from his breath. I think there was also a beer can sitting in some portion of the vehicle.
If I could interrupt you.
Yes.
To ask you questions here. You mentioned your training experience and that you recognize the odor of alcohol. Tell the jury a little bit about your training experience as far as it pertains to alcohol consumption.
Yes, so we go to CJTC, which is the Basic Law Enforcement Academy, where they teach us field sobriety testing, BAC testing, and then the indicators of when someone is intoxicated. So droopy eyes, obviously the odor of, liquor on someone's breath, droopy eyes, if they are slurring their words, how they're standing, the ability to walk. And so just being inside the academy, they taught us the basics. And then I've been a patrol officer for 1 year now, and I've just had multiple contacts, DUIs, and just social contacts with people who are intoxicated.
So you made contact with this plan with Mr. Miller.
Yes. So I provided him back his cell phone and the charger. He took the cell phone and the charger from me. So at this point, I asked him if he had been inside the store. He said he was. And then I tried to interact with him a little bit more, but he kept saying to me, I'm too drunk to be held accountable for my actions. I tried, communicating him, getting his side of things, but he just kept telling me I'm too drunk to be held accountable for my actions. So at that point, I advised him, you're going to be trespassed from the store. You're not going to be allowed back on the property. He asked me if he should move his car because it was parked right next to the building. And I advised him that because he had just said, and I could tell that he was drunk based on my experience. I didn't want him to drive, obviously. So I advised him, he asked if he could manually, him and his friend was sitting in the passenger seat, and they asked if they could get out and put it in neutral and push it. There's about 25 yards away, there's a little gravel spot next to the 7-Eleven that isn't really their property, and he asked if they could push it over there so that he wouldn't be driving. And I advised, that's fine. I said, you had he asked if he could move it tomorrow, and I said, no, you have until nightfall to push the car, or until you're sober. If you're sober, you can drive it away. So I went back to my patrol vehicle, and I completed a trespass warning.
Officer, I'm going to.
Yes.
Your Honor, can I go to this?
Me.
So, Officer Evers, I'm handing you what's been marked as Plaintiff's Exhibit 1.
Yes.
You recognize that exhibit?
Yes, I do.
What is that?
So this is our City of Lacey trespass warning paperwork.
Ms. Heasley read this to the jury, so they're already familiar with at least a substantial portion of its contents. She mentioned on there that he acknowledged that. I wonder if you could describe to the jury what the form indicates as to that and why.
Yes, so I wrote his name, all of his information, because like I said, I had his information. I had attached it to the call as well. And I had already confirmed his identity. I wrote the date. Right here, it says signed. Normally, you would hand that to the person being trespassed, and you would ask them to sign their name. I, however, write acknowledged in front of them rather than having them sign it. If they're showing any signs that they're intoxicated or that they might possibly be disorderly, I prefer not to hand them a pen just because it could be used as a weapon against me. So I just, advise them in front of them, and then I write acknowledged. We also have here at the bottom where normally a manager or the person who requested they be trespassed would sign and then date. However, with the City of Lacey, we've worked with one of our units, a community resource unit. They went out to all the a few of the businesses in Lacey, and they basically asked them, hey, when it's nighttime and we have someone using narcotics on the property or, being disorderly, can we basically have your authorization to trespass someone? So the management, all of this, it says on file because we have the manager's permission on our file that gives us the authorization to trespass someone for them.
So, officer, after
yes.
You filled out that form, what happened then?
So I completed the form. This form has 3 pages attached to one, and as you write on it, it leaks through each page. It has a white form. This white form is for us to keep for our records so we know who's been trespassed from what properties. It comes with a pink form, and that one is for the offender to give to them. And then a yellow form, which is what I later provided to Ms. Heasley. So I completed the form. I ripped off the pink sheet for Mr. Milton. And then I went back to Mr. Milton. At that point, he still had the cell phone and the charger in his hand. And he asked me, well, can I go back in and charge my phone? And I said, no, you're not allowed on the property. I said, here is the trespass warning. I provided him the pink slip of paper. And I said, if you go back in the store, you will be arrested. I said, because you're intoxicated, I'm not going to make you drive. And, if you're tired, you can rest in your car before you push it over to the other side of the lot. But if you enter, I told him, if you enter the store, if you go over to the gas stations, if you go outside on the walkway in front of the store or on their property, you're going to be arrested for trespass. And then I provided him the paper. He agreed that he would move his car later in the evening. And then I went back into the store. I advised Miss Heasley, hey, he's been trespassed. If he comes, I advise him not to come in the store. And I let her know, hey, he's intoxicated. I'm going to let him stay in his car out there for a little bit. But if he comes back in the store or is being belligerent, just call us and we'll come back. So I talked with her. She acknowledged, and then I left the property and I responded to other calls. Approximately 4:30 in the evening, we got another call from the Marvin Road, and Jessica Heasley was the one who had reported it to us.
Officer, just for those not familiar with the store there, how long was it roughly between these two?
So the first call was at approximately 2 p.m. and then the second call was approximately 4:30, so about 2.5 hours between.
So you were dispatched. What happened?
Yes, so the call note said that he had been disorderly in the store and he had went back inside. I responded back to the location and I went inside to contact Miss Heasley first. She advised me that he had come back into the store, that he was yelling at staff and he was being belligerent again. And then she again provided me the same prepaid phone that was left by him, Mr. Milton, prior. She provided it to me again. I took the cell phone Actually, I believe I left the cell phone with her for now. And then I walked out of the store. I went over to Mr. Milton, who again was sitting in the driver's seat of the car at that point. I advised Mr. Milton, hey, I told you don't go back into the store, you're going to be arrested. He just continued to tell me I'm too drunk to be held accountable for my actions. He kept, whenever I tried to communicate that with him, he kept saying that. I advised him, no, you're going to be under arrest for trespass. I opened the door of the vehicle. He was holding a drink and smoking a cigarette, and I was like, no, you're done. You need to sit down. It was some like Starbucks cup and then a cigarette. I said, no, you need to set that down. It's time to go. He complied. He was able to stand out of the vehicle, and I placed him in the handcuffs. And he wasn't so intoxicated that he never requested like medical. He did not seem so impaired that I felt he was in danger to himself, or that he was so intoxicated he didn't understand me. He was able to stand out of the vehicle, comply when I put handcuffs on him. When I walked him to my patrol car, he was able to walk with me, and I wasn't trying to carry him by any means because of his intoxication. And then I placed him in the patrol car. I went back inside the store and collected the cell phone from Miss Heasley. And I believe at that point I had asked Mr. Milton if he wanted to take the cell phone with him or if he wanted to leave it in the car. His friend who was in the Toyota, he asked if his friend could like have the keys to the car, and then he was transported to the Nisqually jail where he was booked for the LMC of trespass.
Also, I'd like to just ask a couple of clarifying questions revisiting that issue of intoxication. Mr. Milton states, so you testified you had two different conversations with the applicant.
Yes.
How do you describe those conversations in terms of parents?
He was, especially when I was speaking to him about moving his car, like he was, asking, hey, can I move it tomorrow? I was like, no. And then he asked me earlier, hey, can I go inside and charge my phone? No. If I tried to ask him questions and communicate with him, he would say, I'm too drunk to be held accountable for my actions. His words were slightly slurred, but it wasn't so much where I couldn't understand him or I felt he couldn't understand me. When I handed him the trespass form, he was able to physically grab it from my hand and collect it. So I didn't feel he needed medical attention or was too intoxicated where it was a danger to himself. So.
Thank you, Officer. Brian, this time, say
Thank you. Mr. Milton, questions for Officer Evers?
Yes, Your Honor. Evers.
Officer Evers, do you recall that I was out of gas?
I believe you did tell me you were out. Yes.
Okay. And that was why I was going to have to push my car. Is that right?
I believe you told me that you were too intoxicated to drive, which is why you had to push your car.
Oh, okay. I probably would have said that to an officer. Do you recall that I had my friend contact me after I was placed in the back of your vehicle? And I believe you were up front finishing your report. And I was like, hey, your phone is still inside, dude. Go get it. By the way, can you please make sure my vehicle doesn't get stolen again?
Yes, I do remember you giving him the keys.
Okay.
I don't recall you saying anything about it being his cell phone.
Okay. You recall me asking Jessica if she knew whether or not who came and picked up that phone later. It was like 6 days later I was released. My friend was like, where'd my phone go, dude?
I was not present for that, no.
Okay. That was actually earlier in the courtroom today. Forgive me.
Oh.
Forgive me. I must not have been clear enough. Should have said it. When you guys, as police protocol is operating, do you guys investigate the narrative of the call or the antagonist of the situation? Narrative.
I think I'm trying to understand what you're asking me, but I believe we speak to everyone involved. Are you talking about a trespass or just
In general.
in general? Well, if it's a criminal offense, we develop probable cause for a crime, and if we have probable cause that a crime occurred, then we make an arrest on it.
Gotcha.
That's what you're asking.
Okay. The questions do I need to ask you that I was going to ask myself until yesterday? You make contact with the manager, Jessica.
Miss Heasley, and there were other staff members present at that time.
How many other staff members were there?
I believe one other. There may have been two others. I don't recall completely, but Miss Heasley was my primary contact.
Gotcha. There was two. Wrap up.
Mm.
Was the manager who was just about to leave.
Make that a question.
Sure. Do you know the manager there at the 7-Eleven?
At the time, I did not know.
And you know that I am a regular there and I have permissions more or less to stay on the tribal truck stop across the street?
I did not have the information, no.
Okay. I do good, Your Honor.
You said, did I do good, Your Honor?
If I was asked to leave and I wasn't allowed to leave based on perhaps somebody stopping me from being able to leave all of my belongings, but I did my best to get out of there as quickly as possible, would I still be guilty of a trespass if the manager there told me to go get gas to leave?
Your Honor, objection. He's asking the witness to opine about final conclusion of law.
I'm going to change your question because you can't ask somebody. The jury's going to determine whether you're guilty or not. It's not up to Officer Evers. Okay, so what I'll lie to ask is, would Officer Evers arrest you given those facts?
There you go.
Well, I would, because you had knowledge that you weren't allowed in the store.
Even if the manager had told me to go back in and had to leave to catch a flight.
If the manager was, you still had knowledge that you weren't supposed to be in the store. It doesn't matter what other people tell you, you have knowledge of what is right and wrong, and you have paperwork. The law enforcement, the law is more than a person. Basically, if you know something's illegal, you shouldn't do it, even though someone else tells you to.
And how would I be expected to return back to the property I was trespassed from? I wasn't allowed to leave with my belongings.
No one ever told you you weren't allowed to leave the property.
Might I remember you? I was out of gas and was told to leave the property. Apparently, I was making Jessica uncomfortable, and I suppose that brings me to another great question. If I was waiting for her to leave so that I could purchase gas, so that I could go, because she denied me the sale of gas, would that change anything from your perspective?
No, because there are other gas stations and you shouldn't have gone in the store you were trespassed from. There are other gas stations you can go and buy gas from. You don't have to buy it from that gas station. If you are, and we also have gas cans that we can provide people gas if they ask us and let us know, hey, I'm out of gas. But
so then how would one in law enforcement expect me to leave and come back to a property that I was trespassed and still follow the RCW or Lacey Municipal Code that we're operating under today?
Yeah, because you were advised that you could stay by your car and you had the allowance to stay at the car until the evening until you had moved the car to the other side of the gravel lot, which wasn't the 7-Eleven property. About 25 yards away, there's a little gravel space. And then if you would have manually pushed, like you offered, push it over off the property, and then you could walk to another gas station to collect gas as well.
Thank you. Thank you, Evers.
Mr. Milton.
Thank you, jury.
Okay, Mr. Sharp, any further questions?
I do have a couple of clarifying questions.
Bye.
Thank you.
So Officer Evers, Mr. Milton, I think, was asking about how you conduct investigations like this one. You had mentioned that you work to develop probable cause. And I think you explained to the jury what that means.
Yes. So basically, when we develop probable cause for a crime, it's basically, if you think about it in a plain way, like evidence. So if I have evidence that someone had committed a crime, then I can make an arrest based on that evidence. So I had the evidence of that I had given him the warning, that staff had advised me that he had been in the store twice, and that I had also advised him that he wasn't allowed back in the store. That was my probable cause.
So how did you get this evidence?
Of the evidence that I had the form that I had given him, I had the copy of the evidence as well as witnesses, Miss Heasley, my personal observations of his behavior when I was contacting him, that he was intoxicated. I confirmed basically what she was saying. He was intoxicated. He had been belligerent inside the store based on her testimony. It was a bit argumentative with me as well. And then my physical evidence that I had trespassed him.
And Mr. Milton asked you about a truck stop that was across the street by, sounds like it was a tribe. And I believe your answer to Mr. Milton was that no, you weren't aware you had permission to do that truck stop across the street. Given that that is a separate property than the one you're involved with here, does that make any difference? Would that have made any difference in the investigation?
No.
Mr. Milton had asked you a couple of questions about his ability to leave, and you answered that he had suggested he pushed his car to that gravel lot, and you had granted him the leeway to do that. And you had suggested that gas could be bought at other gas stations. Are there other gas stations reasonably nearby?
Yes, yeah. Within walking distance, there's a Chevron. If you cross, there's a little bridge on I-5 on Marvin Road. I'm not sure the distance. I would approximately less than 2 miles at the most. 2 miles.
So that's reasonable.
Yeah.
Questions, John?
Thank you, Mr. Sharp. Mr. Milton, any further questions for Officer Evers?
No, Your Honor.
All right, thank you. Members of the jury, any questions for Officer Evers? I see one. Teresa? You'll go get the question.
I love that jury has a question. I just love
two.
this.
3.
2, 3, 4.
Hey.
Everybody has questions.
No, that's fine. You'll hand Teresa your written questions, please.
I'm enjoying a ham and cheese sandwich here. Pardon me.
And Teresa, just tear off a piece of paper with the question. And thank you. Teresa, thank you. If while you're there, if you'll just have the jurors step back into the deliberation room, please.
Okay, the jurors are going to step out while they discuss the questions. And I'm not sure who mentioned this, but it's true. He is, thank you, Ivan and Kim, for the match. He's not doing much Sov Cit. I think he just wants to be pro se. He's got a little bit of Sov Cit terminology at the beginning, but that's really not his argument. He's just mad about his phone or his friend's phone.
I'm going to retrieve Exhibit 1 for the court.
Thank you.
Okay, so the council's going to review the questions. The judge is going to review the questions. Let me just cut to that so you can see that. He's reading them to make sure they're appropriate. They'll discuss them with counsel and then ask the witness.
Essentially, 3 questions here. First question is, why could not Mr. Heasley's friend drive the vehicle away? Mr. Sharp, any objection to that question being proposed to Officer Evers?
The one hang up the city has there is the name. I suppose officer would have an opportunity to correct that. No objection.
Well, I mean, there's no name in here. It just says why. It just says.
Your Honor said Mr. Heasley.
Okay, I'm sorry. The question was why could not the friend drive the vehicle away?
No objection.
Okay, and Mr. Milton, any objection to that question?
Negative.
Okay, I'll ask that. Next question is, how did Officer Evers know Mr. Milton? I'm not going to ask this question because it
goes into
has
priors.
Potential of being prejudicial to Mr. Milton, potentially. So
I already answered all of them.
Okay, so I don't intend to ask that question. There has been some evidence provided, but I don't need Officer Evers to go into a history of why she may have had previous contact with Mr. Milton. I don't want that influencing the jury's verdict.
Understood.
Okay. And then the third question was the Forerunner Mr. Milton's vehicle or Ms. Heasley's vehicle? Any objection, Mr. Sharp?
No, Your Honor.
That question. Mr. Milton, any objection if that question is set?
No, Your Honor.
Okay, so I will ask 2 of the 3 questions.
Thanks for the super chats, all of you. Appreciate that. I will say he's a likable guy. He's being kind. He's being respectful. He's clearly, I believe, sober at this point. It sounds like he can be somewhat belligerent when he's drunk.
Please be seated. Folks, you submitted 3 questions.
Lois.
I've reviewed the questions with Mr. Milton and Mr. Sharp, and I'm going to ask 2 of the 3 questions.
First
Officer
super chat ever
Evers,
from Lois.
Do you
Thank
have,
you, Lois. It's an honor.
or I guess, what is your understanding as to who the Forerunner belonged to, Mr. Milton or Ms. Heasley?
Is registered in Mr. Milton's name when I ran the plate.
Thank you. Mr. Sharp, any follow-up to that question?
No, Your Honor. Thank you.
Mr. Milton, any follow-up to that question?
Thank you.
And the next question, Officer Evers, is why, to your understanding, did the friend not drive the vehicle away?
I didn't really have any. He was sitting in the passenger side of the car. I didn't really interact with him. I let that, since it was Mr. Milton's car, I let them decide that between them. I didn't know if he had been drinking with them. I don't have any information of that. So I left that up to Mr. Milton to have his responsibility of getting the car off of the property.
Thank you. Mr. Sharp, any follow-up to that question?
He speaks very quietly.
Yes.
Thank you. Mr. Milton, can you follow up to that?
No, I don't. I don't believe that anything further that I can ask will assist my case any more than just putting on a bit of a show.
Okay, thank you. All right, Officer Easers, thank you for your testimony.
Thank you.
Very astute. Astute observation by the
Sure.
defendant.
Any further testimony?
No, Your Honor, and the city at this time would rest.
All right, thank you. And Mr. Evers, do you wish to testify today?
No, Your Honor, but
okay, actually, tell you what, let's pull off on that
I heard
thought.
you just call me Mr. Evers.
Well, that won't work. Mr. Milton, do you wish to testify?
I appreciate you. She'd probably make a great wife.
Do you wish to testify, Mr. Milton?
I would,
actually, hold on. We'll have that
right.
conversation.
You already know what I'm going to say.
Folks, if you want to step back into the deliberation room, I'm going to discuss Mr. Milton's right to testify with him.
Okay, the jury's going to step out again.
May I ask the jury a question?
No.
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 All right.
Be kind. Thank you for your first ever super sticker. I appreciate that. Thank you very much.
Please be seated.
Philip, he called.
All right.
He called everyone else on their raises.
Door shuts. So, Mr. Milton, I know this is, and we talked yesterday about this is going to be confusing where you're acting in one time as your lawyer and another time as you as the defendant in a criminal charge.
Right.
So it's the testimony part where you get to tell the jury what you believe the facts are. And if you don't testify, the facts are going to be not in the form of what you say when you're asking a question. It's going to be the responses that you got and that the jury has heard. So if you're satisfied that the information has come out, that's fine. If you want the chance to say something different to the jury, it comes with me putting you under oath, you asking questions, and then Mr. Sharp can cross-examine you once you just telling the jury. I'm not going to make you ask yourself questions. You telling the jury what you believe you want to say to them by way of facts, and then Mr. Sharp would have an opportunity to cross-examine you.
Right.
And then I would give the jury a chance to ask you questions if they had any.
Right. My only concern is the concern that I brought up yesterday, which I won't digress and repeat.
Okay. So the answer then is you're choosing not to testify?
If Mr. Sharp would like to call me to the stand and ask me some questions, I would allow it, but
what?
Okay, I will rest my case as I am.
That's the exact language that would be used. Okay. So there will be no further testimony. The jury has taken a break, so now would be a good time for us to review the closing instructions. And
thank you. This guy literally
I
just
started
waived
that
his right to
process
testify,
yesterday after we
but would
concluded.
answer questions under cross.
Mr. Sharp, what we are going to need is the instruction on the defendant, in this case, Mr. Milton, not testifying.
Yes, sir. I'll prepare that and email it to the clerk.
Thank you.
Hopefully she can
So,
print it out so Mr. Milton can see it.
The reason I'm saying that, Mr. Milton, is there's an actual instruction to the jury that tells them the fact that you've chosen not to testify cannot be held against you. They cannot make any assumption based on your choosing not to testify.
Cool. Will you also let them know that I allowed the city to call me as a witness if they'd like?
Well, I'm not going to say that, but I'm going to instruct them that they can't hold the fact that you're choosing not to testify.
I appreciate that. Thank you. Yes, Your Honor.
It's going to take me a few minutes, Your Honor, to prepare that.
I understand it. And once again, we're going to be a few minutes. Teresa, you don't have to wait there. We're going to actually go to instructions.
So tell them it'll be a few minutes.
Work at Home LLC, Tina. First super sticker. Thank you very much. Okay, this guy is funny. Okay, he's really a nice guy in court, what we're seeing right here. And I realize you guys are looking in some of his record. I don't know if he's been charged or convicted in the prior record. I don't know the facts of that case, so I don't want to talk about that. Obviously, if there's animal cruelty there, that's not a good
Reminder
thing.
from yesterday.
I'm not
What I'm
condoning
looking
that in
at
any
here
way.
are the instructions on the law, and I know Mr. Sharp provided you a copy yesterday. So I just wanted to make sure you understand that. That's all I'm looking at.
I
The same
appreciate
ones.
that, Your Honor. Thank you.
The jury, all they have is the prosecution evidence. There is no
This
evidence.
is a very brief instruction. The model is
It is
6.31.
from his side.
If it's okay with the court, I'm going to send it to the clerk without
He should
citation.
have just pled guilty.
Okay. Thank you. Teresa, you're going to get a copy of an instruction if you'll print it up for me.
Should we do a straw poll?
I'm emailing.
Mr. Sharp is going to email it to you. City rested and Mr. Milton rested.
It's funny, he rests, but he wants to still talk to the jury without testifying, and he wants to be cross-examined by the state, by the city. Okay, we're going to do a quick poll.
End of this. No.
It'll be added in.
It's not looking good for Mr. Milton right now. Although it's getting slightly better as more and more people are saying no. Is it wrong that I like this defendant? He's definitely presented a likable, entertaining, lighthearted approach to this. The outcome of this, first of all, it cost a lot of money. It does. Setting a trial, think of the impact on all the jurors who had to be in court yesterday for their jury selection. The jurors that are now taking a day out of work to go to trial. The city attorney, the police officers that have to be there, the judge's time. There's a lot of this. It's not cheap. But this is a right. You have the right to do this. Okay, so we can't look at that and say you're wasting all this money, thus, we should throw the book at you. No, this right is important. Okay, this is important in the United States. This is something that everyone has the right to do. If anything from a traffic ticket all the way up, you've got the right to this trial. I think some states, the right to a jury trial might.
It's your full name with the period between first and last. It's not your old address.
What?
It's not in the outbox. It's already gone. I can send it again.
The email's not going through. I feel like he's doing this just to waste state resources like RA does with scam calls.
I also have a thumb drive in my briefcase that I could put it on to walk it up to you.
Never trust anyone with a thumb drive. Your Honor, I would not stick somebody else's thumb drive in your computer. You don't know where it's been. I'm eating mandarin oranges as well. The judge could hit him with court costs at the end of this, in addition to any fine. Generally, the court costs are very limited, and I think lower than the actual cost. Going to wrap up the poll because it's a simple one. Do we find him guilty? 87% said yes, with the ballots coming in at no. Here's what I think. If he had come in and fought this with an attorney, he might have gotten off. They might have found an error.
Should he send it to?
They could have found something that the city had done wrong. They could find an error in the document, in the trespassing document, in the instructions that were given to him, where he was basically told he could stay on the property until later and leave later. That could have been exploited a little bit or expanded in the minds of the jury. So if he had an attorney, even a court-appointed attorney with 5 minutes notice, this could have been dug into, and those little red flags would have been seen. Yeah. I do want to sort of watch his social media. He's very active on Instagram, Facebook, and YouTube, with sort of like a self-help, like awareness, kung fu, testosterone improvement techniques. He's got a lot on there, and he also shares a little bit about his court experience. So we'll see if he posts something after this is over, if he doesn't have any jail time. I don't know what the city ordinance is. It's probably a fine and or a few days in jail, up to 30 days in jail. I doubt they're going to throw the book at him for this. He was drunk, first of all. It's hard to see. Here's Ivan. Ivan's got his take on this. Yeah, it's probably right. Come to think of it.
From
Mr. Ivan.
Ivan, as soon as the judge talks, I'm going to cut you off. What you thinking?
Amen. I'm just, I'm thinking here, first of all, what are we waiting for? Are they on break?
They're preparing the jury instructions.
Okay, I gotcha. What's hilarious is I don't think he's probably even facing any time. I think
Proposed
he's
instructions.
And what's
Instruction
kinda
number
crazy
one
is
will be the
if he would have had counsel, he
three-page
had
opening
one point he could
instruction.
have rested on. That when they invited him back into the store to charge his phone, he did not understand that he was not welcome there.
Yeah.
But he just had no ability to articulate it.
Counsel could have helped a ton here. I mean, it would have been awesome. Yeah. Judge is talking and going over the jury instructions.
Okay.
Ivan, we're going to take that. Thank you very much. See you.
Bye.
Instruction number 6 is the voluntary intoxication instruction. Instruction number 7 is the instruction concerning Mr. Milton not being required to testify. Instruction number 8 is the duty of the jurors instruction, and number 9 is the closing instruction. The verdict form appears to be in proper order. Mr. Sharp, any objection to those instructions being the instructions of the court?
Just an inquiry, Your Honor. So, Your Honor, I believe the court assigned instruction 4 to the to convict instruction.
Yes, I take out your definition of criminal trespass.
Okay. No objection. Thank you.
Thank you. Mr. Milton, any objection to those instructions?
I wouldn't know what to object, Your Honor. Thank you.
You're welcome.
Yeah, that's the
All right,
point.
those will be the
of
court's
this.
instructions on the law. And we will make copies for each of the parties and for our jurors. So, and for the jurors, make 7 copies for the alternates and 9 copies for everyone. Actually, you'll need to cover. Sorry.
That's not very much.
Ouch, a year in jail and a $5,000 fine. I don't think they'll go maximum on this guy. Just because he's been nice. I think the judge is the one that makes the sentence. He's been respectful. He's tried. Whoa. They just cut the
Zach
feed.
Woodchow appearing for the state of
So we
Wisconsin.
get Judge Doro. That's no good. Hang on one second. Why'd they drop the feed? We need to know how this ends. Okay, hold tight here. Let's see what we got.
Whether if you're satisfied that the information has come out, that's fine. If you want the
Trying to
chance
see
to
if
say something
how
different
this
to the
ends.
jury,
I'm
it
rewinding
comes
this and
with
watching.
me putting you. Number 6 is the voluntary intoxication instruction. Instruction number 7 is the instruction concerning Mr. Milton not being required to testify. Instruction number 8 is the duty of the jurors instruction, and number 9 is the closing instruction. The verdict form appears to be in proper order. Mr.
Mr. Sharp, any objection to those instructions being the instructions of the court?
Just an inquiry, Your Honor. So, Your Honor,
Trying to skip ahead here. Yeah, it just cut off. Let's see if they restart it. I'm not sure if they know that it's that it crashed. Man, they can't leave us hanging like this. I'm gonna have to call a court clerk. Yep, call a court clerk. There we go. Quick search. We're looking at what? Thurston County.
You have reached the Thurston County Clerk's office. Please press 1 for District Court, traffic infractions, and DUIs. Please press 2.
Welcome to Thurston County District Court. To continue in English, press 1. Para continuar en español.
Thurston County District Court clerks are available to assist by phone between the hours of 8:30 a.m. and 4 p.m.
That's us.
Monday through Friday. The court offices and phones will be closed from 10 to 10:15 a.m., noon to 1 p.m., and 3 to 3:15 p.m. If you would like to respond to a traffic infraction, live chat with a court clerk.
What's this judge's name again?
File a civil protection order. You may do this electronically through the Thurston County District Court website. Please select from the following options. For general court information, press 1. For information regarding an infraction or misdemeanor, press 2. For information on civil, small claims, name changes, or anti-harassment orders, press 3. To contact the probation department, press 4. For all other information, press 0, and you will be connected with a court clerk.
Thurston County District Court, this is Laura. How can I help you?
Hey, Laura, this is Scott. We were watching the Court 4 online YouTube. It's a case with Mr. Milton. It's a pro se defendant in a jury trial, and the feed has dropped from the courtroom. We're trying to observe this remotely. Is there any way we can check and see if that can be restored?
Is the jury trial?
It's a jury trial I know it's Court 4. It's the Channel 4. Yeah, so I'm not sure which room it is.
I am messaging the clerk to see what's going on with the YouTube. Give me 1 second, please.
All right, thank you. How's your day going today?
It's good. How are you?
It's pretty good. It's a nice day. Though it feels like another Monday.
Every day feels like another Monday. Give me 1 second. I'm trying to see. They may be on break.
I know they were just preparing the jury instructions. So
Yeah, because she is not answering me. Hold on, I'm going to put you on hold. I'm sorry.
Oh, thank you. I need to take this offline. I can't have music. The music could get me demonetized and possibly stricken by a copyright. So we'll plug this back in as soon as she comes back on. Okay, sorry. Can you hear me now?
Yes.
Oh, you said they were taking a break.
They are
and they're gonna
taking a
live
break right now.
Do you know how long their breaks normally are? Is it like 15 or 30, 1 hour lunch break?
I'm asking her.
All right. I appreciate your help.
Yeah, absolutely. They're just waiting for the judge to come back, so I'm not entirely sure how long it'll be.
Okay, that's good enough. Thank you so much. You've been most helpful. You guys are amazing. Thanks.
Yeah, no problem.
Mm-hmm. Bye.
Yeah, you have a good one. Bye-bye.
You too. Bye. All right. Just evidence that a quick phone call and search on the internet can do you some good. So it looks like they're taking a break and they'll be back. If they're just waiting for the judge. Man. Okay. So, yeah, she doesn't know anything, says Jackie D. Yeah, it was close. Who was it? Were you the one that said, I've got some property to sell you in Utah? I was going to do a reverse prank call. That was not cool. Copyright strike for elevator music. Yes, actually the business of providing that music for hold, that's big business. There's big money in there. And yeah, they guard that very carefully. Think if you had a company and you wanted to have music that you could play that you wouldn't get in trouble for, you have to pay for that. Somebody holds the copyright. You've got to pay for that music, and people produce that for companies like this or government organizations like that. The judge took a brief break. I don't know how long it's going to be, which means we cannot take a break because he's just going to start up when he gets back, and he gives us zero warning. So for those that are following along at home, let me show you. This is the page I'm on YouTube. If you want to watch this, you can click the subscribe button, and you have to. It's Thurston County District Court. So let me zoom in right here. There we go. So it's Thurston County District Court number 4. There are 4 different courts. We're in the 4th court, and that's where this one's going on. So we have to watch for the new live to happen here. That's when the jury's going to come back and get the instructions, and then we'll be on verdict watch. And hopefully we'll have a red button. Probably not. It might be a little tricky to find out what the verdict is, unless the jury's like, Judge, don't send us out. We already know what we're going to do. Best call ever was your call from the cruise scammers when you were camping. I thought I burst out gut laughing. That was a fun one. They spelled court wrong in their handle. It was abbreviated. Yeah, this court usually does not have a lot of watchers. There were 2 of us, or 3 of us watching when it first started. But the video we just watched had 66 views. That's not very many, just by counting. It's up to 73 now, so a few people are watching that. Sending out a second match donation. Come on, addicts. Ivan, you're awesome. Thank you. Appreciate every single one of you. So if you see the judge come back online before I do, that's why I'm showing you this page. Please let me know so I can pull it up. We don't want to miss any of this when the jury comes back. Okay. Love the solar lunar panel call. That was good. I actually today, while I saved the life, I like to think that I saved the life of that raccoon. I was in the rights legally to shoot it, and the police had told me I was supposed to shoot it, but I didn't. I let it go. But I did so legally because I never was in possession of it. Anyway, in doing that, when it ran out towards the front of my house, I went out there and the postman was walking through the yard delivering mail. I'm like, just be careful. There may be a rabid raccoon about ankle height near you. So I saved his life too. Two in one day. Can you show his Facebook page while we wait? I can't. Here's the problem. Even though Facebook, YouTube, Instagram, they are social media platforms where people are putting something out there to the public for them to see. I'm not trying to out somebody. I'm not trying to put them on blast or dox them or anything like that. And because of that, I can share you his information and tell you he's on there and let you look yourself. But I would feel bad putting stuff on there that he, first of all, he has the copyright to any video or production, anything that's on there. And he could technically hit me with a strike if I shared one of his videos from his channel. Thank you, Anne and Jill. Oh, man. Yeah, what's the defendant's name? Peyton. I spelled it Peyton. What was the last name? I forget. Is it Martin or starts with an M? Milton. There it is. Peyton Milton. Payton. Peyton. I'm not sure which one. His profile pic on Facebook, which has links to Instagram, and his Instagram links to his YouTube, it's interesting. Raccoons are mean. This one looks like it's got some problems. Honestly, it's gone right now, but it might be back. Regina, thank you very much. Appreciate that. Station alert has arrived. A new station alert has arrived. News warning in my area. Comfy weather sticks around for the next few days. Just in time because I got my AC fixed. Caper 000. I took your challenge. Thank you. I appreciate every single one of you. That's awesome. Okay, we need to catch the end of this Sov Cit trial. We can't call him Sov Cit anymore. He's just pro se. He honestly, he doesn't deep in his soul. He doesn't have that Sov Cit fire that just screams subject matter jurisdiction, like Daryl Brooks had. He likes being famous. He probably does. He probably will be happy about the extra attention his social media channels are getting. He has some interesting stuff on there. I was looking on Instagram. He was talking about the benefits, the health benefits, specifically to testosterone, where it would double your testosterone level if you can sit in a sauna for 2 hours at a time, 177-degree sauna for 2 hours at a time. And he talked about how he's been able to do 45 minutes and 35 minutes instead of the 1 hour. But really, I think it just cooks you. 177 degrees for 2 hours. That's like a recipe for dinner, not a recipe for good health. We killed a garden-destroying groundhog with a bow and arrows since we were in city limits. Groundhogs are rough. They can do some damage. Kibby Girl, Super Chat Train, Choo Choo. Thank you very much. Love it. Love every one of you. Thank you so much. You sat in the sauna for the last 2 weeks. That's why I'm speaking from experience, Greeners. I'm telling you that your health is at risk when you stay in elevated temperatures like that. Yeah, I don't know if he has immediate family. And honestly, there was a concern, MCAT, toot toot. There was a concern that he might have mental stability issues, and the judge actually, as in the initial hearing when he first brought it up. Let's actually listen to that. This is the soundbite we played during the open. I think it's this one. No, that's not it. that's a different one. Wait. Here we go.
I did. No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you.
Listen.
And as to Mr. Milton, is there a competency concern, or is this...
So immediately, the first thing the judge says as soon as this guy starts going off is like, is there a competency? I mean, is this guy all right in the head? Was his first response. And the answer was, yeah, he is. I'm being told I missed a few super chats. Let's see. I do apologize. I missed Weather Watch. I missed Steven. It scrolls so fast, and when they came all together. So we had Caper, Steven. It went in this order. It went Steven. I'll scroll. Then Weather Watch, keeping it going. And then Kibby Girl. And then MCAT. There we go. Oh, and then Megan for support. Stephen. Thank you very much. Appreciate it. Amber's on the phone. Hang on one second. Amber, how are you doing?
Good. How are you?
Great. It's a fabulous day.
You turned down the buffer, and we're back on live.
Oh,
with
where?
1.99.
Okay, hang on.
Megan for support.
Where? I'm not seeing it. Oh, I see you. Okay. Thank you. We'll go there.
Good morning, Your Honor.
Bye.
No, wait.
And parties ready to proceed?
Yes, Your Honor.
All right, thank you. And
hang on.
Mr. Milton is just by way. You're going to have the opportunity, as I.
Okay, so they could just continue their old live.
You to disregard any evidence.
Okay, here we go.
Then you must not discuss that evidence during deliberations or consider it in reaching your verdict.
We're going to back up.
Do not speculate whether.
Okay, give me just 1 second. Okay, it's going to be here. Cut. Make this large. Okay, here's how we're going to catch up. We're going to watch this on 1.5 speed, just so we catch up so we don't miss anything in case they cut it off at the end. Okay. Jury's coming back in. Judge is having a little bit of water. Britta, thank you very much for the super chat as well.
Please be seated.
Eileen, appreciate that. We're going through jury instructions first here, so we're going to go fast through the jury instructions.
Folks, Mr. Milton has indicated that he has rested his case, so there's no further presentation of testimony. I'm now going to read the instructions on the law. You all have a copy of those instructions. You're welcome to read along with me as I read them, or you can just listen and you'll be able to take those back with you to the deliberation.
I'm trying to fix the view so you get a better view.
There. It is your duty to decide the facts in this case based on the evidence presented to you during trial. It also is your duty to accept the law from these instructions, regardless of what you personally believe the law is or what you think it ought to be. You must apply the law from these instructions to the facts that you decide have been proved.
I'm matching
and in
Yvonne
this
on
way
behalf
decide
of
the case.
Yvonne, agent of.
Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during deliberations consists of the testimony that you've heard from the witnesses, any stipulations, and there have been none, and the one exhibit that has been admitted during trial. If evidence is not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the clerk and given a number, but they do not go with you to the jury room during deliberations unless they have been admitted into evidence. The one exhibit that has been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during deliberations about the reasons for my rulings on the evidence. If I've ruled that any evidence is inadmissible, or if I've asked you to disregard any evidence, then you must not discuss that evidence during deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that has been admitted that relates to the proposition. Each party is entitled to the benefit of all the evidence, whether or not that party introduced it.
1 year in prison, $5,000 fine.
The credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of a witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The attorney's remarks, statements, and arguments are intended to help you understand the evidence and to apply the law. It is important, however, for you to remember that those statements are not evidence. The evidence is the testimony and the exhibit. The law is contained in these instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law as stated in these instructions.
You may have heard objections during trial. Each party has the right to object to questions asked by another and may have a duty to do so. These objections should not influence you. Do not make any assumption or draw any conclusion based on an objection. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by words or conduct, my personal opinion about the value of testimony or other evidence. I've not intentionally done this. If it appeared to you that I have indicated in any way my personal opinion, either during trial or giving these instructions, you must disregard that entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the parties may properly discuss specific instructions. During deliberations, you must consider the instructions as a whole.
Jump ahead about a minute, okay? We're gonna
As
take
jurors, you are officers of the court. You must not let your emotions overcome your rational thought process.
There we go. We're jumping ahead.
The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in the case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in the case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. To convict the defendant of the crime of criminal trespass in the first degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about March 31st, 2023, the defendant knowingly entered or remained in a building. 2, that the defendant knew that the entry or remaining was unlawful. And 3, that this act occurred in the city of Lacey. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any of these elements, then it will be your duty to return a verdict of not guilty. A person knows or acts knowingly or with knowledge with respect to a fact or circumstance when he or she is aware of that fact or circumstance. It is not necessary that the person know that the fact or circumstance is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted, but not required, to find that he or she acted with knowledge of that fact. No act committed by a person while in a state of voluntary intoxication is less criminal by reason of that condition. However, in determining whether the defendant acted with knowledge, evidence of intoxication may be considered. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict.
When you begin deliberations, you should first select one of you to act as presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 of you are present. You are all officers of the court and must evaluate the evidence with an open mind free of bias or prejudice. If during deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During deliberations, you may discuss any notes that you've taken during trial, if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during deliberations. If, after carefully reviewing the evidence in these instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out, pardon me, simply and clearly. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to Teresa. I will confer with the parties to determine what response, if any, can be given. You'll be given the one exhibit admitted into evidence, these instructions which you have, and a verdict form, or recording of your verdict. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibit that has been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form, the words "not guilty" or the word "guilty," according to the decision you reach. Since this is a criminal case, all 6 of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify the clerk. You will then be conducted into court to declare your verdict. Mr. Sharp, how much time do you wish to reserve on your closing argument?
2 minutes, Your Honor.
2-minute closing.
Mr. Sharp.
Thank you, Your Honor.
That's his final close is 2 minutes. So he gets the first half and then he gets 2 minutes at the end. I'm not sure if Peyton's even going to have a closing.
They do the whole thing. Now again, this is a pretty important process. Mr. Coleman is entitled to his day in court. He's had that now. And that couldn't happen if he weren't here. Also, let me point out that this was important because of the property rights at stake. 7-Eleven had a property issue where their rights were infringed upon in a criminal way. And so this is not only important just for Mr. Cummings, as well as 7-Eleven too. And so all this together, it's not going to be in a movie, but it's still pretty important.
It's in a movie.
So as I described this morning, you heard from 2 witnesses, and they both testified about 2 phases. That's just kind of bundling things here, but there was the earlier afternoon incident 7-Eleven about 2 o'clock when police were first called, and then the second incident later on, 4:30. The purpose of having both of those phases explained to you is that the first event really sort of sets the context. City not accusing Mr. Milton of trespass within the first one was he was notified.
He is so quiet we can't hear him. Come on. think he knocked the microphone, and now he can't. It's not even pointed at him. I can tell you what he's saying, though. He's saying there are three parts to this. They're the three parts he talked about in the opening. He was notified. He was not supposed to be there. He was told to leave. He didn't leave, and he stayed there. And it happened. He knowingly did it. He had the paperwork. It's pretty clear cut. Let's see. We got and. That's it. Prosecutor is whispering to the.
See the elements that the city must approve. 1, 2, 3. It's a little different than the order that I just gave, but it's the same material. And the city has the burden of proving each of these beyond a reasonable doubt. I embrace that burden. It's important that it be hard to prove the crime. The evidence needs to be substantial. This case is pretty clear. They'll submit that there's not a reasonable doubt. So I'll just really quick kind of review what facts pertain to each of the elements from what you heard this morning. So the first one, that on March 31st of 2023, stop there. You heard two witnesses ask about what happened on that particular day, and then they relayed the information of this. So it's pretty clearly established, and no reason to doubt this occurred on that. Next, that the defendant knowingly entered or remained in the building. Here, he's accused of entering that building. Specifically, it's that second. It's after the police left, after he was given that warning. So he's alleging that he knowingly entered the building. We heard from Ms. Heasley testifying that he came back in. He again brought a cell phone with him, putting it up on the counter. That he, at that point, was again basically conducting himself in the same way, shouting, something customary. We heard about a confrontation with an elderly gentleman that was in there, and that got pretty contentious. You heard about him throwing a fit, sitting on the floor, refusing to leave the store as asked, forcing him to basically call the police again to intervene. Second element, the defendant, Mr. Milton, knew that the entry or remaining was unlawful. How could he not have known? He was told over and over. He was told by Ms. Heasley at the beginning, when she started reasonably with him, okay, you believe. That's not, you can't swear at me. She said that she tried multiple times. Other staff there with her also tried. Got him to leave finally. Also, Evers testified that she made it very clear to him not to go back in that store. He not only told him, she gave him written instructions about that. You're going to have a chance to read this form in its entirety. He makes it plain as day. He's not to go there, and if he does, there's a specific law that violates. As Officer Evers mentioned, she wrote acknowledged in the sign. I want to point this out because I could see it being signed. She explained why she did that. Because of his behavior, and she has to be concerned about personal safety. Why hand a pen to someone and that could be used as a weapon? There is aggressive behavior happening, unpredictability, intoxication. So this is a procedural thing. You know what? I'm going to tell you that didn't matter. Let's look back again at instruction 4. Number 2, the defendant knew that the injury or remain was unlawful. Is there anything in there about a form? So I don't see anything saying that the city was required to give Mr. Milton a form, Mr. Milton was required to sign a form, or anything like that. We just have to prove that he knew that entering that store was unlawful. Okay. Now this form, this sure is a nice tool, right? This makes it very clear to Mr. Milton what the expectations and parameters of the behavior were, what the potential consequences of going outside of those parameters would be. And it also makes it very clear to others like us that he was aware of what the situation is, and that wasn't going to be acceptable for him. So I'd suggest taking this form as a beneficial tool, keeping in mind that it's not actually required. It's not in that jury instruction. There has to be a form involved at all. Finally, and this one's kind of a no-brainer, that this act occurred in the city of Lacey. We heard Jessica Easley testifying that she works at the 7-Eleven in Lacey. We heard Officer Beavers testifying that she controls the department for the city of Lacey. She's the responding officer at the logical. Asking again to flip some pages here and go to instruction 2. I had mentioned that the city has the burden of proving these elements beyond a reasonable doubt. And I embrace that burden and we think it's been reached. This is the instruction that explains what that means. You heard the judge explain it a minute ago, so I'm not going to belabor the whole thing. I just wanted to really hone in on that third paragraph. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. So there's a reason. There's a foundation for it. There's some sort of cause for that doubt that's logical and that arises from the evidence or the lack of evidence. We're working within the parameters of this evidence. And, I think during jury selection, Drew was talking quite a bit about how that happened for her in the trial. We get a ton of things, so I appreciate that. I think in advance for working within the evidence. I want to address really quick the intoxication. There is an instruction in here. It's number 6, and it's a pretty brief one. No act committed by a person while in a state of voluntary intoxication is less criminal by reason of that condition. I would invite you to agree with me on this. I read that as saying, you don't get a freebie just because you got them. You don't get to go consume alcohol and have a license to do whatever you want, treat people however you want. It doesn't work. There's a second sentence here that's important today. However, in determining whether the defendant acted with knowledge, evidence of intoxication may be considered. That's super important because knowledge is at the core of this case, right? Did you know who's going in that building? Did you know who was supposed to go in that building?
The 2 minutes he's reserved are for the very end after Mr. Milton goes.
Zero in on this and submit to you respectfully that he certainly knew what. Not so drunk that he didn't know. Heard Officer Beavers explaining her background, her formal training, and then her experience on the street dealing with people with various levels of intoxication. She had specific signs to look for and ways to gauge how that worked. She explained to you that she observed Mr. Milton getting out of the vehicle, standing on his own 2 feet without assistance. He was able to walk over to the police car to get into that without any help. She recounted for you a fairly complex conversation today. Now, while he did repeatedly assert that he was too drunk to help him out, she did mention that when he had an idea of success, there was a productive dialogue. She didn't give any indication that there was any sort of confusion or inability to understand on his part when they were having that conversation. I mean, think about that whole thing with troubleshooting in a car. He's not allowed to be at 7-Eleven, but his car is there. He can't drive it. What do we do about it? As she explained, Mr. Milton came up with the idea. Hey, how about if my friend and I push it about 25 yards off the premises to the next lot over? First of all, I want to point out, it wasn't Officer he was just being super reasonable about that. Yes, of course, that makes sense. I'll give you some time to figure that out, okay? But what that's really showing us here is that Mr. Milton did have the clarity of mind to work through the sort of processes that would allow him knowledge of his restriction for doing that. So he demonstrated logical thinking, right? And with a problem, he on his own offered a solution, negotiated that with the officer. Is that a person that's too drunk to know what's going on? That's not the time. That conversation, with him understanding that his vehicle needed to be somewhere else, that implied an understanding of his ground. Implied he knew he couldn't have his vehicle there forever, or there would be some sort of consequence, right?
That's the same thought process involved in knowing the good doing the soul. That there was a parameter, a limit, and if you pass that limit, there won't be some sort of consequence. So, all this together, I would submit to you that while he repeatedly told the officer that he was too drunk to be held accountable, suppose I'd ask you, was he too drunk to be held accountable? Is that a thing? Cherry on top of this argument, a person that immediately on the scene repeatedly would say, I'm too drunk to be held accountable. Is a person that's too drunk to be held accountable able to say, I'm too drunk to be held accountable? Wouldn't a person too drunk to be held accountable be too drunk to be able to say that, to formulate a complex thing like that? That's a question for you to answer.
That puts a cherry on top. This is clearly a dessert for this DA.
Mr. Sharp, you are entering your reserve time.
Thank you, Your
Honor. He has 2 minutes left.
Close of arguments here. I'm going to go back and I wish you luck in your deliberations.
Thank you, Mr. Sharp. Mr. Milton.
Here we go. Let's see if he becomes a Sov Cit now. He hasn't up to this point. Oh, please, we want to hear this.
I recall that March to get my vehicle to the other side of the tree line. We had gone to assistant manager, I believe. Started to go get my gas. Definitely took about 6.
Your Honor, objection. Again, I'm so sorry to interrupt, but Mr. Milton is introducing evidence, in other words, testifying while he's not under oath.
All right. Jury's to.
Oh, are you not under oath?
Okay, hold on, Mr. Milton. Jury's been previously instructed to consider the facts only as provided through testimony.
I was under oath. I'm not a witness. I'm not allowed to testify as a witness, and I'm not an exhibit.
Your Honor, objection. That's a misstatement.
All right. I'll let Mr. Milton go ahead.
Appreciate you. I digress. Phone was not mine. It has been asserted this entire time that it was. For whatever reason, that seemed imperative to him. I was instructed by the management at the time. We did not have time to stick around. Selling anything. Specifically, you're right. That I don't speak with Jessica and get her. I guess I'll close with, if I was one of your children, would you feel like the police did a good job or a bad job in this case? Finding me guilty or not guilty?
Thank you, Mr. Milton. And Mr. Sharp, you have 2 minutes left in your.
Please just waive your 2 minutes. Just waive it and sit down.
Your Honor, as a procedural matter, I suppose the city would move for clarification for the jury on Mr. Milton asserted that he didn't have the opportunity to testify.
Here, which he did, but chose not to.
May I, Your Honor?
No, we don't need to get into any more on that.
Okay, sure. I merely wanted to ask if they were presented with the same concern that I had yesterday.
Jury's only heard what they've heard today.
Gotcha. Appreciate you.
Sure.
So, ladies and gentlemen, touch on indication.
If only someone would invent something that would allow us to capture the audio from a courtroom and carry the sound over the internet to our ears. And then teach this lawyer how to use it and talk into it. Because even though he's pantomiming to the best of his ability, it's off the camera. He's giving his 2-minute synopsis here. This is his 2-minute drill. He's delivering right now. It's great. It's epic. He practiced this all night in front of the mirror. I realize this might be the smallest case that his office has to handle, maybe this decade, and he's the lowest person on the totem pole. But he was assigned this job, and by gosh, he's going to win this case. he's given his all. What was the concern from yesterday? The concern from yesterday was something that was in what we heard this morning, because that's all that happened yesterday. Where everyone's just like, just give us the verdict. The jurors are like, I've already marked the verdict box for everybody. You all good with this?
Not under oath, Dan.
He's not. Thank you.
Thank you, Your Honor. I will take.
No. City always goes last because they have the burden of proof. You don't have to prove anything.
Oh, okay.
Okay. Folks, you've now heard closing arguments. You're going to retire to the deliberation room. You're going to select one of you to act as presiding juror and then deliberate on your verdict. When you've reached a verdict, you'll just notify Teresa and we'll bring you back into court to declare your verdict. Juror number 7, this is the point where you separate from your colleagues. You can just stay right where you are. We're going to send the other 6 back, and then I'll have a short conversation with you. Okay, folks, if you'll...
Do you have any questions?
No, at this point, we're done with any fact gathering.
He asked the jury if they had any questions for him. He's like, he does not, he's never watched a single Judge Judy even. He has 0 experience with the court system. So warm up for Sarah Boone. This guy, unfortunately, he became a Sov Cit.
Juror number 17, it's always a little awkward. You know, we ask you to give us all your time and then you don't get to stay to conclude your service as a juror. So we really appreciate it. You know, the one time we choose not to do it, I'm sure we're going to lose a juror and then we're going to wish we had an alternate. You have no further obligation. You are welcome to remain if you wish to find out how the case turns out. These proceedings are being live streamed on YouTube, so you can also get on our YouTube channel and find out that way, or you can just contact the court and we will be happy to let you know what the end result is. But you have no obligation to remain with us, and I want to thank you for spending the last 2 days with us and sitting through the trial, and hopefully gives you a good understanding of the importance of our citizens being willing to do so.
And the importance of having a lawyer.
Thank you very much. Thank you. Yep.
Dude's like, do you mind if I just take a seat here and watch the rest of this train wreck?
Did you turn a cell phone into Teresa?
I did.
Okay, let's make sure you don't leave without it.
No.
Okay, she'll be back. You can't go back in there now. She'll be back out in just a moment.
Okay.
So we'll have her give you your cell phone.
I think Milton wants to go talk with the jury.
Free to go take a pee?
Yes, you are indeed.
Beautiful.
Okay, yeah, just wait a couple of minutes, Mr. Melvin.
Oh, gotcha. Oh, no. Gotcha. She was talking about me. 5 days.
Apparently the free water is just a little too much for this long court. Mr. Milton needs a quick break. I know. I think he saw the writing on the wall and he's sprinting. What if he never returns? Free to take a pee. One of the great freedoms enshrined in the Constitution of the United States and in every constitution across the land. No, that's not one of them. But I don't know. I wish that if Milton had strongly held beliefs in some of the things he's espoused here, especially when it comes to sovereign citizen, I'd like to talk to somebody who really and truly believes that and can respectfully hold a conversation like Milton has been able to. Now I realize he is in over his head when it comes to the legal system, and it is confusing. Any one of us, had we not, watched true crime over and over and over, would be, Like, what happens now? Why does he talk? When is it my turn? When do we share this? How do I get evidence into court? There's a ton of things that's just difficult. The court system is not designed, unfortunately, and I think it actually should be, but it's not designed for the layperson to just walk in and be able to represent themselves. I think that's a shortcoming in our system. Mr. Milton has done a good attempt.
Catherine, clear, Teresa. Okay, Mr. Milton, you're good to go.
Thank you.
So to speak.
So to speak. It's like, bailiff, watch the door. It'll be interesting to see the I don't know. Is it a Law Talk with Mike raid? Are you serious? Oh, that's awesome. Welcome, Law Talk with Mike, friends. Mike is awesome. I don't have a screaming goat. I have a screaming pickle, which I have to say I got mine, I think before Emily got hers. But I'll have to get a screaming goat in honor of Law Talk with Mike.
Do you just have one?
Yes.
Okay.
Defendant is running to the bathroom and possibly running for his life right now. He may be like out of the building and headed down the street. And I don't think he was in custody, clearly, because
Sir, thank you very much.
His uniform is a little less than what the court normally has convicts wear or inmates wear. Please invite him on the show so we can ask him what I learned in court. The only question I think he could honestly answer that would be beneficial to us is if he felt now that it would be good to have a lawyer. That's it. That's the only thing we learned. We watched there. He wasn't really a Sov Cit. He said he was. He professed that immediately at the beginning. He did the whole "my name in capital letters. That's not me. I'm an agent of the person whose name you've read, but isn't that person because of the capitals." He's had a little bit of Sov Cit in there. It's like he, earlier this week, discovered something about Sov Cit on the internet and read it up a little bit, printed off one page, and he went through his script, and now he's done. He doesn't know there's more to Sov Cit, like actually believing the things you said. It's not there. So really, this was just pro se. Come on. You're really going to... Why do they keep cutting the feed? They cut the feed. It's going to be like a six-parter.
Turning my grandma coming.
There's Mike. Law Talk with Mike. Now my algorithm goes to Law Talk with Mike when we're done instead of Judge Doro. Oh, let's see. Ivan, how are you doing, my friend?
To accept, press 1.
Oops.
To send a voicemail,
Helps if I
press 2.
hit this button. Ivan, how are you doing? I was talking to the machine before I picked up.
Yes, I have just one major bone to pick here. So, does anybody really think this guy was able to assist in his own defense? I know he's funny. I know he's entertainment. Believe me, I've been laughing off my chair here. But just because you can say you understand, just because you can read the form and sign your name or sign your agent of or sign Dog Dabani, whatever it ends up being, okay? Just because you can do all that formally, I thought the standard was assist in your own defense. He's done nothing but hurt his own defense. And
right.
So at one point...
But he had the capability to. The fact that he didn't...
What does that mean?
He has knowledge. He understands now. I mean, everything that explained to him, he understands. He's like, oh, okay, Your Honor, I'll be respectful. Okay, this is when I talk. All right.
Yeah, after the fact.
He's learning. The fact that he didn't take the opportunity to find out how to do it, that's his problem.
I don't know, man. I guess I just have a different standard. Like, I have to know that you understand how this is going to go. Like, the judge did more than he absolutely is required of, certainly, and maybe even allowed to. That's a different conversation. But, like, I mean, just because you can read the form, just because you can shake your head and acknowledge and give a charismatic response or rebuttal, I don't know that necessarily tells me that you can assist in your own defense. I don't know.
Yeah. Here's what I think. I think mentally, he has the capacity to learn. He has the capacity. Much more than many other defendants we've seen. He didn't use it. He had no knowledge to work with. His hands. It's not that his hands were tied. He just didn't know where to look. Somebody give him a little law book, a little 101, law for dummies. Okay, and he flipped through that for a day or a week before trial, just so he knew the process. just so he knew how to subpoena witnesses, so he knew how to submit evidence and the proper time for when, he gets to testify and how to, it was critical. He had zero witnesses. He should have been on the stand. Okay. What does he have to lose?
And that's what I mean. Like, so he doesn't even seem to know like the prior or proper timeline of the court or like the proper procedure. So if a guy doesn't even understand how the court proceedings work, I understand it's a constitutional right. Believe me, everybody in the comments, nobody is more of a constitutionalist than Ivan. If you've heard me for 5 minutes, but my point is the only time you can refer to that is if you're able to, of a mindset. I don't know. It's just, like I said, I've been laughing like everybody else, but at the end of the day, I have to ask myself, does this guy really know what's happening right now? Because it doesn't seem apparent one way or another.
I think he's aware of what's going on. I don't think he's high. I don't think he's drunk. I think he's there mentally. Just watching.
Me neither.
Watching well we had.
I feel way better. I feel way better if he had a 6-pack in him right now. At least that would make some sense as to why he's acting this way.
I'm not sure what the verdict time was. I think this is about right. Is that 4 minutes and 12 seconds, roughly? I don't know. We're guessing on the verdict time. I don't know. Ivan, here's what I think. I realize I'm with everybody else on this is your right. It's enshrined in the Constitution that you have a right to defend yourself. You shouldn't have to trust your defense to someone else if you want to do it yourself. So he has this right. That's all cool. I think he has the ability to learn. Watching his videos on some of his social media while this was going on, I was perusing through that through Instagram, YouTube, Facebook. He's got some intellectual capacity where he can learn. He's got he's got big words and he knows how to use them in some cases. So I think he could assist in his own defense. He just didn't know how. And this is great for someone to learn by in his case, I believe he has a prior record. He should have paid attention the other times he was in court, probably some of them with a lawyer, just so we could follow a little bit and understand the process.
But none of that can be considered with the court case at hand. You know what I mean? Like nothing on the social media, nothing. I'm just talking of the behaviors he demonstrated in court on this case. That's all.
The judge talked to him three times and explained this to him. Said, "Hey, I'm not going to be able to help. Are you sure?" He's like, "Yeah, I'm good with that." So, I mean, at what point are you going to say, take that right from him because he's not going to use it appropriately, and it will harm himself?
Yeah. But, I don't know. It's a weird one. I just don't like. Yeah, I don't know. What's crazy is like. They never give the maxes on these misdemeanors. It's just not how it works. Like, if he does any time, I'd be amazed. Probation, community service, XYZ. He may get 30 days.
He might have time served already, and before he got out on bond.
Right.
And stuff, so.
Like, it's just not that kind of case. Like, even though he did make threats, and believe me, like, if he tried to pull this crap in Wisconsin, it would have never flew. Like, even if I wouldn't have been at the store, like, the cops would have arrested him on demand. There would have been none of this, like, oh, don't come back. Like, that would have never happened. Like, so it just amazes me it got to this point in general. But, so anyway, right on, man. I'll let you fly.
Thank you, Ivan. Appreciate you. As always, good talking to you. Thank you, Samantha, for sharing.
Have a good day, guys.
We'll see you, Ivan. Have a good one. Amanda, thanks for sharing the link to Law Talk with Mike. Mike does follow cases like this on a regular basis, and he has his take on this. I think he was live today with this one as well. I think Mike has like actual lawyer stuff to do today, so he's probably won't be able to follow the actual verdict. He'll probably catch it on the replay or something. But it's fun to listen to that. But really, the right thing for this defendant to do, which would have cost him nothing. It could have saved him a great deal of headache and us a great deal of frustration and the jury a great deal of headache, is hire a lawyer. Hire a lawyer. Better yet, have the state appoint one for you because it doesn't cost anything. It was offered. The judge says, even right now, right before your case is about to begin, later, tomorrow in the next 24 hours, I'll appoint a lawyer to you. I'll do that. And he turned it down. and with disastrous consequences. He ended up going to court in front of a jury, having no evidence, no witnesses, and no testimony, and nothing prepared in the form of statements. He didn't even have questions for the juror questionnaire. He had zero preparation. So either he took this whole thing as a joke, or he, I don't know, maybe there's something wrong upstairs. All right. Matthew Harris Law. He could have taken a couple of Matthew Harris's quizzes. Speaking of quizzes, we've got a poll going right now in chat that we're going to wrap up here about jury deliberation, because I think we're about to the end of that. Let's see. The poll was, how many minutes will jury deliberation take? And 6 to 10 minutes was the winner. I think we're still in that slot. 2 to 5 was 25%. Jurors saying, can we at least get lunch, was 24%, and less, 1 minute, only 6%. So I think we're about 8.5 minutes roughly is our time, currently on the verdict watch, but I forgot to start it. It's not quite over. The jury's deliberating, and how long they take, no one knows. Let's see. Is it live again? I don't see anything live yet. Yeah, it looks like 9 minutes ago they stopped the live stream. So we've got about 10 minutes of deliberation time in right now. Anna, thanks for clicking the subscribe button. Good to have you here. You're among friends now. You just can never leave. It's like Hotel California. Mom's Wholesome Videos. You have to be deemed competent to understand, not intelligent enough to make the right choice. Right, and that's what the judge has his hands tied. At one point, he says, look, if there's any indication that this guy isn't all there, that he can't make his own decisions for himself, or he can't make the best decision in his own best interest, I'm going to step in and say, no, I'm not going to allow it. And he took 3 chances to talk to this guy and say, Mr. Milton, look, here's what I recommend. It would be in your best interest. This will serve you best. And the guy was adamant, no, he wants to represent himself, and even went so far as to bring up the pro se side of it, which is really frustrating for a judge because it's nonsense words that don't work in court. It's literally like trying to plug in a European outlet to an American plug. The two are not compatible. You can't get power from one to the other. It takes an adapter or a lawyer or something to go between to make this work. And so when he brings up that terminology and says, I'm pro se, this I'm my own person, I'm my own man, it makes it even more difficult for the judge to do anything. It sort of ties the judge's hands, and he's like, all right. Just like Darrell Brooks, you've convinced me. You've convinced me. You're going to go down in flames, and you want to be the pilot of your own ship when it happens, and they'll let him do it. It'd be hilarious if they found him not guilty. How embarrassing, Maddie, would this be for who was it, Mr. I forget his name. What's the DA's? It escaped my head. It starts with an S. How embarrassing for him if he literally the office. They laughed at him, first of all, when he went to court this morning. There's 100%. Everyone in the office was chuckling under their breath. Somebody put a sticky note on his back, because he had this case, right? He had the Milton case, and he's going to go face that. And they're like, good luck, hope you really bring your A game for this case where you've got a pro se defendant who doesn't, Sharp, that's it, Michelle, thank you very much. Matt Sharp. The office is laughing at him. He's got to be the smallest guy, lowest guy in the totem pole to get handed this job. And if the jury turns around and just says, we were just struck by the long flowing hair and the curls and the sandals, and we just my heart resonated with this dude. We were beating in time. We're on the same page, and we think he just deserves to go free, and lets him go. How embarrassing as this Mr. Sharp, comes back through the door of the office, tail between his legs, and he's like, guys, I tried. I did my best. I even the full 10-minute closing, and I had the jury in the palm of my hand, and then they just went rogue. I object. Red pen. I have never seen a defendant so enthusiastically object We even had the arm motion. I object. You know, that he almost came up out of the chair, and it was great. And we had a couple of them. Let's see. I'm hoping he comes back from the bathroom. I really do. If he goes missing, we might never know what happens. Okay. Not live yet. I know Judge Stephanie Boyd is live. We're tempted to go down there, but I want to be able to jump in on this as soon as it happens. Hey, little RA, how you doing? I see you peeking in the door. Okay. We've got 14 minutes of deliberation in. Brandy Hernandez, thank you very much. Welcome to the gallery. Good to have you as a member. You are one of us. One of the perks of being a member is you have reserved front row seating. Yes, we reserve front row seating just for you. You can type !seat in chat, and we'll go ahead and escort you to that front row. There will be nobody obstructing your view except for the attorneys, the defendant, and possibly a few exhibits. Want to be able to type in object and say, I object. Please make that a soundbite. Red pen, I'll do that. That'll be my goal for today. I still have to do Homestead as a soundbite because we want to support Sarah on her YouTube channel, the Homestead to Hardware channel, which is I'll be doing a live stream for, I believe, on the 12th. I'm super excited about that. I'll have the live view going on her channel, but I'll be filming for that as we go live on the hardware store. It's gonna be fun. We might even film the cows. We'll go out to the ranch and maybe film the cows. It's gonna be fun. Anyway, so we got to do Homestead and we have to do I object. We'll make that a soundbite that you all can control. Okay, so I have to make a note or it's not going to happen. I made notes of the last thing I was supposed to do and that didn't happen though. So I'm going to need reminders. I object. Soundbite. And we also need Homestead. Okay, link. There we go. Okay. Not Daryl Brooks. We've had enough. We've got so many. We already have subject matter jurisdiction from Daryl Brooks. We've got
Are we going to address subject matter jurisdiction?
We've got that one. Let's see. We also have. I forgot which is the other one from him. Let's see. I don't recall, but I think we have.
Are we going to address subject matter jurisdiction?
We have that one. I thought we have another one from DB. But I don't know. Okay.
Bring the jury.
Bring the jury. That's a different one. I'm getting notes from Amber. Thank you, Samantha, for putting this up. Sarah, if you like homesteading, if you like gardening, if you like the idea of having cows out your kitchen window, Sarah, who's absolutely amazing, you're going to love her once we get her on the channel. She'll be on her channel. I'm working sort of as a consultant for her and her company, where she started a hardware store in my little town. The best hardware store in the world. Just, you'll never get service like this anywhere else. And anyway, if you like that, if you like watching Brahma cows and everything else, subscribe to this channel. It's going to be a blast. It's brand new. It's just barely going live, and we're just getting it set up. She's got huge plans for it. It's going to turn into a chase stream. We had a chase earlier. We got the FOIA request back from Utah. We did the live police, well, not live, but we watched the helicopter with the FLIR, the infrared, the thermal imagery that chased the car down there in southern Utah. It took forever. It took like a month to get that information request back, but they finally sent it to me today, so we watched that already. Okay, I keep thinking I'm getting messages and it's yours. I turned the sound off a little bit on the phone, so it shouldn't be dinging anymore. Okay, we're staying glued to the screen here to see if the jury gets their work done. They're about coming up on 18 minutes of deliberation right now. Let me see if I can put the counter on the screen for you.
Squirrel.
I can do that. Here we go. Super source, box sources. Box 2 is going to be camera 4. There we go. Okay. So here's our counter. There's our verdict watch, and it's approximate as far as the time they've been deliberating. Not back yet that we know of, but we're keeping an eye on it. The judge is just going to go live when they're back in court. Oh, here we go. Here we go. Here we go.
I was kicked back, taking it easy.
We're going to be on camera 8, 7. Just 1 second. Give me audio.
Your ears at the range.
Oh, yes.
He's back from the bathroom. I think people are just talking.
Is that correct?
There are variables. We'll see what the judge has marked. If that happens.
Trying to get the live stream feed. Just 1 second. I mean, here we go. We want to take this.
My hearing is already shot.
Uh-oh.
It's a hot mic.
Yeah, my hearing is already shot.
There we go.
I did welding and shooting previously before my job without earmuffs, and now. And then I read a thing where like bad hearing can lead to can possibly lead to dementia.
What?
I don't have bad hearing. Mine was from playing in garage bands as a teenager.
Oh, nice.
This is Washington, Seattle, Washington.
Ear protection. Get your ear right down next to the amplifier, right next to the drum set.
Yeah, my
Back when young and invincible, you know.
Oh yeah.
This is the
Officer Rosa. She has
police officer,
a hearing aid that she wears,
and the prosecutor.
Yeah.
and I'm like, man, maybe I should get my hearing checked.
We're lucky we have the technology to kind of compensate. Unfortunately, you know, you can't treat or cure that kind of damage. However, I think there was recently some breakthrough with it. I saw a headline. I didn't read the article. Some sort of like DNA based treatment for that. That would be awesome.
Crazy. Now you can hear.
Because it'd be so cool if they could treat, you know, lost senses. Like,
so this is the
see again.
Prosecutor talking with the witness, the police officer witness.
That'd be super.
Regina.
I already did that. To develop like glasses.
Yeah.
It wouldn't be too far off. I need to get that the surgery for your eyes.
Which one? LASIK?
Yeah, LASIK. Some people I've heard it doesn't work.
Yeah. There are some downsides to it too. For example, if you are nearsighted and you want to correct farsightedness, you can do that, but it'll mess up your nearsightedness.
Oh no!
So then you need reading glasses.
Oh,
right?
I
It's
didn't
like you
know
can switch. Yeah.
Oh, that would suck.
Also,
That's
if
what
you so permanently stabilize, but there's a probability that if you get it, you'll be fine, but it'll fade away and you'll end up back. I don't think you can do it twice.
Yeah, that's what happened to Officer Scott, his wife. She got it done and then said like 3 years later.
Oh, that's fast.
She was already like the same.
I ended up not doing it because that was too risky. I looked into it and they're like, well.
And with how much you read up close to it.
Right.
I'm just impressed that he came back from the bathroom.
Contacts isn't bad. Not bad though.
Yeah, as long as you're up on your hygiene and all.
Here we go. After 23 minutes of deliberation. See if they have questions.
You're back on the record. It's my understanding that the jury has reached a verdict. We'll bring the jury in.
They barely had time to elect a foreman. There's our defendant. Open shirt. I'm not sure what it says on it. It's the same one that was in his video.
Please be seated.
Facebook video.
Folks, it's my understanding that you all have reached the verdict. Would the presiding juror rise and read the narrative portion of the verdict form, please?
We, the jury, find the defendant, Peyton Ansley John Milton, guilty of the crime of criminal trespass in the first degree.
All right, thank you. And Teresa, would you get the verdict form from juror number 1?
That was quick.
Thank you.
I'm not surprised. They had nothing else to do. All the evidence was that he was guilty. He presented no other evidence.
Members of the jury, I'm going to ask each of you 2 questions, and if you would each answer those questions, please. Juror number 1, does this reflect your personal verdict and also the verdict of the jury? And juror number 2, is this your verdict?
Yes.
And that of the jury? Juror number 3, does this reflect your verdict as well as that of the jury? Juror number 4, is this your verdict and the verdict of the jury? Juror number 5, is this your verdict and it's also then the verdict of the jury? Thank you. And juror number 6, does this reflect your verdict as well as the verdict of the jury? All right, very well then. I will accept the verdict, enter finding of guilty on the charge of criminal trespass, first degree, based on the jury verdict. Folks, that brings to a conclusion your obligations in this case, and you've been at it now for a day and a half, 2 days basically. I know you had to give up this day too. So I want to thank you all very much. Much like I spoke with juror number 7 before he departed. We really appreciate the time that you've given this case and the attention you've given this case. And as I said yesterday, hopefully it gives you some sense of how important it is to us in the system to have members of our community come in and willing to be the fact finders in these disputes. So it's very important. You can't operate without it. And we really appreciate the commitment to do it. So thank you very much. You have no further obligation. We are going to proceed to sentencing in this matter. If you want to stay where you, to hear that, that's fine. You can just stay seated exactly where you are. You have no obligation to remain for sentencing. If you want to get on with your day, like lunch or anything else, you may do so. Teresa has the phones to return to you, and you have no further call back during this jury term. So once again, on behalf of all of us, thank you very much. So we'll proceed. If you want to stay in the courtroom, that's fine. Otherwise, just feel free to depart out through the deliberation room.
It was 23 minutes of deliberation.
And Mr. Sharp, based on the conviction on the criminal trespass charge, is the city making a motion to revoke the deferral on, or the continuance on the assault charge?
City's previously made that motion, Your Honor, and yes, would ask that happen today.
All right.
I've emailed the report to the clerk.
If I may, Your Honor, I did put in a motion to suppress that, and I was not denied the motion, but I was not told it was accepted either.
Right. And nothing had happened, and the city was waiting to find out what happens on the criminal trespass charge.
Right.
So did you provide the police report on that to Teresa?
It should be in the clerk's email, Your Honor.
Okay, thank you. All right. So one of the conditions of the continuance on the assault charge was that there be no further criminal law violations.
Yes,
and let me just, I want to check one thing here just to make sure.
So he's in violation of that. That could mean the penalty is bigger than he was expecting. Judge is reading the records to the actual ruling of that continuance.
Looks like the continuance was entered on the 22nd of March, and then the offense date for the criminal trespass charge was the 31st, so it is a subsequent conviction. So, Mr. Milton, one of the conditions of that continuance that you entered on the 22nd of March was that there would be no further criminal law violations. With the jury's verdict today, there has been a subsequent criminal law violation, which means
forced to sign it under duress, but yes, go ahead.
Yeah, which means that the the continuance on the assault charge is revoked. And Teresa, you'll need to print up the police reports, which Matt sent you, or Mr. Sharp sent you.
They all left.
Okay, thank you.
They all left? All the jurors left? Yeah, it's time to ask for a
And
lawyer.
criminal trespass is a misdemeanor or gross misdemeanor?
First degree, Your Honor, is a gross misdemeanor.
Thank you.
That is pretty gross. Yeah, the DA can walk out with his head held high. He didn't lose this case. He says he signed that agreement, this continuance, under duress. I don't think the woman in back is the bailiff. I think she might be a court officer, or maybe an observer. Yet he says 90 days and 1K fine. It depends what the assault charge has attached to it. Because now he's got both charges. He's got the assault and he's got the criminal trespass. There are going to be penalties for both of them. And that is why you need a lawyer. I think the last 2 minutes changed my... Yeah, I wasn't made up until that last little bit there, Adam. Yes, that he's become a Sov Cit again. Signed under duress means I was forced to do this, which you can't hold me to anything I signed because it wasn't willing. You made me do something I didn't want to do. Ed, this is cruel and unusual punishment. I'm not sure if he wants to go to jail. I don't think he does. It's interesting because his whole take on this case, this trespass case, he was more upset about not getting this phone back, and the fact that his accounts of what happened with the phone were different than their accounts of what happened with the phone. Because his friend was mad at him because it was his friend's phone, and apparently he says he went back and got it like a week later, which would be, or his friend went back there and got it a week later, and the cops say they gave it to him the day of. Not sure which was which. Riley, they are very, very entertaining at times. VC, this trial, believe it or not, up in Washington, it's in the state of Washington, they are still operating under their pandemic protocols. That's why the seats you have in the background are spread out. They're not doing masks. They've got rid of the masks, but they are still operating under that. They have not changed because they say we're mindful of some people are still very cautious about that. And so we're catering to the people, to the few right now, who are very cautious. Just ripped my leg open, kicking my desk. The 90 days and 1K is max for trespass, not accounting for assault. Judge is doing his judge work right now. Probably checking the statutes for the penalties, doing the math, seeing what his options are, reading the priors, seeing how it lines up. Sarah, it is a conference room. It's converted because the courtroom would force people to sit all together. And so the whole reason they're using this room instead of the other courtroom is because they're following their pandemic protocols still.
Do the police report. Stating that on the 15th of March in the city of Lacey, officer responded to a call for an alleged assault, speaking to Mr. Nathan Clark, who said that in the course of a altercation between he and Mr. Milton, that he was bitten by Mr. Milton on the nose, causing injury, and Mr. Milton indicated to the officer that Mr. Clark had pushed him in response. Mr. Milton pushed Mr. Clark to the ground and bit him on the nose. Based on those facts, I will find Mr. Milton guilty of the charge of assault.
Excuse me, Your Honor. Will you please read the entire report, please?
I did. I read the entire report. I see that the officer indicates that he thought Mr. Nathan was the instigator of the argument, but that you elevated it.
Do you have the statement from the witness, Mark, who was being assaulted by him?
Right.
Was it put in the statement that Nathan had a knife? Those are the two things that I want to know.
He bit in self-defense, apparently, of a third party.
The city will concede that there is a statement in there and that the SOC called for the court to examine the materials provided during discovery. That would include this statement.
Yeah, and I'm reading it now. Thank you.
This judge is regretting never taking this case. He's like, I could have called in sick. Could have called in sick. Yeah, it's not over yet. Just because the jury's left the building is all enjoying their sandwiches. We've got more.
Mr. Michelle, I guess Mark, doesn't say anything about a knife, but he said that somebody, he didn't know Mr. Clark's name, came up and Mr. Clark had been harassing Mr. Bushell previously, and that Mr. Bushell had told Mr. Milton this, and that when Mr. Clark got on Mr. Bushell's face, that he says Mr. Milton acted instinctively to protect him. So that's what Mr. Bushell's statement indicates. Do you want to make an argument, Mr. Sharp?
Sure. I think the city's inferring that Mr. Milton's asserting defensive other there.
Correct.
The city would submit that the defensive other has to be performed in the face of imminent danger to another, as well as has to be proportional. And the city would argue that it was premature in this instance. There was no.
I'm gonna come to you in a moment.
Appreciate you. That there was no clear indication that harm was imminent. Sounds like there was a verbal argument of some sort. That alone would not justify use of force in defense. Additionally, I think that would speak to the proportionality as well, and that there was no force presented, but force was used in reaction, and that city would submit as inappropriate.
All right, thank you.
Not protected conduct.
And Mr. Milton.
Yeah. If it's wrong to defend your senior citizens when somebody 20 years younger than them lays hands on them, then please do find me very guilty of this.
Okay. All right. Thank you.
Yeah, the difference here is based on the facts as I read them in the police report. It's the bite on the nose that was the one step too far.
He told me he had a knife.
Okay.
Officer Tittle asked me if that knife was mine on the ground.
Okay, but biting somebody on the nose doesn't address the issue of the knife. It just causes damage to somebody. It doesn't keep them from using the knife. It doesn't do anything. And so,
wow.
Okay, hold on.
I got you.
The pushing away, I'm fine with that. The biting on the nose, that's one step too far. Based on that, I'll find guilty in the charge of assault on Mr. Clark. And Mr. Sharp, city's recommendation on each of these two cases, please.
Thank you, Your Honor. The city would like to point out and offer to Mr. Milton that there's no joy being taken in any of this. And I see in the assault report and the assault report and what Mr. Milton said today, it seems pretty clear that he likely intended well, but did act outside the bounds of the law. So I'll address that case first and then the trespass case. City's not seeking additional jail time on the assault. He, I believe, served 9 days in a combination of time from the initial arrest, as well as he did have a hold for a few days right after the trespass arrest. So city's calculating 9 there. City'd asked that the court impose 9 days, give him credit for the 9 he served, and suspend the remainder. In terms of probation, the city would ask that Mr. Milton abide by the criminal law as a term of probation, that he not possess any firearms or dangerous weapons, that he not have any contact with Mr. Clark. And I believe there is a written order, and I'll prepare an updated written order for the court here in just a minute. Additionally, the city is seeking chemical dependency evaluation and treatment with the appropriate probation level and fee determined by the court. That's provided as based on the broader context here. And if it's okay with the court, I'd like to really quick address the trespass case first. And I think the recommendation for chemical dependency treatment will make some more sense when that's all out there. So on the case that the jury just convicted Mr. Milton for, the trespass in the first degree, again, the city is not seeking further jail time there. He's already served some time. I'm calculating 7 days. So the city would ask the court impose the 7, give him credit for the 7 served, suspend the remaining 357 for 2 years on the probation conditions of no new law violations.
Wow.
No contact with the 7-Eleven. Separately, no contact with Jessica Heasley. And again, the chemical dependency evaluation, probation supervision level determined by the court, as well as the fee. As to that chemical dependency evaluation, the city believes that would be appropriate given the broader context here. That was pretty obviously a factor in the trespass case. But it seems to speak to the broader issue Mr. Milton seems to be having lately. And I'd like to kind of be candid with the court here that the court heard me at opening statement mentioning to the jury that this wasn't a case where the jury is asked to sit in judgment on Mr. Milton as a person, as good or bad, but rather we're discussing an action here today. And that wasn't just informative for the jury. That's the result of preparation in this case. And through the course of this case, talking with Ms. Heasley and with Officer Evers, both of them expressed to me that they've had many contacts with Mr. Milton, and most of them were fine. Most of them were maybe even pleasant. But there seems to be a pattern that when he's consuming alcohol, things don't go very well. I'd invite, if the court would have it, input from Officer Evers, because she's here and she has had these interactions. I'll share with the court that the driver here is a safe and peaceful community, and that includes for Mr. Milton. And if that's the cause of recent issues, pointing out that he doesn't have prior criminal record before very recently. So if that's what's changed and that's what's causing this, we're hoping that that could be addressed and he could get the help to not have further problems with the law and go back to having positive interactions as he used to before. So that's the driver. Again, I'd ask the court to inquire of Officer Evers if the court's inclined. And nothing further. Thank you.
Thank you. And Officer Evers, anything you want to tell me about that?
I think I agree with that. That has seemed to be one of the leading issues lately, just based on my experience and social interactions with other people, and then Mr. Milton himself. I would say that's pretty precise.
Okay, so I understand that was the observation on the 31st. Have you seen him previously intoxicated?
Yes, when during a warrant arrest for the DUI, he was also intoxicated, and
Actually,
it wasn't as good of a.
a beard yet. Oh wait, maybe I had.
Oh, okay, yeah, careful. You don't want to say anything because that charge is still pending.
My mistake.
Yeah,
Wait, oh no, I was picked
during
up
a
on
warrant, not
an
the
FTA
actual
warrant.
Oh, okay.
not the
Okay.
actual arrest,
Oh,
but
okay.
just on the
Okay,
warrant.
thank you for
And
for
the
clarifying.
interaction was as pleasant as it had been when.
Yeah, I'm
he was
tired of
not
telling you guys the truth and getting in trouble for it.
All right.
I'm not allowed to tell the truth to people that are supposed to be having my back for having.
And Mr. Sharp, you're presenting me with a new order
Yes,
regarding Mr. Clark.
It'll take a couple of minutes to prepare.
Thank you.
I don't know if this matters, but my move how you feel training says, you know, you're setting me up to go to jail for a year and a month from now, right? Like right off the bat, like no questions asked.
So, Mr. Milton, let me ask you a question on the criminal trespass, which was, I think you were taken into custody, as Officer Evers says, on the 31st, and it looks like you didn't post bail until the 18th of April. Is that right?
I only posted bail because I was denied being released on my own recognizance after.
Yeah,
saying
but
that
were
I
you in jail that
represented
whole
myself.
time?
Yes.
So 19 days in custody?
Oh, my mistake. No, there was not 19 days. There was only 6 and then 6, I believe, was actually.
I could help with this, Your Honor. So
Sure.
the two cases, one of the docket texts says that bail was received April 6th. The second one says it wasn't received until April 18th. My read on that was they came in, but it wasn't applied to both, possibly.
Yeah. Right.
But Mr. Milton, I think he agreed that he did get out after 6 or 7 days.
Okay. I think the city said 7, so I'll give you credit for 7. Thank you.
I think the judge is a little frustrated with the defendant right now.
Mr. Milton, anything else you wanted to say?
Here goes. Buckle up.
I'm just very sad that it seems the narrative of phone calls is more important than investigating an antagonist in a situation. Details that are very imperative to somebody defending a community standard and the elders of the community are being withheld from the reports by the actual officers that are supposed to be in charge of upholding this standard, not me, who's doing it and getting in trouble for it. Other than that, I'm just highly emotional right now, Your Honor, so I'll shut.
Know thyself, I guess, huh?
You know how it goes.
Okay.
Oh, I'm also grateful that I'm not going to jail today, so thanks. I think that's what I heard.
That's what you heard from him. It's up to me, though.
That's what I was saying. I don't really know yet, but.
And if Mr. Sharp were the judge, you'd be getting off easy.
Well, if he was the judge in his position as prosecutor, I may not be.
Yeah, that wouldn't work. That's how it is in some judicial systems where the judge is also the prosecutor. Doesn't sound very fair to me.
I'm glad to be in America for many reasons.
Okay. All right. So, Mr. Milton,
Sov Cit.
on the criminal trespass charge, I'll give you 7 days in jail. I'll give you credit for the 7 days that you've served. 357 days will remain suspended for the next 2 years. And during that 2-year period, You're to have no criminal law violations. You are not to consume any alcohol or marijuana, not enter any bar or tavern. Alcohol clearly played a role in this offense, as you acknowledged in your many statements to Officer Evers on the date. You're to have no contact with Ms. Jessica Heasley and no contact with the 7-Eleven store on Marvin Road. I know there was a request to have you get chemical dependency evaluation and treatment. I'm not going to do that. I think I agree with you on this one, that that's really going to set you up for a failure there. I'm just going to, you understand what these conditions are. We've had a conversation about it. You recognized on the 31st that alcohol was putting you in a position where you were maybe making some wrong decisions. And so you understand the importance of not drinking and not using. So I'm going to trust that you are going to abide by that. On the assault case, the conviction has entered on that. I'll give you credit for 9 days served. The 355 days will remain suspended on that for the next 2 years, on condition during that 2-year period that you have no criminal law violations, that you not possessing firearm or other dangerous weapon, and obey the no contact order with Mr. Clark. I won't impose any other conditions. So you have just basically
so he walks.
Compliance with law and no use conditions going forward.
And no fines.
Any questions for me?
Should be ready for you.
And Mr. Milton, any questions for me about that?
Negative. I appreciate you, Your Honor. And I appreciate you too, Mr. Sharp. I know you're just doing your job and you're doing it to the best of your ability, you know? You have emotions. But I would never hold anything like that against you.
Right, and we'll get you copies of these documents here shortly.
So after all that, as long as he doesn't commit any crime or get caught for them in the next 2 years, there's no penalty. And that will be tough. I admit that I believe that will be very difficult for somebody in his current situation to stay free of any conviction during that time. Anyone who's living in their vehicle, honestly, that it's a challenge. You park in the wrong place, you sleep in the wrong place at night, and they'll call you, say you're trespassing. So it is sort of setting them up to fail, but at the same time, it's going very soft on these two offenses, and it's sort of passing the buck.
Have a no contact order.
It's kicking the can down the road to say the next judge has to be the mean guy, but I'm going to be really nice and let you go.
So when I was advising you of that DUI court date, it looks like there's also an obstruction charge that I don't know if it was related or occurred the day before. I can't tell.
That does actually, if I may, that reminds me of an issue. When I go to the DUI now, is it no new charges that I'm supposed to not get?
Yeah, the DUI and the obstruction is not, they're not going to be violations of any of the sentence I've imposed today.
Cool.
So, because they occurred prior to my entering
not
this
a
work.
criminal, I should be all right.
Yeah, so, you know.
Fantastic.
But what I was going to point out is the obstruction charge and the DUI are both being heard with Ms. Rowe on the 1st of September. That's why it's going to be important to reach out to her.
Calendars. September.
Thank you very much.
Yep, and we'll give you all these papers here in just a moment.
We'll put Sarah Boone, BK, everybody on hold. The Microsoft executive, all those trials are going to be on hold because we're going to follow Mr. Milton's case in September for his obstruction. He picked up 4 charges in, 2 weeks? He's cool with it. Crusoe, I'm not sure if you call it a sentence or if it's a get-out-of-jail-free card they just handed him. He's done a total of, 9 days and 7 days combined for the 2 charges, the assault charge and this trespassing charge. And
I'm self-employed.
What do you do?
I'm a Qigong and Kung Fu teacher.
You have students?
I do.
Good.
Not here.
Okay. Yeah, it's important to be able to support yourself, and it sounds like you have means of doing that.
All right, Mr. Milton, if you'll come on up, I'll give you copies of your documents here.
Thank you again.
Good luck, sir.
Yes, he teaches Kung Fu.
And that will conclude our proceedings today.
Thank you, Officer Evers, for everything you do that I do know that I don't.
The police report went into the file. And I also have the recorded phone.
He's dancing out of the courtroom. Can you grab one more for those free bottles of water? And they've cut the feed. They're done. Namaste, right? Wow. Yeah, Ivan, don't call in. I realize you would not be able to restrain yourself in this moment. We'll have to talk at a later date. Is this a prank? Nope. That was Lacey Washington. Wow. He's a Kung Fu biter. Everybody was Kung Fu biting. We're on Candid Camera. Seriously. We watched a guy get 62 years and had the book thrown at him. This guy is going to end up down that road if he just keeps getting pushed down the can down the road. Totally thinks he nailed it.
Hello, it's Tony Mac. I'm coming to you from Chicago.
I love that. YouTube knows me, and instead of Judge Darrow, I'm now getting Law Talk with Mike as the next feed to watch as we just finished that live feed from Washington. Hello to all those who are friends from the Law Talk with Mike channel. Thanks for popping in as well. I think the judge found him humorous and gave him a slap on the hand. I think the judge found him threatening a little bit as well, and instead passed it to somebody else to take care of. Just kicked the can down the road. I don't think, first of all, somebody who has trouble with alcohol and possibly, it sounds like marijuana, I don't think that they're going to be able to just not do that because the judge told them not to. Those are difficult. That's a difficult change in your life to make all of a sudden, especially in a situation that is as fluid as his living situation, living out of his vehicle. I'm not buying it. We'll see him again, I think. All right. Anything else we need to cover today? It's been a fun day. We're ending a little bit early. I have a couple things to do. I have to make a I object soundbite from this court, the I object moment. We're going to see if we can find that from the early morning stream. I think that was his first objection that we want to grab the audio from. I also have to do a Homestead link. Tomorrow we have court with James and Cynthia. This is another Zoom court. These are a couple that were convicted of shoplifting in Walmart. They're the cutest couple you've ever seen arrested. Honestly, they're just wonderful. And it's also Judge Cedric, who is just a great judge. We love watching stuff from his courtroom. So we're going to pick that one up tomorrow. That's going to be live. We think it's been pushed a couple dates. We think this is actually going to be the resolution at this point. So that'll be good. What was the new Sarah Boone date all about? Let me do one more check on that. We have a date for Sarah Boone's trial. That's Orange County, Florida. Let me just pull it up one more second. Let's see, record search. It's amazing how much faster my computer runs when it's not overheating. Let's see, we need Sarah Boone 2020 CF 002603080. There it is. So we have a trial date of the 2nd, in 2 months, basically. 2 months she goes to trial. So October 2nd, she's going to go to trial. I'm looking for the ex parte motion. Let's see, notice of hearing, ex parte motion 726. I'm looking this one up. You're notified that the undersigned will appear before the Honorable Wayne Wooten of the above-styled court on September 8th. Okay, there's going to be one on September 8th at 9 a.m. at the Orange County Courthouse. Ex parte motion filed by defense counsel. Interesting. We'll have to look into that and see what it means. Document delivery. Okay, well, the big thing right now is we've got trial date for October 2nd for her. All right. Anything else we have to go over today before we wrap things up? BK, SB, and Melly are all 10-2, I believe. How are we going to do this? Amanda, first of all, BK is going to push. Of all the trials to be pushed out, I think BK is the first one that's going to slide. They're playing that game that we're like, oh, we want a speedy trial. We want a speedy trial. We're going to force you to do this. But really, I don't think they want a speedy trial because they're not ready. I don't think they're going to be ready for that. I think that's going to be pushed. So that's my call on that one. Sarah Boone, probably going to happen. Melly, if it happens, I don't think we're going to watch. Those that watch it, especially if we've got the same judge. First of all, the sidebars took forever. The court is painful to watch. I mean, I'd rather just go to the dentist and like drill them all out, slowly. No Novocaine, just hit me. It's a rough trial to watch, and it just drags on, and it seems like it never ends. So I think we're probably going to catch that on like replays and updates on the Melly trial. I don't think even Brandy wants to stream that one. So it's probably going to go on 10-2. It's probably going to be Sarah Boone is my prediction that's going to move forward. BK will probably go, if it does push, it might push way out. It might push like 2 years out. But I don't know. We'll see. I think that was it. That was a fun day. It's going to be another joke of a trial, Sarah Boone. It will, Denny. It's going to be about 3 days for that one, 3 or 4 days, depending on the expert witnesses. Today has been a great all-over day. Yeah, hope you like the live stream, not the live stream, but the police cam that we got. It's rare to get footage like that from a helicopter, especially I like the overlay so you can see all the technical stuff. I'm a bit of a nerd when it comes to cameras, so that stuff is a lot of fun for me. So I hope you like that as well. We still have some more requests out right there as far as FOIA requests. We've got one out of Texas, from a little town called Wichita Falls. We're waiting for some video camera footage, dash cam footage of a police chase of a U-Haul that ended on a golf course with a shooting. Thanks to one of our very own for tipping us off on that one. So we're waiting for that, and we'll see what we can find. I came in late to a nose biter. 80s Music Man. It was good. There wasn't a lot of editing needed on this one. Everyone was sort of behaving as far as language went. Appreciate you guys being great to Mrs. R.A. as she took over for me while we had the little raccoon incident today. Hopefully that's resolved and it's found a place to live that is someplace other than under my house or in my garbage can. What time are we starting tomorrow? Probably 9 o'clock, I think. 9 a.m. is going to be our start time. The only thing I have tomorrow, Sharon, just a heads up to the mods, is the only firm thing we have is James and Cynthia. So we'll probably do some court hopping around there. We do need to find another court case to watch. James and Cynthia, you don't want to miss this. This will be fun. But we need to find another trial to watch. So if you've got some suggestions, just realize that we've had some pretty heavy essay trials type things lately, or essay related or adult content trials. I'm trying to take a break for that. Obviously, we don't like going through trials where children are victims on that. So we're just looking for a plain old murder trial that's live streamed. That's what we're looking for. So we'll keep our ear to the ground on that one. We'll find one, whatever it is. Hopefully it will be as close to what we want as possible. Otherwise, we'll have to settle. But we'll have a trial for you, as we do pretty much every day. Otherwise, we'll find some police chases. Let's see. Is it over? I don't have it in my volume up and paused it a while so I can watch it later. It's over. It's over, Lil Miss. Yes, you can watch it now on the replay and get it. We'll do that. Okay. There's one from Albuquerque where there was a police chase that ended on Top Golf with guns drawn. Woo. We'll have to look for that one. Let's see. I wouldn't stream Melly. Brandy was getting death threats over it. It's not worth it. Yeah, I wasn't interested in the Melly trial personally. We might sum up how things work a little bit, like after the fact, but we wouldn't do a live stream of it. Yep, that's my P.O. box. If you need to send me something, that'll get to me. Let's see, anything else? Can't watch it again, and no, Brandy's not streaming it. Yeah, I heard her say she was not interested in doing a repeat. Dean, too soon, man. Too soon. Talking about a prank call where people think I own property in Utah, which I do not. And they want me to sell it to them, which I'm happy to do, but I don't own it. Okay. All right. I think that's it. I think we're going to end it on that note. Let me bring in the music. Which page is it on? There it is. Ooh, all right. I think I have to do one more sweep outside for a raccoon and make sure it's not here. But I do want to just say I appreciate everyone for being here today. It's been a lot of fun. This is a great community to hang out and watch true crime with, even if it's a crazy case out of Washington with a Sov Cit who doesn't know what Sov Cit means. It was a great day. Thank you for being kind to Mrs. RA as well. That was wonderful. I wanted to do a big shout out to the mods who keep the community nice and safe and happy and well informed. You guys are amazing. You guys and gals, very much appreciated. I could not do this without you. To all of you, thank you for making this channel what it is. It would not be the same without you, and I appreciate that. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. Tomorrow morning at 9 a.m., as we do pretty much every day. It's going to be good. It's going to be good. We'll have something fun. It'll be James and Cynthia for starters. That's going to be worth watching, and we'll go from there. It's going to be awesome. You don't want to miss it. We'll see you. Have a great day.